said you don't know how many, it's more than 10, correct?
I don't think so. But if you have the number, we can go through them.
All right, and you testified, I just want to be clear that you found out on the back end that all of this was held up by Chief Judge Emerson.
I
correct?
did, because Judge Emerson started communicating with me via email. And I responded to him. Well, he was talking at me, not with me. So I responded to him and he just disregarded everything that I said and talked at me again.
So your testimony is you found out that he was the one, using your words, obstructing this process
Yes,
based on his communication to you.
based on that. Yes, he said, I told IT not to give the data.
Okay. And I want to be clear specifically about this issue. When you sent this email on Tuesday, April 27th, to Betancourt and Subadan, you, according to what you said earlier, you had attempted in some way to speak to Chief Judge Emerson about this issue.
I'm sorry?
Had you attempted to speak to Judge Emerson about this
I don't-
data issue?
Absolutely not. He's not authority to, I don't reach out to Judge Emerson about probate information. It's not his space. It's not his authority. I spoke to who I needed to speak to, which was IT and the county administrator. Judge Emerson had nothing to do with that authority, so I wouldn't have to speak to him about it.
Would you acknowledge that the Superior Court has any supervisory authority over the inferior courts in your circuit?
Supervisory,
Specifically, probably. You acknowledge-
perhaps, I would say generally, I would think so, but my court, it's a real, like I said, generally it is, but I'm an Article 6 court. So if I'm appealed to the Court of Appeals. Prior to me, Hamrick was appealed to us, to Judge Emerson. So he doesn't have that same authority. And as a constitutional officer, I don't get approval for contracts and how I run my court through Judge Emerson or the county the Board of Commissioners. It's the probate judge who makes those decisions.
You advise Mr. Betancourt and Ms. Subadan that what they are doing is obstruction. correct?
Likely. I don't know if I don't see the emails, but likely I might have said something to that effect.
Okay, and you conclude with issuing them a directive to provide CJT what they need for your conversion.
Absolutely.
And you testified in response to Mr. Lopez's question about how this was resolved, that ultimately you got the data that you needed for your software, correct?
Absolutely.
However, that data was not provided in the manner in which you directed the IS department to provide it, correct?
That's not correct. I never made a specific request on what data or files. I don't know. I'm not technology. So I just said, please provide the data that's necessary to transfer probate files. I don't know if it's BAK file. I don't know what that is. So I never made those directives. I said, please provide them what they need. And that was ultimately done.
All right. And just for the hearing panel, there is a portion of this email that I've got to explore with Judge Emerson. So 9 will be tendered through Judge Emerson.
Okay.
All right. I am going to now transition into complaint 2021-339.
2021, so 339.
I did.
Gunnar, if we could have just a few.
I had asked Judge Peterson to bring some stuff that Ms. Beal wanted, and I just didn't ask her. I neglected to ask her. about
Okay.
that This morning.
So you need to talk with your client? Not a problem.
And to be clear.
Do you need us to go away? What, tell me how you want this to work.
1 second, and then I'll know. if I
Okay,
actually-
okay. I,
Yeah, they're in there. Yeah.
Testing. I think we've resolved it and we need you to stay.
stay. Okay, stay we shall.
And it's about birth certificates, and I don't really have I'm not insisting on it being certified. I'm not sure we had the originals,
Okay.
but I don't think it's.
As long as folks are collaborating over it, we're happy. We can even substitute an exhibit later on if that's what we need to do.
You want me to stipulate those in?
We are, and we have by agreement, we stipulate to exhibits 31 through 35.
Okay.
And now 61 through 63.
What are those?
61 is a translated copy of a birth certificate that the petitioner attempted to present to Judge Peterson.
Okay.
62 is a copy of her birth certificate from Thailand. And 63 is a copy of a certified translated version of the birth certificate from Thailand.
Could I ask what 31 to 35 is?
Did you all get the exhibit list?
Yeah.
Yeah, so that's on their exhibit list, the 31 through 35. The 61 through 63 are just add-ons. They weren't new.
And just for the record, we do stipulate
Stipulate.
to the admissibility of those.
Of all those.
And,
Okay.
and again, I think the birth certificates are not certified, but we agree to their copy.
Great, thank you.
All right, Judge Peterson, in reference to complaint number 2021-339 and the contempt issue, on August 24th of 2021, you jailed the petitioner in that matter for the fraudulent misrepresentation she made to the court via her filings with the court on May 3rd of 2016, correct?
Your Honor, I do object to the term used jailed. She found her in contempt. And the jail was the resulting sentence. Asking her if she jailed her implies that she took some extrajudicial action, I believe.
Okay, well, she's on cross and she can frame the question and I'm confident your client's about to clear that up, but if not, I bet you will.
That was one of the reasons. The main reason is because she submitted a fictitious document to the court. But she was held in contempt for that.
Okay, so your testimony here today, on September 9th of 2023, is that the main reason you jailed her was because she submitted a fictitious document to the court?
I didn't say the main reason. I said that was one of the reasons.
Okay,
So the fictitious document that she submitted to in the court while we were in court was an issue, as well as her testimony in court on that day.
Judge, would that have been a crime?
Yes, the fictitious document, it would have been forgery.
Did you report it to anybody in law enforcement, sheriff, GBI?
No, because it was done in court while I was on the bench. I held her in contempt.
It's a crime, isn't that a felony?
Well, it would be, but I wanted to see I want to see what the real document is. I gave her an opportunity to show what that is. But yes, it's a crime. The document that was submitted, it's not a legal document. She was submitting it to the court as if it was her original birth certificate.
What was fictitious about it?
It stated not a legal document, not to be used for any legal purposes. And so obviously it wasn't a real item.
Well, when you say fictitious, that sounds like she fabricated or forged or altered a document.
Well, Judge, I wouldn't know I'm sorry. What do I call you, Mr. Lopez?
That's what
I wouldn't know what it was. I just know that the document, what it stated, and I know what she testified to in court.
Well, hold on. If you don't know what it is, then
You
This
just
is-
told us that
this
she
is-
submitted a fictitious
That's
document,
it.
and now you're saying, without interrupting us, you're saying, oh, I actually have no idea what it was, but it was so fictitious, I locked her up. So
Well, it was
reconcile.
fictitious. If you look at the bottom of this document, right there, it's very faint, not recommended as a legal document. This accompanied with, and I got testimony from her in court about all the proceedings and all that she's done. And she admitted that she's been lying. She's not giving the court the correct information. She's only doing this to get her mother back in the country from Thailand. So this all came out on her sworn testimony.
So what you told us was one of the reasons you held this person in contempt was that she submitted a fictitious document. And what you're now saying, I don't know what's on the screen, I'm sure it'll be explained in a minute, that it's not to be used for, I don't know what language you're pointing to, that's real faint. I guess it says not recommended as a legal document, but what makes that fictitious? In fact, it says on there.
certified translation.
What is it?
The first part says certified translation.
That's
But
not,
not recommended as a legal document. So what's the fictitious part of the document that caused you to decide this woman needed to be held in contempt?
well, when I'm on the stand, all I can look is what's in the presence of me at the time I'm on the stand. When I reviewed the information, it was not a legal document. When people come to change, I'm over vital records. So when people submit records to me for changing, or when they have to bring certified true copies that are legal documents.
Just Peterson, I think I'm having a hard time with the semantics of this. Fictitious to me means this is not true. This is somehow she has taken a document and changed information that is not true,
Okay, I get it.
and it is false. And it is a fraudulent document. This is my understanding of what you're testifying to is perhaps you didn't think this was a fully certified document that you could base a decision on as to whether this is all accurate or not. That's different than saying she went and created a false, fabricated a false birth certificate
Mhm.
and then tried to pass it off as a real birth certificate or a copy or a translation of one. And that's where I'm having a hard time, because this says this is a certified translation. And I've dealt with this because I had to get my birth certificate from Puerto Rico and it's in Spanish and I had to get it certified and translated and all that good stuff. So I can use it here in the US. But to tell me, look, I need something more official is one thing. To say this is a fictitious document is where I'm having a hard time.
Well, maybe it's the wording. So when I say it was not legal, it's not as a legal document. If when it says, so remove fictitious, it's not certified or not recommended as a legal document. We generally don't even take copies. We would take the original. We need the original to verify that the information you're giving me is true.
Right. I agree with all. Could you have just told her that and not say, I'm here finding you in contempt for defrauding the court because you just turned in a document that's not certified? And it is certified translation, but I understand the point you're trying to make.
But what I'm saying is it wasn't just that. It was everything. It was
Right.
all the testimony that came out at the court, and she admitted to defrauding the court and lying under oath. And now she's presenting this document. It was the totality of what was happening in the court.
Is there a
And let's
transcript?
walk through that, because I think Ms. Veal wants to do that.
Yeah, I'm sorry.
No, I shared the same concern, because the first words out of Judge Peterson's mouth were fictitious document,
Yeah.
and I'm not seeing a fictitious document, but it could be when coupled with the testimony of this person. The judge was under the apprehension that this document was something that it wasn't, and then we get to where we got. So
Okay.
And
take it
just-
away, Ms. Veal.
Sure. There is no transcript of this proceeding. correct?
No.
Because litigants who come into your court have to bring their own court reporters, pay for them if
Yes.
they want it taken down, correct?
Yes.
So there's no record of the proceeding.
No.
Okay, so what we have then is your word and the petitioner's word regarding
And-
what happened.
And the clerks that were present.
Okay, we'll be glad to hear from them. Which clerks were present?
My chief clerk would have been there, Bonnie Fasik and Sandra Hall.
Judge, would you consider that proceeding a contested matter?
No, contested? No.
Because contested matters would have to have a verbatim takedown, right?
Well, in my court, we don't ever supply, the only thing we're required to record under probate laws is guardianship proceedings. So we don't take down anything. It's the petitioners or the party's duty to take down.
So if there's gonna be a big fight over a will, it can be taken down, but the parties would need to supply.
Right.
a court reporter, and you put them on notice, hey, if you want a record made, you should show up with us tonight.
That's right.
All right, so I'm showing you Judge Peterson, exhibit, JQC exhibit 33.
Mhm.
And this is the petition that was filed. Where, and I'm going to refer to her as PJ because those are her initials and I don't want to mess up her name. Or the petitioner, but PJ came into your court voluntarily on August of 2021, filed this petition with your court and says father's name should be, and then she's got presumably her biological father's name, correct?
I'm reading what I didn't take this petition in, but yes, that was filed with my court.
Okay. But you saw this petition at or around the time it came in, right?
No, I saw it at around the time that I would schedule a hearing. So whenever that was, I don't get it right when it comes in necessarily.
What's the typical gap? If I bring a petition in, is my hearing in a week or a month or?
It depends. It depends. I have a full array of cases that I handle. So it's however they get to my desk, however they get to my office. I don't know. It just varies. Some petitions require service, so they might be delayed. This one probably would have been placed in a bin. I don't know if we had bins around that time. We've got more organized, but I'm not sure how long it would have taken to schedule.
Okay, so your testimony is you didn't see this petition until you said at or around the time of the hearing, correct?
At or around the time, when I received the petition, I would have scheduled a hearing because they're asking for an amendment to a record.
All right, well, I'm going to show you exhibit number 35. This is actually your contempt order that says, I'm at the third sentence. This court was alerted to the fraudulent misrepresentations on August 2nd of 2021 when PJ filed a petition to amend marriage record.
Okay, that was when I was alerted, but that doesn't mean I saw the file. So anytime somebody comes in my office and there is some issues at the counter, I always get alerted to the issues. So that was one.
What does that mean? word, is there a little button you hit?
No, you don't hit buttons in there. Stay away from the buttons. No, anytime there's issues like there's been, I mean, for example, people might come in and they might have active warrants. I might be alerted or things
What you
like,
mean is somebody that works for you says, hey,
yeah,
this dude's got active.
right.
Gotcha.
So that was what they would let me know.
You were alerted to the fraudulent misrepresentations on August 2nd of 2021, correct? So on August 2nd of 2021, you were of the conclusion that there were fraudulent misrepresentations involved, right?
Was alerted. I'm saying that's what the court was stating. Yes, at that time.
You're the court, so.
Yes,
were you-
I'm sorry, my clerks. Yes. So that's what my clerks were representing to me. And then after we had the hearing, it was confirmed.
What was the fraudulent misrepresentation? This is your contempt order, by the way.
This is a
What was the
portion.
fraudulent misrepresentation that you were alerted to on August 2nd of 2021?
There was a lot of misrepresentations made. So, Miss PJ came to the counter. What was told to me was that she wanted to amend their marriage record. What was told to me was she was only changing the marriage record because she was trying to get her mother into the country from Thailand. She represented that she always knew who her father was. She just put on the paper that it was her uncle. I mean, not her uncle. She also put on the paper someone else because she wasn't in talks with her father. So that's what was told to me. So naturally, either way, when she's asking for a change, we have to have a hearing so she can present legal document, true documents to authorize the change. Obviously, it needed to be changed because she put information up to the court that she gave the wrong information. So it had to be changed.
Would it be better had all that been in your order, all the misrepresentations you say she made? Instead of just misrepresentations, because the reader doesn't know, right?
Perhaps, yeah. This was August of 2021, so I was just getting in there. So I'm more
I
detailed.
understand that you applied for the job.
Yeah, I did. And I get better as I go. So yeah.
Judge Peterson, okay, let me unpack this a little bit. So you're saying that at some point she admitted that she is the reason she's trying to amend her marriage certificate is because she's trying to bring her mother into the country, correct?
Well, she said that in court, but that was the representations in that some of the clerks say she made, but she did that as well in court.
Okay, she's only trying to amend her father's name. She's not making any change to her mother's name on this record. So that's my
Correct.
confusion.
Yeah, it was my confusion too. It's still confused. I don't know. Maybe I don't know how that works in getting people in the court, but that's what she testified to.
She
So-
also
Go ahead, I'm sorry, go ahead, Ms. Veal.
She also told you that the reason that she put her biological uncle's name on there was because he had raised her from the time she was a baby, correct?
No, she didn't. She said the reason why she wasn't speaking to her father. She never stated why she put anybody on there. She just said she wasn't speaking to him and she didn't want to put him on there. And honestly, you have to put anybody. I mean, we've seen some licenses that don't have, or applications that don't have a name. It would have been better to put that rather than to just blatantly lie and swear under oath.
All right, well, let's talk about blatantly lying. On August 2nd of 21, you've already concluded that she's made fraudulent misrepresentations to the court, correct?
No,
Okay, you on August 12th of 2021, and this is exhibit number 34. You then send, or your office sends, a notice of trial or hearing on a petition to amend marriage record, which provides that a hearing has been set in the matter for 10 a.m. on 8/24/21. So 12 days after she filed the petition, quick hearing. And you provide that you must appear in person. Video conference is not available for the hearing. And you also say court reporting is not arranged and is your responsibility.
right.
And
There are
this is the
certain here-
entirety of the notice that was sent to her, correct?
Right, and there are certain hearings that are not, video conferences not offered, especially if the court needs information or documentation, as in this one, it wouldn't have been video conference offered.
You ordered her to come to court, having already made up your mind that she had willfully provided false information on her marriage application, correct?
No, this order was done after. I'm sorry, what are you asking? Yes, this order was August 24th. You asked me about when I asked her to come to court. So just because my clerk states something at the counter and alert me to something doesn't mean the judge or the court has made a ruling on what happened. Regardless of what she would attest, what she testified to, that's not here nor there. The point is, she wants to amend her marriage record. She needs to bring sufficient documentation to do so. But the information that she presented to the court on that day, as well as the material she presented, it wasn't true. It was not sufficient for the court to make a good ruling on. And I had an issue with that as the judge on this.
I'm sorry, those sounds like two different things. Not sufficient and not true. Which is it, not true or is it not?
It's
sufficient?
not true. It wasn't sufficient. I wouldn't have been able to issue or amend any type of vital record with what she submitted to me. And combined with the testimony that she's given us, she lied under oath that she's only doing this to get her mother in the country, combined with all of this information, that was an issue for the court at that time.
But if all of that's true, if you think, would it have been better in your view to have somebody, a separate entity, person, look into that and make investigative findings and then come back to you or maybe report it to the district attorney or something, instead of you handling it yourself?
I mean, in probate, we don't have that. We don't have those resources to do that. So,
You have a district attorney in Douglas County.
yes,
We have the title of Attorney General, of Georgia, right? You have
yes,
GPI.
yes.
So you could have picked up the phone and reported that to anybody, any police agency, right?
Yes, there's a lot of things I could have done, but, and it could have been done any different ways. If I could have done it, I wouldn't have done it this way. But this is the way that in that moment, that's what I felt was the thing to do. Now, when I have cases that come in like this, I make referrals to the district attorney's office to do investigations. I've sent things and I copied the sheriff's office as well, to investigate. So I've done that, not that they respond, so I don't know if they're picking it up, but that's what I have done now.
You didn't want to, or did you want to send her to jail when she came in for the hearing?
No, I did not.
Okay. But you knew that when you ordered her to come in for this hearing, you were going to ask about, to use your words, the fraudulent misrepresentations. Correct?
I'm sorry. I knew I was going to ask about them.
You knew you were going to ask this woman about what you had determined were false, fraudulent misrepresentations. You knew you were going to ask her about that during the hearing.
I didn't know they were fraudulent misrepresentations until she confirmed them at the hearing.
Okay. So you were going to ask her about that because you were alerted to it on August 2nd of 21.
I was going to ask her about the amendment and why it was necessary to make the amendments. I have to know why. Why are we amending your father's name? Did your father change? Did you get adopted? That's a court inquiry. That's a proper inquiry that I would make when someone's trying to change this type of record.
And your notice contained no mention of contempt allegations or no mention of fraudulent misrepresentations, correct?
It wouldn't be, she wasn't held in contempt until she was at court.
Is this the first person you held in contempt? since-
It's not, no. Mm-mm.
How many people have you jailed?
Well, 2 people were held in contempt that were incarcerated. And one was held in contempt that was not. And the first one is when I kind of inquired about the contempt proceedings because we were never trained in it. But that's when I contacted the listserv and other probate judges. But the first one that I held in contempt, the DA did pick up and held him and filed charges against him.
Did you give any of these individuals an opportunity to consult with counsel before holding them in contempt?
Yes, now it's being, when they get noticed, they're actually served. If I know about contempt in advance. So if they violate a court order, they'll be served, by a process server. And they'll get notice that you can get an attorney and this is it says contempt hearing when it's a contempt hearing. But the first ones were not contempt hearings.
You just held them in contempt.
Yes, because of what they did present in that court on that day.
PJ was not given an opportunity to consult with an attorney.
Right, because I didn't know it was a contempt. I didn't know she was be held in contempt until we were in court.
So there are 3 folks you've held in contempt since you've been a judge.
Yes,
Counting this person.
and counting this one.
Your testimony today is that you held her in contempt based on what happened in court, correct?
Yes,
But your finding in your order of contempt says the court finds that PJ is in blatant disregard of the laws of the state of Georgia and of this court, evidenced by her fraudulent misrepresentations to the court via her filings with the court. And the original filing for a marriage application was in May of 2016.
no, I was talking about her filings in the court that she presented. What are you talking about, 2016?
What filings then are you
This-
referencing in your order?
What we were talking about now that you just placed on the screen.
So
The,
her petition to amend the marriage record?
so you've presented what you've identified as her birth certificate that is not, but you have her real birth certificate in your evidence. So that would be the true filing. But she did not submit that to the court. She submitted what you
But
posted.
Okay,
Don't interrupt the witness.
this is your order from the day that you jailed her.
Yes,
You say that she is in contempt because she's in disregard of the laws of the state, evidenced by her fraudulent misrepresentations to the court via her filings with the court.
right.
What is the filing that you were referencing in this order?
You've already put them on the screen.
So that translated birth certificate, if we could use the exhibit, so 61, can you put 61 on the screen?
Could my client look at the documents that we've stipulated in and
That would be great.
I know the technology is good for display, but if she could see them, she might be able to, she has all of them in front of her there.
Sure.
Can you use 61, 62, and 63?
Okay, 61 is what was filed. 62 and 63 came after the contempt. Those are the true copies. Those are the true documents.
Okay, so you were testifying today that what you meant in your order of contempt, the fraudulent misrepresentations to the court via her filings with the court, you have identified exhibit 61 to be the filing that you're referencing.
Yes, on top of all the other filings she did, but that was the filing that was submitted in court that day.
This was
To my
filed
clerk.
to you.
It was submitted to my chief clerk and to the court, yes.
And what is the fraudulent misrepresentation contained in this filing?
It is not a true document. It is not a birth certificate. It is not a vital record. It says not recommended as a legal document. So the court, you don't submit a non-legal document or something that's not recommended as a legal document to the court.
So if I'm a lay person, Judge Peterson, as I assume PJ was, not a practicing family law attorney or anything like that, and I hand you what I think, because I'm working with the translation from a document from Thailand, and I hand it to you, and it has on there language that says, hey, this is a certified copy of a translation, not recommended as a legal document, but this is what I hand you. What's the fraudulent part about that? Unless I say, please don't look over in the corner, ignore that language, or I mean, did she do something like that? Or she handed you the best thing she had? I guess the fraud part's not jumping out at me. And I think that's what Mr. Lopez was getting at the outset of the conversation, but we've moved far enough along. There didn't seem to be anything underhanded about the document because of that language in the lower left-hand corner. Why was the response simply, ma'am, this document doesn't suffice? You're the judge. If you say
Right.
it doesn't suffice, then she's stuck and she needs to get something else.
Right.
It's not like she can say, aha, I say it is enough, judge, and you must accept it. And then,
Right.
all right, I'm gonna accept it. And then only later you learn that it's insufficient, which was the word
Correct.
used. And
Yes.
I've got to tell you, you have shifted your words a whole lot on this one. But your order says fraudulent misrepresentation, and you have now said Director 61 was that document. That was the filing.
Yes.
That was the fraudulent misrepresentation. I'm trying to figure out what on here is fraudulent. On its face, it alerts you, hey, maybe you don't want to rely on this. Your
Mhm.
call, your discretion, whether to rely on it or not. You can not rely on it. Sorry, PJ, you're out of luck. I can't go forward with this amendment. Or this is complicated. You're from Thailand and you've done the best you can. I'll exercise my discretion, enter an order allowing you to amend your marriage certificate. Option 1, no, thank you. Option 2, yes, we'll do it. Where does option 3, I'm locking you up, come from?
Well, option 3, see, so we can talk about what could have happened. If we talk
You know
about,
what? I don't, because we know what happened. You
Yeah.
locked her up, and you've told us it's because you wrote it. She fraudulently misrepresented through a filing,
yeah,
and you've now said this was the filing. And I'm looking at it. What on this filing prompted you to conclude that she was defrauding the court and blatantly disregarding?
well, it's the representations that she made on this filing. Well, not only this filing, when I said totality, it's all of the filings. So then we have other filings where she had to swear under oath and certify to the clerk that what she submitted to the court is true, honest, legal representations. She's admitted under oath that this is not. Plus, you're submitting this document that's not a legal document. So in totality, when I looked at it at that time, I felt like we had a contempt issue.
She admitted under oath that this was not a true document.
Yes, she
told you
said,
that this is not true. The
yes,
information on
well,
here is not
no,
true.
she said this was, I'm sorry.
That's why we let him finish his question.
She admitted under oath that this was not her birth certificate. And she said, I said, so this is not, where is your birth certificate and why would you submit this to the court? There was no, she's stating, I want to get my mother in the country and I need this name. So I'm confused on, is this a real representation of who is this the person you're saying is your father? Is this your father? Is this a real document? Because she's testifying to things that are not necessarily true, or she's admitted to lying.
I think you're sort of going all over the place here. I'm going to look at your order. The first part of your order says that she willfully provided false information on the marriage application.
Yes.
This order does not reference birth certificates, fictitious documents, or anything else. The only reference to anything that might be fraudulent or misrepresentation is this willfully provided false information on the marriage application. And then the court was alerted to the fraudulent misrepresentation on August 2nd of 2021, when PJ filed a petition to amend. And this court frowns on anyone who dishonors the judiciary by lying under oath and providing false information to the court. Is that what the basis of the contempt was, or was it this document? You told us it's both and it's fictitious and it's everything. I'm having a hard time understanding what the basis of the contempt.
This is half of the order. There's another portion of the contempt order.
There's another order.
There's another portion. There's an order and notice.
So there's a second page to exhibit number 35
What's
that Judge Peterson calls an order and notice.
Petition to compromise doubtful claim of minor.
That is, I know, that's my clerks. Listen, they drafted this and this is what we were having to deal with. So they must then change that part. You were supposed to remove that.
So you didn't write this, you just signed it?
I didn't write it, no. So the information, the case number and the marriage situation, that's the correct information.
Is your clerk a lawyer?
Nobody's a lawyer in my office but me. And that's what, around this time, I was requesting the Board of Commissioners to get me a budget for legal, additional support. And that was being obstructed by Judge Emerson. So I'm just saying it was hard. I was doing all of this by myself. I'm the only legal.
Could you have hired a lawyer, let me finish, part-time with some of your vital record money? Hey, tomorrow, if you wanted to.
Could I hire I guess I could, but you would, yeah, I've never considered that. I've never thought about that. So we can say what we could have, would have.
I'm the dumbest guy in the room.
But I mean, I was asking for a budget to get legal support, legal help. And I still haven't found a lawyer who would want to work part-time. So.
Well, Judge, I don't think this order of notice answers any of my questions because it doesn't reference what the fraudulent misrepresentation was, what the basis of the contempt is. It also says that this case will be dismissed for lack of prosecution, which makes little sense to me.
Yeah.
Since you're the person prosecuting this person. Pending, a certified birth certificate, official document, which I understand why you'd want that in order to make your decision. I just don't understand how we went from, hey, this is not sufficient to, hey, you're lying to the court, defrauding me, and I'm going to put you in jail for the maximum amount of time, which is 20 days with a fine of $500.
That's not what, she was not in the maximum. That's not what the order stated. That's not what happened either.
You said she could purge herself if she paid, right?
Yes, and she was there. She purged herself immediately.
But if she couldn't, then she
She
was
was-
serving the maximum amount of time,
Yes,
which is exactly what Mr. Lopez just
Is
said.
that
Yeah.
20 days?
yes,
It
it
is.
is. So at the time, the information presented to me, and when I speak about this order combined with the second, yes, it was the documentation. But when you have somebody coming into court swearing under oath that I knew I lied, I lied. And the only reason I'm changing this and updating the court is because I'm trying to get my mother into the country. Here is a copied version of something, a non-legal document. So I want you to take this as true on who my father is, even though I swore on the oath that my father was over here. That was an issue to the court. That was the decision that was made on the time. It appeared like it was a fictitious document, or what I thought as a fraudulent document, as well as the representations and the lies under oath. So I did hold her in contempt. Yes, if we could do it now, I would probably refer it out to the DA's office or give her an opportunity to submit me a real legal document.
Judge Peterson, the reason and this is an area that I'm particularly sensitive to, I'll go ahead and tell you now.
Mhm.
It just seems to me, and putting aside whether you did the contempt right or wrong, it just seems to me like such a harsh sanction for someone who's coming into a probate court, who wasn't given an opportunity to get counsel, who had no idea that this would become a contempt hearing, had no notice that maybe I should get this taken down because this is not just a simple petition to amend marriage record anymore. It's become something more. It just seems like such a harsh sanction to go from, 0 to 60 and go from, you could have just denied the petition and said it's not sufficient, but you went all the way to the maximum penalty that our law allows for a contempt on someone who's in a probate court. This isn't a criminal matter. It's not. I mean, I guess I'm struggling with this because in 11 years on the bench in state court where people routinely would say things that I thought were misrepresentations, and I held people in contempt. I put someone in contempt for a day,
Mhm.
for something that I thought was pretty egregious. But this, I don't know, I'm struggling with, do you not feel like this might be a harsh sentence for someone who's just going to your probate court to get something amended?
Well, I feel like it's harsh. And when I can, like I said, if I had an opportunity to do it again, I would have given her an opportunity to present a true legal document. I'm presented with what I was on the bench. And so now, like I said, at that time, I didn't have resources where I could ask questions, or I didn't know what was what. So I'm trying to figure this out. I knew she was misrepresenting things and lying, and you submit a document. I'm from prosecution. So I know that document in prosecution would be considered a forged document.
What it was for, what document here was forged?
Well, see, you don't know it's forged, or you don't know if it's untrue until you learn that it's untrue. So that's what I'm saying. So what you all are asking me or stating that I should have done was given her the opportunity to present a real document. That's what this hearing was for.
I just asked which document is forged. That's all I asked, not why did you do what you did?
Well,
or
that
would you
was-
do it different. Which you've now several times referred to a document as forged. Which document are you telling us was forged?
Well, the word was fictitious,
No, your word was forged.
Right.
I just heard you say it.
but what
Which
I'm saying
document
is
is
this
forged?
document that we're speaking of, I'm not saying it's forged. I've learned that there is a true document. I got that true document, and I got the true birth certificate. So I had to see what it was. This is not, I don't know where you all want me to go. I'm taking the information that was presented to me in court, the sworn testimony, the document that was presented that wasn't a true legal document, as the support to change this record. And that's what happened from that.
When you obtained the true and accurate birth certificate, did you compare it to the document that had been previously filed to see if there had been any alterations, deletions, or any fraudulent, anything that was changed that would make you think it was fraudulent?
I didn't acknowledge this document
Is
because,
that a no?
yes, I did not. I used the certified translation.
But you know, from being a prosecutor and a lawyer, that there's a crime of forgery,
Yes.
and then there's a crime of altering public documents.
Right.
Two separate distinct things,
Mhm.
right? Forgery is not necessarily fraudulent or vice versa. Which
Right.
one did you say this one was?
Well, I was saying I didn't say it just wasn't a true document. It was not, she submitted a non-legal document.
Where is the forgery? Is what-
No, I'm not alleging this was forgery. I'm saying at the time, I didn't know what it was. I just knew it was a non-legal document.
Right. So that's my question. You didn't know what it was. So how do we go from not knowing what it was to 20 days in jail?
It was because it was topped with the information that was presented to the court in the court at that time. And this document that was presented, that's where I felt there was a direct contempt. And I felt like she was manipulating the court with the data, the testimony, and the document. And that's why the decision was made at that time. In hindsight, it should have been allowed for her to present her true document or a true data.
And I'm promise Ms. Veal, we're gonna give it back to you in just a second. But at some point during this hearing, it became apparent to you that you are now considering contempt. Did you stop at that moment and say, all right, I need to figure out how to do a proper contempt hearing. I'm considering potential jail time for this individual. Do I need to let her get a lawyer? Did any of those thoughts cross your mind, or did you stop, pause, and go talk to someone, go look it up, or do anything that might, give you some guidance on what you should do next?
At that time, I believe she was in direct contempt for presenting the information that she presented to the court, and that's why it was done. So no, I didn't make calls or do anything. So yes.
Back to you, Ms. Veal.
Do you remember where you were?
I'm trying to mark off my questions as they're asked by the hearing panel. So Judge Peterson, you just said that I want to be clear that you didn't do anything, you didn't do any research or pause before you jailed this woman.
I did research.
I'm sorry, 1 second. Sir, you're gonna need to silence that device, okay? Well. Oh, okay. All right. No. I didn't realize it was connected to that. You keep doing what you're doing. I apologize.
I'm sorry.
What to Mr. Lopez's point, did you ever pause and say, you know what, I'm about to jail this person, considering doing it for the maximum time permitted under the law? I need to do some research before I'm comfortable doing this.
I did, like I said, I had a contempt matter previously and I had done some research. So I knew what the allowances were, but I didn't, like I said, before the court hearing, I wouldn't have known this was a contempt matter.
Sorry, Ms. Veal, I got to interrupt again. I feel like you've just changed your answer. So now you're saying that you had previously done some research and you knew what you were supposed to do in a contempt?
I previously did research on contempt overall when I had the first contempt matter. When someone has done something in violation of a court order, then you have to have a hearing and things like that. But that's contempt where they're violation of an order. So I knew about that, and as well as direct contempt if they're in the presence of the court. So that's information that I had researched and had learned about. If I had any clarifying questions, I had reached out. I didn't get full clarity because I reached out to the listserv. No one knew in the probate listserv. I'm sorry. It's a email list of all the probate judges.
Sidebar where all the
Yes.
Superior Court
Yeah.
judges chat amongst themselves.
Yes,
They don't think any of us know they do that.
right.
Got it.
So yes, I reached out to the listserv. I'll use the resources that were made available to me previously.
So at what point did you reach out to the listserv?
It was around the other action, the prior contempt matter. This was another case unrelated to this.
And nobody knew the answer to your inquiry related to your other contempt case on the listserv.
No, most people, the things that I heard from probate judges, they say there's more contempt power because the statute, it states a little more than the contempt in the Superior Court Code. So they say we have expanded power, but that's all they know. They don't know how to utilize it, what to do, nothing. They just say we just stay away from it. The ones that I've talked to after the fact.
No probate judge on the listserv knew how to.
They didn't respond. The ones that responded said, we don't, I don't really know how to help you.
Well, you did some research on LexisNexis, correct?
Westlaw or Lexis, yes.
Okay. Did you look into the difference between direct and indirect contempt?
Yes.
Okay. And did you read about due process related to contempt proceedings?
Yes, in relation to the due process that's required for the indirect.
And how do you understand due process for somebody in that position? What do they allow?
Well, now, I've done further research, but in regards to a contempt, say if I have an order, if I issue an order and someone is not in compliance with the orders, say a conservator is not turning over money or something like that, I will issue a contempt notice, a hearing notice for contempt. I will also actually have them personally served.
How many of those have you done?
We do them often now because there's a lot of cases that are conservatorships.
I thought I asked you how many contempt and you said.
No, I've had hearings. I haven't held anyone in contempt. Yes, they have the hearing because they are evading court and taking people's, may be exposing people and their money. So we do conservatorship. So they're over people's money.
But with regard to this woman,
Uh-huh.
due process, does it just mean notice and hearing?
Well, in this,
What other due process was she due?
well, in this one, I viewed it as a direct contempt. So I didn't know that I would have to give her order of a notice and a hearing. So
I don't know. I'm asking.
yeah, so in my understanding of the law, when it's a direct contempt, it's in the presence of the court, and that's
So
what.
I'm gonna pause you because this is not meant to be a legal quiz. And
Yeah.
I know Mr. Hyde is free to ask those questions, but I want to reassure you and really echo something Mr. Tate said early on, that none of this is about how savvy you are about the finer points of this or that, but we are just trying to understand the steps you took or didn't take, and
Mhm.
what steps you thought ought to be taken now that you've had a chance to look back at it.
Mhm.
But please don't come away from this wondering, well, gosh, I didn't know I was gonna have to be the horn book on contempt law.
Mhm.
None of us, other than maybe former Judge Lopez, is on that. So
Okay.
don't worry about
Yeah, I didn't know
defining
that.
direct
Quiz.
versus.
Well, no, I mean, now, like I said, because we've had we do guardianships and we do a lot of estate work. We do see a lot of people mishandling estate. So I've had to have a lot of contempt hearings, and I do issue contempt hearing notices, and I have them personally served so they can't say they didn't get notice. And we let them know I draft the orders, because you saw how this one was drafted poorly. But I draft the order stating, or the notices stating, hey, this is a contempt hearing. If you're held in contempt, you might be subject to incarceration or a fine. You have a right to have an attorney. You probably want to consult with one. This is not taken down. You need to get it taken down if you see fit. But you should be here in person on this day. You shall be here in person on this day and this time. So that's what I do now after further research and clarification of all the contempt matters.
Judge, you said that in hindsight, what you would have done differently is allowed PJ the opportunity to present the additional document that you wanted to see, correct?
Yes, I would have asked for, I just would have told her to bring a legal document to court.
Okay, without jailing her.
Right, right.
Okay. And in fact, you've had multiple opportunities to explain this situation and to offer what you might have done differently, correct?
No, how?
So this contempt situation was part of the basis for the first motion to suspend you, which was filed by the JQC, correct?
I'm sure it's been a lot, so.
Do you remember submitting an affidavit in conjunction with your attorney's response to the investigative panel's motion for interim suspension?
I don't remember, but I'm sure it was probably done since there was a motion.
Would it help you refresh your recollection?
Yes,
Documents that were submitted with that motion for interim suspension?
yes.
Does this have a number, or it may, or right now it's merely refreshing recollection? Okay, Mr. Tate?
Yes, it may. It's what we submit as an affidavit to the interim suspension, and I'm fine with all of this going in. In fact, I think I discussed, I might put at least tender both of those going in.
Right.
So have no problem with this being read.
Okay.
Have no problem with questions being asked about this, but there's something that I do want to make sure that I point out here, because the question that Ms. Veal asked was, you've had all these opportunities to say you would do something different. And, you know, what she puts in here is what happened. There wasn't any retrospective about this.
Well, okay, rather than narrate what's in there, you'll be able to follow. I have skimmed that before. I don't recall the specifics. Ms. Veal thinks there's something in there and is drawing your client's attention to it. She may acknowledge that she signed an affidavit. She may not. We'll see.
I think all of that's true. What I'm saying is it is not impeachment because she wasn't asked the question, what would you do differently here? For it
Okay.
to be impeachment, it has to be, what would you do differently here? Oh, then I said, I wouldn't do anything differently. Now today I'm saying, oh, I'd have another hearing.
That would be one form. So let's see where this
Did,
goes.
did the investigative panel ask?
I don't know.
Thank you.
I was not at all investigative panel meetings about that. I was retained shortly before the first motion for interim suspension
Wasn't aware.
was there. We haven't had any contempts. Nobody's been jailed since then, so.
Can I add to supplement that response to your question? She did come into the investigative panel meeting on October 15th of 2021 with Mr. Tate, and she did talk about the contempt issue.
Okay, I bet we're gonna go there, but you were asking Judge Peterson about the affidavit she presumably signed and hopefully read in connection with the first motion to suspend.
What's the question?
So have you reviewed the document that I provided to you?
I reviewed the portion that you, yes, it showed me, yes.
Okay, and what is the document that you reviewed there?
An affidavit, my affidavit. It says affidavit of Christina Peterson for the Supreme Court case.
And within that affidavit, you offered your explanation for what went on with this contempt matter.
I did.
Okay, did you offer any reflection regarding whether you would do things differently?
That wasn't the request in this matter. It wasn't to talk about what you would do differently. It was to talk about what you were alleging I did.
Within what term did you use to refer to the document that we've discussed over and over again?
It was in that form,
Yeah.
illegal, not legal. It's,
Another illegal document?
yes.
in this affidavit?
I said illegal. That means not legal.
You said another illegal document.
Yes, illegal means not legal.
When you came before, actually, strike that. Have you ever before today said that you would have done anything about this contempt proceeding differently?
I'm not sure. I don't know if I've ever been asked.
All right, I believe I am ready now to move on to our next complaint. It is 10:35.
So we'll take a brief morning break.
Okay.
I've got 10:35 on my timepiece as well, so let's try to start as close to 10:45 as we can. I think we have a hard stop for the lunch break at noonish. Okay, we'll be back.
Do you think? That's, I mean, this is all stuff you gave us, right? This is the one that, this is the one that Bo counted as an appeal, even though it was a transfer, right? Where is his order? Is it on there?
It's this one.
Fine. Okay, those are all fine. I'm not gonna stand there and read the rest of it.
Thanks. Fine, then.
Okay.
You need to think about it.
I did.
Oh.
You all can be seated. Thank you. So before we resume, just a reminder that one or both sides had invoked the rule of sequestration. I forgot to mention that this morning, but if any of you in the courtroom now think you might be called to testify, you need to be outside the courtroom. We are resuming the cross-examination of Judge Peterson, and Ms. Veal had indicated just before the morning break that she had wrapped up her questions in connection with 21-339, the contempt hearing allegations, and we're moving on to which next?
21307.
Okay.
And Your Honor, we have stipulated to the admissibility of exhibits 15 through 28, which all relate to complaint number 2021-307.
So 29 and 30 are contested in some way, or you're not going to use them? Those are the last two listed under.
I'm sorry, Judge, it's 15 through,
You had said 28, and there are two more exhibits listed,
15 through 30.
15 through 30. Is that right, Mr. Tate? All 15
Yeah.
or 16 of those, or Mr. Chamberlain, you're stipulating to their admissibility?
To stipulate to their
Okay,
admissibility.
Great, they are in. I will ask, Mr. Tate was one who brought it up, if there is a document that you're wanting Judge Peterson to hew to pretty closely with your questions, if she could have that document rather than it just be on the screen, I think that'll flow more smoothly.
Yes, Your Honor. All right, Judge Peterson, there was a petition for years support filed in the probate court of Douglas County back on February 17th, 2021, in reference to a Steve Richmond, correct?
Yes,
All right, and when a petition for years support is filed, they are generally filed by the surviving spouse of the deceased or minor children,
yes,
correct? Okay, and in this circumstance, the petition for years support was filed by Mr. Richmond's surviving spouse, Diane Richmond,
Yes.
correct?
I know I said there aren't going to be a lot of legal quizzes for you, but what is a petition for years support? Is it literally what it sounds like?
that is, it's
Get years worth out of the estate?
that's right. That's right.
In petitions for years support, petitioners, so those asking the court to grant them the support, must identify all interested parties, correct?
Yes,
And what are interested parties?
there would be the heirs, there would be any creditors, and if it's property involved, it would be the tax commissioner.
Ms. Richmond identified two adult children as interested parties, correct?
Yes, they're heirs.
Okay, and one is named Jaquita Mercado, and the other is Steve Richmond.
Yes, Steve Richmond Jr. We just call him Junior because it's two Steve, so yes,
And Ms. Richmond also identified a potential creditor, which was Bank of America.
yes,
I know that probate court across our state operate differently in this regard. What I'm interested in is the way your court operates. When you receive a petition for your support and you've got interested persons or heirs, as you called it, identified, those individuals have to be officially notified that the petition has been filed with your court, correct?
yes,
And the purpose of that notification is to give them the opportunity to object or to respond to the petition.
right.
Okay. And your court handles the notifications to heirs or interested parties on petitions, right?
Unfortunately, that's a requirement of the probate court.
Okay. And the way in which your court handles notifying those heirs or interested persons is sending them certified mail to the address provided by the petitioner, right?
No, we serve in accordance with the law. If they're in Georgia, they must be served personal service unless specifically requested in the petition to be served by certified. If they're outside of the state, then certified mail restricted delivery is a means of service. So yes, we do
Alright.
both.
Okay, and so both of the heirs in this case were outside of the state, correct?
That's right.
They were up north in New York.
I don't know if both of them were. I know at least one, Jaquita was. The other one, Steve, we never got a good address on him. He was never served.
All right, so how did your court serve the notification on the two heirs in this case?
Well, when they file the petition, any petitioner files the petition, they have to provide, generally, they'll provide an address. So we'll utilize the address that's provided to send out, like I said, if they're out of state, I believe in this case, we'll send certified mail restricted delivery. So that means it must be signed for by the person listed on the letter per the statute under the probate code. So we sent it to Jaquita Mercado in New York. We requested that she sign for it, and we sent it to Steve Richmond the same way. So we use the addresses that came on the petition. That was the initial service.
And your position is that when you are notifying persons out of state, they have to sign for?
That's not my position. It's OCGA 5311. There's two that we're concerned with today, 5311.5 and 5311.3.
Okay.
That's the law.
All right, right, and you're the probate judge, so explain to me, break it down, what is required.
It's
to complete service on out-of-state parties.
Out-of-state parties, it must be, well, it can be served personal service, but we serve certified mail. It has to be listed, limited to the recipient that it's listed to, and the green card that comes back must be signed by the person that's addressed on the envelope. So who's been served we must get a green card back with their signature.
So if Ms. Mercado had a significant other and that person signed for it, that's not sufficient.
It's
because
not.
That's not proof she actually got it.
Right, and the statute states that we must get service by another means the effective way. Yes.
All right, so just generally, what happens when you've sent a notification to an out-of-state party certified and you don't get the card back?
We don't get the card back, or we get it back.
You don't.
If we don't get the card back, then we would have to we generally notify the petitioner and advise we don't have good service. And maybe to try to see if we can get another address or information, or we'll see if they can get some type of acknowledgement, because we can skip service if we get a notarized acknowledgements. So that's usually the next step.
Do you ask the petitioner to try to get an acknowledgement?
Yes, the court doesn't get acknowledgements. It's usually the petitioners that get acknowledgements.
So what if the petitioner says to you, we gave you what we believe to be is the right address for this person. We don't have another address to give you, and we've been unable to get an acknowledgement. What steps generally then would you take?
Generally, I would, at the court, we will research and see if we can locate a address for the heir, unnoticed heir, so we can send the service to them.
And is that provided for in the law, that the court can research to try to find another address?
No, it's provided for that we shall get service. It doesn't say how. So it's not a go to LexisNexis, but no, it's what we do.
Okay, so when you all research in these circumstances, because you haven't gotten the card back, where do you research?
LexisNexis will pull there's an Accurate. and if you have the person's name that's being served or their last known address, you can input that. And generally it'll come up with their current address.
And you believe that it's fine for you to conduct research on LexisNexis to find addresses of people when you haven't gotten the little cards back?
Yes, I believe that based on the law and what's required. See, my court is very different from Superior Court. And we have duties. Superior Court, the attorneys and the person's filings have to do service. In my court, my clerks are responsible for it. So if my clerks don't get the service, the petition can never go forward. So that's a duty of the probate clerks to get service.
You said if your clerks don't get service, a petition can never go forward?
If there's not sufficient service in accordance with the law, we cannot go forward and sign an order. The case will be pending until there's sufficient service on the heirs or an acknowledgement.
And who's responsible for affecting,
The probate clerks,
who works for you?
yes.
But can the sheriff's department help you out?
We have to initiate it. So yes, so if we're doing personal service, we have to have an address and we have to fill out the form, submit it to the sheriff with the payment for them to do it. So we initiate all service in my court.
But why wouldn't the sheriff serve the papers for you just as a matter of routine?
I don't know. I don't think it's ever been done. I know it has.
One of the jobs of sheriffs.
Well, they do, but they'll take payments. So we as the clerks collect the payments for any service and we have to initiate it and fill it out and submit it to the sheriff or anybody. If it's out of state, we'll have to mail it. But that's a duty of the probate clerk, and that's how we're different from the other courts.
It's one of the ways.
One of the ways.
Judge Peterson, what I've done is put exhibit number 16 up on the screen for
Okay.
your review, and this is the first notice of petition to file for your support
Right?
that appears to have been sent out by your court in the Steve Richmond matter. It's got your chief clerk's signature here down at the bottom, and this document was certified by your court
Okay.
as just this one page. And this notice says that all interested persons are hereby notified to show cause if any they have on or before May 3rd of 2021, why said petition should not be granted, right?
Yes, that's what it says.
So that means this notice goes out to the heirs at the addresses that petitioner provided,
Hmm.
right?
Yes.
And it tells them you have until May 3rd of 2021 to get us an objection to the petition if you want to object.
Now, I'm going to.
Sorry. I'm going to assume that this is the same notice that went in the mail, but this one specifically was for publication. That's why she said run 4 times. So this is what went in the Douglas County Sentinel. So I don't know if this is the same one that was mailed to the heirs.
Okay. Would that be in the official court file if it existed?
It should be. It could be very well the same notice that was mailed out to the heirs because it's the same information to tell them that they have an objection date and they should.
Okay, all right. So, but your court sent notice to the heirs in this case that they had until May 3rd of 21 to file an objection.
I'm going to assume so without seeing another notice.
Is typically the date that's in the notice mailed directly to, at the address of record, the same deadline as the one that's in the notice by publication?
No, so the notice by publication is specifically for the creditors and the tax commissioner. So it's generally the 30 days from when it starts running. The ones notice to it's mailed would be probably 30 days from when it's mailed. So if we got an address later, it'll be extended.
Different dates?
Yes,
Okay, so this would, on May 4th, the ability of creditors
Yes.
and others will have expired.
That's
to
right.
object to.
that's right. But we still need service on the heirs. Yes.
Was service completed to your knowledge on Miss Mercado, the one up in New York?
When?
when the first notice went out?
It was never completed per Georgia law.
How do you know that?
Because we received a green card back that was signed, that we sent out for Jaquita Mercado, and it was signed by a Jose Mercado.
Okay.
And that came back on April 5th of 2021.
And that was insufficient, I'm assuming to you?
Yes, it was insufficient per Georgia law.
Okay, so what did you do when you got the card back signed by Jose?
Well, before then, before we even got the card back, I looked at the file and I said, we don't have sufficient service on Jaquita. So I probably looked at LexisNexis, that's normal, and would try to find an address. I don't know. I don't think I found one on her. So that's all I did on that case.
Why would you look up a new address? I mean, it could well have been the correct address and Jose signed in lieu of, let's pretend it's.
Okay,
And so he signed it. So it's not sufficient.
yes.
And I'm asking purely because I'm curious about how this works. Would not you then let Diane Richmond know, hey, we're gonna do this again. Maybe you want to reach out to your daughter, whoever this is. She's got to sign the green card. We got a green card back, but Jose signed and Jaquita, that's not the right set of communications.
Well, this is before I got the green card back. So this is when it's delayed. We haven't received a green card. I'm just reviewing the file again and saying what's going on. Let's see if we can get another address
I
and see if,
misunderstood. I thought you were responding to the question of you got the green card, it's got the wrong name on it.
no.
And so then you'd hop on to LexisNexis. And I was just curious why you'd be looking for a different address because you don't necessarily have the wrong address.
That's right.
You got the wrong signature.
Right, but no, this was before. This was still in May. So it's still, when I receive the case again, if it's been pending a while, it'll come back on my desk and I'm gonna say, well, why is this case not moving? So you generally look to see who we served and the address is provided to see if that's still the current address. So I looked and it appeared that it was. So that's all that I would do on that.
Let's back up. I understand that you've said that you don't know if this notice is the exact notice that was sent out to the heirs the first time, correct?
Right.
Okay. Let's assume that that first notice provided a deadline for objection, May 3rd of 2021, okay?
Okay.
Do you have any reason to disagree with May 3rd of 21 being the first deadline that was?
I
set?
wouldn't have any reason, no.
Okay. And so you testified though that you got the green card back signed by Jose in April.
Yes,
So.
April 5th.
So why would you have tried to research the address issue prior to April 5th? If the deadline for objection was May 3rd of 21?
Because we would have sent, the deadline would have been there, but we would have sent the service and we would have needed a green card back for the delay. We would have gotten the green card before the objection date. So
Go ahead.
yeah, so we need to know that they're even viewing this document. Do they have it to be able to object by the objection date? So when it comes back on my desk to make sure the case is still moving, I'm making sure that we've sent out sufficient service to the correct addresses.
So you became concerned because the green card did not come back quickly enough that perhaps Ms. Mercado was not aware of this petition being filed.
And yes, I know that. And I also became concerned because whatever we sent Steve, it came back and returned to sender. So the whole envelope came back. I don't know the date that came back. So basically, ultimately, both of those were returned with insufficient service.
Okay. So when you start researching Ms. Mercado's address, did you do that on LexisNexis? In
Yes.
the manner you described earlier?
Yes.
Okay. And what did you determine about her address when you did your research?
I believe I determined that the address that was listed was still her current address
And when you say the address that was listed
in the
You-
petition.
in the petition, 44 Summit Street, Fairpoint, New York, 14450. Does that sound correct?
I mean, whatever's listed in the petition, I don't have it.
Okay, but the address you find on LexisNexis was the one that was listed in the.
Yes.
petition, Right?
Right.
Okay. Did you do any research beyond just the address.
That's all I have access to.
Okay. Did you somehow locate a phone number for
No.
Miss Mercado?
I didn't.
You did?
I did not.
Did Miss Fazick somehow locate a phone number for Miss
I've
Mercado?
Since these proceedings, I have had IT pull all the email correspondence, and it appears that Ms. Mercado contacted the court emailed Bonnie Fasick and supplied her phone number to Bonnie.
All right, so your testimony is that Miss Mercado initiated contact with your court.
That's what I saw via email. That's what the IT turned over. I got all of the email correspondence, and the first correspondence was Ms. Mercado reaching out to Bonnie.
Do you remember what that email said?
It said, hey, this is Jaquita Mercado. I'm calling about my, her father's estate, and, is there I think she provided her number, said, can she call her? Something like that, but ultimately a phone number was exchanged.
Okay, so I want to be clear. You're testifying today that you did not locate a number for Miss Mercado, correct?
Right.
Okay, and you're testifying today that to your knowledge, Miss Fasick did not somehow locate a phone number for her, correct?
No, I'm saying that Ms. Mercado provided her phone number to Ms. Fasick in an email.
And the email, what was contained in the email is what you just testified to?
There was a chain of emails, several. There was a lot of, I had IT pull them all. So I looked at all the emails.
Okay. Did Miss Mercado say in that email, hi, my name is Jaquita Mercado. I received a message that you were trying to contact me regarding my deceased father, Steve Richmond. I'm usually available at 1:30 p.m. if you would like to call me. I will also try to call tomorrow.
Yes, I think that's the first email that I saw.
Okay,
Mhm.
but you just testified that Miss Mercado is the one who initiated communications with your court.
Yes, via email.
Okay, but her email says, I received a message that you were trying to contact me regarding my deceased father.
I don't have any, I'm not part of those communications. What are you asking me?
Okay, so you represented that she initiated contact with your court, and then you went into the fact that you read all the emails.
Right.
You agree with me that in reading these emails, it appears that your court left her a message. Someone there left her a message, and then she's responding back to that message.
No, that's not what it appears. I've read all of the files that were filed with this. It ultimately, the petitioner contacted Ms. Mercado as well. So I just don't understand what you mean, my court.
Mr. Tate,
I'm unsure of the relevance of this because, who called who first or whatever else, because they've got statutory responsibility to find them and they're trying to find them and reach out. So, I mean, I don't understand the relevance of who called who first.
Judge, obviously, if you've read the charging document, part of our allegations include allegations that there was independent investigation and ex parte communications with an interested party in this case. So it is relevant to that piece of our charge.
great, and neither Judge Peterson nor we have seen the document you're reading from, but your position is that that language you read into the record would be the first email in the chain to which Judge Peterson has referred?
Judge, I don't know what emails Judge Peterson is referring because I don't have them.
Okay.
I have documents that were provided to me during the course of my investigation.
Sure.
And based on the documents that I have, it appears that that was the first email
Mhm.
communication.
Okay. Then I understand the relevance and you can press on. I don't think so. Because I don't. This.
I'm gonna go ahead and mark this exhibit or this email as JQC exhibit 64.
I'm sorry, we were working through two different binders. You said what about what?
I have marked that email
Okay.
as exhibit number 64.
Okay,
My question was just, the emails we're talking about, are they in Mr. Tate's?
There,
I haven't seen them.
I don't,
Fine.
I've got a spreadsheet that's got every one of the emails on it
Right.
here, and I'm trying to, but what I have is the emails are short, so they're in the spread.
I'm sure we'll see them if we need to.
all right.
But again, my only objection is, I don't think there's, and I think the allegation is there's been some kind of improper contact. And I don't know that this goes to show any improper contact, call and say, you know, hey, we don't have service on you.
Well, we're about to see what it says, that what I heard it say, would give rise or would support an argument that Ms. Mercado had been contacted by Judge Peterson's team, whether it's Judge Peterson or Ms. Basic, because she is sounding responsive in that email. Judge Peterson has raised the point that, well, actually, it could have been the petitioner who reached out to her. So there are different interpretations, but I don't think it's irrelevant to the allegation. Do you have any objection other than relevance to Director 64?
I do not.
Okay, admitted.
And we may have other emails too that would complete that.
Yep. It's in.
Your Honor, the only thing I would, in addition to what we just explained regarding relevance is Judge Peterson testified that nobody in her office had located a phone number in their research or an email address for this woman, and so I think that's another reason.
Okay.
Okay.
Judge Peterson, I'm showing you JQC exhibit 64.
Well, I didn't say that. You just misclassified. What I said was she gave the phone number to my clerk in an email. I did say that.
No, ma'am.
So you guys don't need to argue. The
Okay.
testimony has been taken down by the court reporter,
Okay.
and whatever Judge Peterson said, she said, and she can answer the next question.
Okay.
Well, let me clarify, during the research that you did you locate a phone number for Miss Mercado?
Phone numbers are generally not available. I wouldn't say so. I don't think so.
Okay, so is that,
No,
okay, did you locate an email address for her?
I did not.
Okay, and then Miss Basic, did she also research Miss?
No.
Mercado? Okay, she did no research whatsoever.
No, I wouldn't think so.
So.
Hold on
does-
1 second. Mr. Tate.
Not to my knowledge.
I'm trying to stop us from chasing our tail here just a little bit. And I'm using my note. I can try to pull the email, but in this same chain, I have other emails where Ms. Fossick says, please give me your phone numbers. It's difficult to reach me by phone. I will call you around 1:30. And she says, sorry, here's my phone number. I'm not trying to, I feel like I'm jumping in the middle of their case, but I'm trying to stop us from chasing our tail here for another 30 minutes about something that might be clarified.
Okay. Well, if there are emails that you intend to use, they probably ought to have been something shared with Ms. Veal. And so hopefully there aren't a lot of surprise emails out there that the director doesn't have.
Well, Judge, I mean, we probably just need to short circuit this because what I have was provided to me by the petitioner. She obtained these emails in discovery. I've never been provided an entire series of Judge Peterson or her office's emails. And so if they intend to enter those, I would like to look at them now and let's just enter them all now versus going back and doing this.
Right. Why don't we, I think that's a great plan. During the lunch break, Mr. Tate can slide across that slug of emails so that your team can, in fact, ideally, I don't know if there's I don't know how it's set up. If there's a way that you could email those emails to Ms. Murphy, so she could be looking at them, and Ms. Veal, I'll just have you we will have you explore other areas of this particular complaint.
I apologize. It's not my intent to short hop anybody. I don't think I realized that the phone number by itself was such an issue, but
Well, I don't know that it's the phone number so much as Judge Peterson saying, it's not an issue, just Judge Peterson observing, hey, Judge Peterson, got IT to give me all these emails that relate to this allegation. And it sounds like she got them to you. I'm a little confused as to why they then didn't get to Director Veal in just the exchange of discovery. Mr. Chamberlain seems troubled by the notion that we would share information that's relevant to the allegations. Not troubled?
If I can speak, I guess, my concern is that we've been hit with like 404s and a lot of evidence from them that has not, some evidence you don't know is even going to be relevant until it comes out in cross-examination. And I understand that. But we have also been in a situation where we haven't gotten, I mean, we've gotten 404s and certain exhibits like Exhibit 64, I guess has been,
Well,
that we don't have that either. So I mean, it's not like it's just us being the party that hasn't completely given everything. And I don't want to leave that impression with the
You
court.
don't, and I have worked with Mr. Tate. You and I are working together for the first time. I know that's not how he rolls, but the fact that allegedly the director's team didn't get you something on time doesn't justify you not doing that. So I'm just confused. I'm not seeing how emails between the judge's team, whether it's Judge Peterson or Ms. Fasik and Ms. Mercado, wouldn't be deemed as likely to be used during the proceedings, given the allegations that flowed from complaint 21-307. And so I'm just a little surprised. I'm not using the word disappointed, but surprised that those emails weren't things that were exchanged. I'm not casting aspersions in any way, but given how it's now relevant, as we've seen from the exchange between Director Veal and Judge Peterson, my suggestion is, unless there's a basis to not share it, is to slide that across to Ms. Murphy so that the director's team can be looking at those and we can press on.
Yeah, I don't have any problem with that. I just had a problem. I thought that was the implication that we somehow were holding something back. And that was never our intention. And we turned over what we thought was pertinent. And now we've realized that now we want more and there's some confusion. And I understand that, but I just wanted to make sure that the court wasn't left that we're holding back and they're giving us all theirs and we're not doing the same. I don't want that.
what I would like to do, because I don't actually physically have the emails. I have a spreadsheet, which I think the spreadsheet was probably what was provided to us from Judge Peterson. And it's on the computer, but I'll pass this over because it's got the text of the emails and it's not best evidence, but I want them to see what it is. And
Okay. Good. No, that's fine. And I want to be clear, Mr. Chamberlain, I apologize if the way it came out was, why are you all sitting on this? I was observing that let's hand it across now. And to your point, what's relevant evolves over time. As I was explaining with why shouldn't the two transcripts be handed over? We don't really know how relevant everything Ms. Fasik said in her interview with the investigative panel. It's just easier to give it to you. And you may end up with a 50-page transcript being interested only in page 32, but you won't know that till you have page 32.
And and of course, with the assistant, we tried to prepare this because I wanted to make some logic to try to cut through and make it easier on the panel to find out. So if you can start talking about who said what on an email, that's really not productive. I mean, the emails are probably the best evidence of what was said. Why not list them in chronology, list what they said and do it that way? And that's why Mr. Tate stood up and did what he did.
Understood.
And I think what I have is
Present my case better.
I think what I have is a summary of what the emails are. I don't think me or my office ever physically had them, so we'll have to get that.
Yes, so the spreadsheet that was prepared is quotes. They're exact emails, but I can give you all the individual emails that was provided to me. That was never, I didn't provide that to my attorney, so I just provided them and I told them, let me know what they needed.
And I've got a sheet of that, but spreadsheets don't print out particularly well, but I will also provide them with this as well.
Ms. Veal, we're not trying to hijack your presentation.
I know you are.
There were references to other emails. In fact, Mr. Tate started quoting from one, and we crave those kind of documents because, to everyone's point, it'll lay out a chronology that is helpful or hurtful to one side or the other, but then we've got the chronology and we're not relying on people's recollection of what happened. This is 2.5 years ago.
And I apologize. I think probably the spreadsheet came to me and I didn't, might have been work product. I'm happy to leave
Yes.
that.
Oh, sure. The spreadsheet, I would
Well-
hold tight too.
But I don't think I think I'm gonna have to get those originals from her.
Okay, Ms. Veal,
Judge
But-
Peterson,
Yes,
what exhibit number do we have on the screen?
this is exhibit number 18
yes,
that I've got pulled up. And you agree that there was a contained within the file of this case, there was a certified mail receipt, correct?
this is showing that it was mailed off.
Right.
Yes.
From Douglasville on March 22nd of 21.
Yes,
Okay. And it's to 44 Summit Street in Fairpoint, New York.
that's right.
Okay. And you said that Jose signed the card and it got back to you April 5th.
That's when it was filed in, yes.
Okay, so you became concerned between March 22nd and April 5th that Miss Mercado did not get your mailing.
Yes,
Okay,
and not just her, Steve Richmond as well, the little junior.
okay. Did you do any research on Mr. Richmond?
Yes, to no avail.
What does that mean to no avail?
The address listed, it appeared to be the address, the same address, but ultimately Steve Richmond's letter came back returned to sender. So just like Jaquita, the address was the same. So there was no new information.
So when you say the address was the same, you mean the address you located on LexisNexis when you researched Mr. Richmond matched the address that was given to you by the petitioner?
Yes, I believe so.
But Mr. Richmond's came back undeliverable.
Yes.
At some point, there was a decision made by you to send out a second notice in this matter, correct?
Yes, once we received an email address from Jaquita Mercado and she was willing to accept service by email, then Bonnie resent a notice extending the objection date and authorizing the service by email.
And I want to talk to you about that second notice, which is JQC exhibit number 19.
Okay,
And this second notice provides a deadline for objection of July 10th of 2021, correct?
yes,
And you said you all sent this second notice out after you got Mr. or Miss Mercado's email address, right?
yes.
Is this the certificate of service down here at the?
That's
bottom?
Bonnie's representation of emailing it to Jaquita Mercado.
And emailed to Jaquita Mercado at richmondjaquita@yahoo.com.
Yes, it appears so.
Okay.
Just-
There,
I'm sorry, Judge Peterson, while this is being litigated, are there provisions in the law that allow Ms. Richmond to provisionally draw from the estate, or she's not able to get anything until you're able to resolve her petition for your support? That question makes sense? I can ask it a different way.
I don't think there's any provisions that would have her be able to take from the estate before a petition for
So
your support,
she's stuck waiting
for service.
while you're doing your job.
Yes.
The opposite of serving Steve Richmond Jr. and Ms. Mercado.
Yes. So the only thing that could happen in the interim, that you could do a letter for temporary letters, but that's only to preserve assets. That's not to disperse.
your decision to send out a second notice of the petition and to extend the date within which these heirs can file an objection from May 3rd to July 10th was based on what?
Her not receiving service. So in Superior Court, if I serve you today and you're not served by the sheriff, you get 30 days from the date of service. But here in probate, we have to set a date. So because we had to initiate new service, there had to be a new objection date. We couldn't serve her in May 10th and have her objection date May 3rd. That would have been improper. So the law authorizes, I think it's OCGA 5311.5 and 5311.3 authorizes the extension of service and additional service.
And I'm not debating that you as a judge have the discretion to extend the deadline for filing an objection. So I don't want you to think that, but do you agree with me that when you make a decision to extend the deadline for an objection 2 months out, and we have another party here, Ms. Richmond, who's waiting on her petition to be addressed, do you agree with me that it would be important to notify Ms. Richmond and her counsel that you have extended the deadline for filing an objection?
Well, I don't know that it was 2 months out. You're asking me something that I'm not aware of. I know I authorized the service and the extending of the deadline. But generally, yes, if the petitioners call in, we will notify them that we can't call everybody and say, hey, on this case, we're doing service, we're extending service. Usually they call in, ask for case information status, and we'll tell them, hey, we're trying to get service on Jaquita. We haven't gotten sufficient service. Do you get it? Do you have an acknowledgement? Can you get an acknowledgement? So that's usually the conversation if they do call in.
So when you extend a deadline like this as a judge, your position is the onus is on the opposing party or the party on the other side to call your court to find out that you did so?
No, you would likely have to ask Bonnie. Generally, I think she notifies the parties, but that would be a chief clerk question. But we are doing our job of getting the service on the case so we can move forward with the petition.
Do you agree with me, though, again, that for the petitioner in this case, it would have been important for her to know that you made a decision to extend the deadline for objection?
I think she would have known that if she would have known that there was not service. So I would say yes. It would be important for her to know that we didn't get service and we are getting service.
Ms. Veal, is there any evidence that you can point us to as to when this second notice went out? I know some things were happening in May, but then all of a sudden, June is gone and we're into July. If this notice went out in the middle of June, and it's really only it is several months extension from that May 3rd date, but it's really only a month that's being allowed in the notice. But if this notice went out on May 5th, it seems like it's a longer period than we were exposed to with all the other notices. I just couldn't see a date on here.
So it appears that this notice was sent to Ms. Mercado at some point via email. There is no evidence that it was ever sent to anyone else, and there's no additional certificate of service.
I didn't ask it well. Do we know when that email went out? Is that an email that we have? I'm just interested in knowing if that email went in May. And so then all of a sudden, Ms. Mercado had 2 months to object, or if that email went out in the middle of June, then she's getting the window that people seem to typically get. It just took a while to track down her email address.
Judge, if you could give me just a moment.
And you all can look that up over the break. I just wasn't sure. You might have been able to say it's right there, Judge, in front of you on the document. I just didn't see any. The only date is the deadline for the objection.
Right.
And perhaps that's in the emails between Ms. Basic and Ms. Richmond.
Okay.
If I could observe, I do think that the phone call, regardless of how it was initiated, the date I have on that is 5/27.
Okay. So we're towards the end of May.
Almost June is what it looks like.
Got it.
I don't expect you to take my word over what the proof is, but
No, but then these dates all fall into the sequence I've come to understand from Judge Peterson.
Were you aware that during the months of May and June of 2021, the petitioner's lawyer's office contacted your court repeatedly, asking for a status update on this matter?
No,
Okay, nobody mentioned that to you?
no, I don't handle phones. I don't answer phones.
Were you aware that the petitioner was never notified, never obtained a copy of this second notice that you sent out?
I was not aware. I later became aware, but at the time I was not aware.
Back in, I'm sorry, back in 2021, was there the equivalent of e-filing for your docket so that I would just get service notice of anything new added to the docket?
There's no e-filing probate. There's some courts have now initiated e-filing, but no, we're all paper.
Yikes.
Yes. All paper files.
And since you're all paper files, then the onus would be on you to ensure that all of the involved parties properly receive notices and documents related to the case.
It would be on my court, yes. I can't correct anything until I'm made aware of what's going on. So once I'm made aware of it, I do make corrections, absolutely.
During May and June of 2021, was Miss Richmond's petition ever on your desk for signature? Like, was it ever in the final stages of I'm about to sign off on this petition because nobody's objected?
You mean order, the order? No, we can't sign off on I can't sign off on an order until I get service on the heirs or acknowledgements.
Is there a reason why somebody from your court would convey that a matter is on your desk for signature and it's in the final stages of processing, if that's not the case?
Maybe, I don't know. I can't, I don't know what they do. They're busy. And so maybe they were just trying to, somebody might have called in and I can't say, I can't speak to it, but no, it would not be ready for signature unless it's ready for signature. There must be sufficient service under the law.
How many employees stayed between the old
Administration,
and you,
one.
and how many employees do you have?
At that time, I probably had about 5 or 6.
How many did the prior probate judge have?
About the same, but they all knew, they all knew how to do what they had to do. So this was all me training new people. So he had about the same.
But there were several months, whether it was official or not. You
Yes.
knew you were going to be the probate judge in June.
Yes.
Was there any transition period between June and when you took office and sworn in?
You mean transition from his administration to mine?
Yeah.
I went up to the court a couple times to see if I can get acclimated to, he didn't really teach me much or tell me much. He just said, you'll get it when you come in. It's just common sense. That's what Judge Hamrick told me. So like, I didn't get any formal training or I walked around. I did things like go to the HR to see what employees he has and the type of employees and what their qualifications were. I did things like that, but just to the operations of the office, I wasn't allowed in to see what they were doing and how they were doing it until January 4th, 2021, my first day.
The heir, Mr. Richmond, according to your testimony, his mail came back. And did he ever file an objection in this matter?
I don't think he ever got notice. I mean, the court is not aware of any sufficient notice that he may have. But we didn't get notice of his official service.
Did you hold your hearings virtually in this case?
I generally do hybrid. Anyone who wants to come in can, anyone can come over virtual.
Okay, do you, recall that you held a virtual hearing in this matter on August 5th of 2021?
I've held several dates. I don't have the dates before me, but I have had several hearing dates on this one.
Okay, well, during one of those hearing dates, do you recall addressing the issue that Mr. Richmond never got service, or that was your concern?
I'm not sure. I think, I'm
Go ahead.
sorry. If I said a hearing, it was probably because we had an objection. And so I probably said a hearing on the objection.
Yeah, and we're gonna get to that.
What does the law say, as best you understand it? Let's say that Ms. Mercado had acknowledged and didn't object, so you've satisfied half. But Steve Richmond Jr., we just can't find him. There's no indication he's deceased,
Mhm.
but he is in the wind. Is Diane Richmond unable to go forward? Because it's not your fault you haven't served. the
Right.
guy. It's just hard to find. He's living in a trailer somewhere and no address. And
Mhm.
is she stuck under the law?
No, under the law, there's a opportunity to appoint a guardian ad litem.
Okay.
And the
'cause
guardian,
I didn't
Uh-huh.
realize, because I noticed there were some exhibits involving a guardian.
yes. And then there's another thing sometimes I do allow, if they do an affidavit of diligent search and tell me all that they've done, I will allow publication for that air.
Okay, so there
Yes.
is that, so this is sort of like on the civil side.
Yes.
If there is a sufficient showing that we've checked accurate and you have to, and we just
Mhm.
can't find a good address, or for all the good addresses for Steve Richmond Jr., it's coming back, no service
Mhm.
available, or he doesn't sign for it. There are two ways, the guardian ad litem, or you could
That's
say,
right.
you know what, you can serve by public.
That's right.
And then it goes in the Douglas Deacon, what was it?
Douglas County Sentinel.
Sentinel.
Yes.
Usually it's the same letter.
Did you ask Miss Mercado during a hearing, if she had a good address for her brother, Mr. Richmond?
I don't recall. I think, like I said, if I said a hearing, it would have been on the objection. So it would have been on the matter that Ms. Mercado was there for.
But you don't recall asking her if she had a good address?
I
for
don't
her brother?
recall. I may, I'm not sure.
Do you recall, during any of the hearings, Miss Mercado, leaving the hearing in an attempt to call and speak to her brother?
I don't recall. I don't remember that.
How often do heirs, you happen to guess, I get
Mhm.
that, object to a petition to file for year support?
When is, I see it a lot when there is a decedent who was married to a woman and the children are not the woman's.
It's a stepmom.
Yes.
It's a late in life wife.
Yes. So that was this case, but every other case, if it's my mom and it's in the kids, they usually don't object.
Give mom the money.
Yes.
And when you say that was in this case,
Miss Richmond is not the mother of the heirs.
she's their stepmother.
Yes.
Do you recall Miss Mercado reporting to you that she had spoken to her brother and he had just gotten notice?
I don't recall. How would she speak to me? And you're saying it's in an open court? Because I don't speak to
During
anyone.
a hearing?
I'm not sure. But if she did say that in an open hearing, it wouldn't be sufficient service for the court.
All right, but Mr. Richmond never filed an objection.
I don't think he had service. Like I said, according to the court, he didn't get sufficient service, but he didn't file an objection, no, or acknowledgement, no.
Thank you. Did Miss Mercado ever file an objection?
She did.
Okay. And how did she file that objection?
She submitted the objection on June 11th to the probate court judge fax. And that's an email.
Is that, do you deem that, is that considered filed?
No, so when it was sent to the probate court judge fax email, I forwarded it over to the chief judge and said, you need to get the filing fees and the original. So like I said, we're really not e-file, although it is allowed, but I would really like the original. But she sent a picture of the objection and it was notarized. And so I sent it to Bonnie and said, hey, get the filing fee and get her to send in the original.
Okay, so your testimony is you, via the probate judge fax email address,
Mhm.
received an emailed objection from Ms. Mercado
On June 11th.
on June 11th.
Yes.
Okay. I'm showing you JQC Exhibit 20. Is this the objection that you're referencing that you?
Yes, that
received?
was the screenshot of the objection that was sent on June 11th.
And what you received via the probate court judge fax on June 11th was just this. It was just a screenshot of this paper that she's typed up, correct?
Yes, showing the objection that was supposed to be submitted to the court. Well, this is insufficient because they're filing fees. So we can't take a filing without the fees. And again, I request the original. So Bonnie communicated with her, hey, there's a filing fee. In order to take your objection, we need a filing fee and you should mail in the original objection. So that was the communication Bonnie had with her after that.
But you never received the original objection, correct?
It never came in. About a month later, the objection never came in. And I believe the Richmonds were asking, hey, what's going on with this case? Well, there's been an objection filed. We're waiting on the original. So we've never got it. So at that point, the court was on notice that there was an objection that had been mailed. The lady mailed a receipt of the money orders as well to Bonnie. And so we knew it was coming, but obviously it got lost in the mail. So I authorized Bonnie to allow the emailed objection and take the payment over the phone.
The uniform rules of probate court, you're familiar with those, correct?
Yes,
What
somewhat.
do those rules say about when pleadings or documents are to be considered filed with your court?
I don't know. Can you can probably, you have it in front of you?
Uniform probate court rule 5.3.12 filing requirements. Pleadings or petitions presented to the clerk for filing shall be filed only when accompanied by the proper filing fee.
Correct.
Okay. But you advised Ms. Basic, it sounds like, to file this on July 14th of 2021.
No, so I'm sorry. I'm sorry, I thought I explained it. So the lady emailed it on June 11th. I told Bonnie, you need to let her know about the filing fees and to mail the original with the filing fees. The lady emailed, Jaquita emailed Bonnie and said, hey, I emailed my money orders and I emailed the objection. And I think that was still in June. When it got to be July and we have not received it, the court is already on notice that there was an objection that was mailed out. So my request was, hey, please see about this objection and where it is. So I believe Bonnie contacted Miss Jaquita, it might have been via email, and said, hey, we never received your objection. Did you mail it in? The Jaquita responded, yes, and sent the receipts. And these were all done before the deadline. So the court, myself, authorized to take the payment over the phone as well as the photocopied objection because she mailed the original and it got lost in the mail. So in the interest of justice, I authorized that.
How do you know that the original got lost in the mail?
We never received it. She had receipts of her money orders for the filing fees that she sent and submitted to the court via email.
How do you know what happened to the original?
Well, she said she mailed it. I'm just going by what is on the email. I'm sorry. We never received the original in the court. So wherever it went, it didn't come to the court.
Okay, so you accepted then a screenshot of a document that's written out on a piece of paper. You accepted that as an objection.
Absolutely.
Okay.
In training, we're taught to accept a ham sandwich if they pay the filing fee.
Okay. So this is filed in by your office on July 14th of 2021, correct?
I'm not sure that it says that on the date that it was filed in. I believe that's probably the date that Bonnie got the actual payment over the phone.
Okay, and that's what the Uniform Probate Court rules say about when documents should be filed. They shall be filed at the time that the filing fees are received, correct?
I believe so, if
Okay,
you
so
said
this-
that.
This document is then considered filed July 14th of 2021.
That would be, well, I don't know about this filing stamp, but that would be more of, I think it's in my outline of when the actual payment was made. So whatever payment, whatever date that payment was made may be different from what's on here.
Isn't that your stamp?
And why shouldn't
For the
we,
court.
why shouldn't we rely on the date we see on the screen? Because you say, well, I don't know about that stamp. Is there a
Well-
reason we shouldn't trust the date?
Well, it's when Bonnie might have got the order. I don't know. I mean, when Bonnie may have gotten the payment might be different from the date she filed stamped it in. I don't know if that's the same date. I would have to have the file and look at it. So either way, the point is, regardless, I'm going to say, if the 14th is the date that she was allowed to pay on the phone, I knew as the judge of that court that the objection and the money was sent and intended for the court before the objection date. So regardless if Bonnie couldn't get a call into her until the 14th, I was going to allow the objection because it was a sufficient notice on the court of her intention to file an objection within the deadline. And I have the authority to extend the deadline as well in the interest of justice.
The petitioner never received a copy of this email screenshot, correct?
She received the copy at court.
Right, but you're claiming that this was emailed to you on June 11th, and for you, that date is operative, right? It's not filed in until July 14th of 2021, correct?
Yes, that's right.
And so you're aware that the petitioner never received a copy of this document?
Until it was paid for, correct.
Well, are you aware that the petitioner's lawyer's office actually called into your office
No,
and were advised that an objection had been filed?
they were advised?
Mhm.
No, I don't know about the communications where they're calling in and talking to clerks. I don't have any information about those communications.
Well, certainly you would have become aware that they never received a copy of this until they called and were told that they got it because it was outlined in the petitioner's motion to strike this objection, correct?
I'm sorry, what was the question?
The fact that she never got notice of this was outlined in her motion to strike this objection.
I think so, because I made a response in the order. I made a response to it in the order.
Exhibit 20 has two parts to it. So I've shown you what we've been referencing is the order that was filed in by your office July 14th. This is the first part. And since you've reviewed some emails that you got from IT in relation to this matter, did you see this email from Madison Beasley, who at the time was a clerk in your office, to Miss Joanne Cabral on Thursday, July 15th of 2021, attaching the objection?
No, I didn't know that emails to Joanne Cabral I didn't know that was an issue. So I didn't have them pull any of those emails.
Who is Joanne
That's an-
Cabral in connection with the Richmond matter?
I think she's a paralegal of the petitioner's attorney. So I wouldn't have thought to pull that.
So this is your office letting petitioner Diane Richmond know, hey, there's been an objection filed.
Yes,
On July 15th of 2021.
yes, it appears.
And the second date for objection, the deadline you set was July 10th of 2021, correct?
Yes.
Okay. So the petitioner ultimately filed a motion to strike or disallow the caveat or the objection that was
Yes.
filed. Okay, and you held a hearing
I did.
on the motion to strike or disallow?
Yes,
Okay, and you ultimately issued an order denying her motion.
Yes,
So you found that the objection had been timely filed?
it was. Well, it was timely submitted to the court. Yes.
Based on the email that went to the probate court judge fax.
Yes, and her sending it in the mail, the payment, yes. So we're not gonna, there's been extensions. I mean, you allow, when you have proof that somebody sent the payment within the objection period, you don't say, oh, well, I'm not gonna accept your objection because, no, you give them an opportunity to pay over the phone if it got lost in the mail, and that's what we did here. And that was the discretion, my discretion, absolutely.
And you denied the motion, understanding that the petitioner had never received notice of this until it was sent to her by your office July 15th.
I'm just knowing that it was sent there on that day. I didn't even know that Madison sent, I'm not a part of these email chains, so I didn't even know that was done.
Did you read the petitioner's motion to strike or disallow the caveat
Yes, I responded to it.
over that hearing?
I responded to it, but that you can make allegations in a petition, but I don't necessarily know if they're true or not.
All right. You mentioned that at some point a guardian ad litem was appointed.
Yes,
Let's talk about that. This is, I'm about to show exhibit number 22. Filed in by your office August 18th of 2021.
yes.
Right, so your order here in exhibit number 22 says that you hereby find that Ms. Mercado and Mr. Richmond, who are post-deceased heir having no personal representative, are in need of representation by a guardian ad litem.
This is a general order. This is a form order. So yes, that's what this says. Am I to answer a question about it?
And so you found that both of these individuals were in need of a guardian ad litem, correct?
So this order was incompletely submitted. So although I have the authority to appoint a guardian ad litem, the problem was at the hearing, the attorney asked, the petitioner's attorney asked for discovery from the caveator. The caveator at that time stated, what's discovery? So in order to effectuate the discovery that the petitioner want, I, using my discretion, appointed a court-appointed attorney to assist in to getting her those responses. So I told my clerk to appoint an attorney to help to get the responses that the petitioner needed. Bonnie, my chief clerk, and the prior administration has always referred to a court-appointed attorney as a guardian ad litem. They use the word interchangeably. So this is what she came up with, but that is not the order that I want. So in essence, when she appointed Joe Gable to assist in discovery, obviously Joe Gable, not operating as an attorney, is not going to respond to discovery. So I wasn't really alerted to the mix-up until we came to court again after this.
You said this is not the order you wanted, but this is the order you signed, correct?
Well, they have a
That's
stamp. I have a
correct?
stamp.
Is this the order you signed?
I have a stamp.
Judge,
Stop. We have a bunch of questions.
Okay.
You go first, Mr. Hyde. We'll work our way down the line.
A stamp, when it's filed in, or a stamp of your signature?
Signature stamp.
And how do you use that?
It's utilized on certain orders. Like if I order in court to appoint certain things, they are authorized to utilize my stamp.
Why do you have a stamp?
It's that way. When I came into the court,
Your stamp was there before you got.
no. When I came into the court, that was the prior administration. They were asking me for my signature on the pad because they said this is how it works. So I got it. There was a stamp that was utilized for Hamrick, so they had to get one made for mine. So there is a stamp. Since then, I have changed the operation and the use of the stamp to be able to further monitor of what is signed. So on new cases that I allow stamps on, I make them put a copy of my authorization to use my stamp, maybe an email, and I make them sign their initials on who used the stamp.
I have never seen a judge use a stamp and it turn out.
I'm telling you, that's kind of,
But you're responsible for the use.
I am. But that's like one of those policies and procedures or practices that was in place that I've had to change and fix. Yes.
Anything else on this? So. So another one of these documents that you're saying, it really doesn't say what it says, but this order with your signature on it appoints a guardian ad litem to two people who may have conflicting interests, one of whom may be dead. When did that jump out at you, that you've appointed someone to represent people who might have conflicting interests? Ms. Mercado may be objecting and Mr. Richmond may say, I want Denise, whatever her name is, Ms. Richmond, to get that one.
Okay, so the guardian ad litem, if this was an appointment for a guardian ad litem, then this would have been, this is okay, because a guardian ad litem has a full duties that are, the court appoints a guardian ad litem to do whatever the court needs it to do. So if the court needs the guardian ad litem to research and find the addresses, the guardian ad litem can do so. That wasn't the intention of the court. The court was wanting to appoint an attorney to represent, to assist Jaquita Mercado in coming and getting responses to the petitioner's request for discovery. So at that time, Bonnie, and she will be able to testify about it more when you have her, but Bonnie issued this order appointing a guardian ad litem with the understanding and the belief that it was a court-appointed attorney.
Of course, you issued the order. You can
Yes,
amend
yes,
mine.
I'm sorry. Yes, it was, I did. It was under my authority. I was not made aware that the issue for guardian ad litem, this order was not made until we got to court the next court day. And then I was alerted when the petitioner's attorney stated nobody's responded to my discovery. So I was like, didn't we appoint an attorney? So then I pull the file, look, and see that there was an order to appoint guardian ad litem. On top of Joe Gable had a medical, he was out on medical leave throughout that time.
And he was appointed to represent
Two people,
two
right, right.
Okay.
So I noticed the error at that time and corrected it.
But you didn't notice the error at the time that you signed,
I didn't notice the error at the time this was filed, no.
at the time that you reviewed it when you signed it.
I answered your question. I didn't notice the error at the time that this was filed in.
Do you review the content of orders before you sign them?
Not all of them. There's a lot of orders that are issued, and no, not all of them. Like I said, I have authorized the signature stamp.
Do you do arrest warrants or certain,
No,
but you could, you
no. I'm probate. We don't do
It
criminal.
doesn't have traffic jurisdiction.
No.
Did you have any questions about this, Mr.?
I have a lot, but I'm gonna try to limit. So you say this order was issued in error.
Yes.
Is there an order revoking this order? Is there an order amending this order? Is there an order that supersedes this order that corrects the error that you say was made by this order?
There was an order issued after this one.
Was?
Yes.
It was an order correcting this order?
There was an order appointing a court-appointed attorney to represent Jaquita Mercado.
What's exhibit 25?
Judge, I'm pulling up exhibit 25.
Yes.
All right, but this order doesn't revoke the appointment of a guardian ad litem.
Yes, it doesn't. There was no, like I said, there was no real harm in that appointment of the guardian ad litem because we never got service on Steve Richmond. So the guardian ad litem could in effect accept service on his behalf. There's still no service. So
So did that occur? Did-
no, that was the guardian ad litem was overturned. We never got there.
It's,
It was removed.
it wasn't removed. You signed an order that was never,
I think she recused and it went up to Superior Court and Judge McLean. I think she's,
And you guys don't need to, I mean, there's a question right now. We've got 2 orders. I don't know if this is a stamp signed or a wet ink signed appointment of attorney, but there's also the Gall order
Mhm.
that isn't countermanded by this. Right now, Ms. Mercado has 2 lawyers that the county is paying for, Mr. Gable and Ms. White. So Mr. Lopez's question was, is there a document that Judge Peterson entered that said, hey, cancel that guardian ad litem thing, at least as to Ms. Mercado, we're only going to pay for 1 lawyer for her, and that'll be Ms. White.
Well, no, so the guardian ad litem isn't a lawyer. Well, he is a lawyer, but the guardian ad litem doesn't operate as a lawyer in my court. So the guardian ad litem can be non-lawyers. So the guardian ad litem remained on the case, but he wasn't active because he was under medical leave. So at the time, he was not removed, hoping he would come back from medical leave to be able to accept service for Steve Richmond. I appointed the attorney to assist with the responses for discovery for Jaquita.
So when you have an heir who has not filed an objection and who, according to your testimony, has never been served, it's proper according to you to appoint them an attorney or a guardian ad litem, despite the fact that they've not filed anything?
The statute and the probate rules allow for the appointment of a guardian ad litem in order to, if we have an unacknowledged heir, the guardian ad litem can be placed to accept service on their behalf. Yes, that's the law. I don't have the code section in front of me, but I can pull it for you.
So then what is just, in this case, Mr. Gable's responsibility to try to research Mr. Richmond?
Sometimes I do that, but Mr. Gable didn't do anything on this case because first of all, he was on medical leave. And by the time I don't know if he probably was still on medical leave by the time I recused.
Right, I have exhibit 25 pulled up, Judge, and that is your order appointing an attorney to Ms. Mercado,
Yes,
and that was filed in October 22nd of 2021.
okay.
So Mr. Gable then would have been in the case for about 2 months.
Mr. Gable there was an appointment, but he was on leave, so he wasn't active in the case.
I understand, but your order appointing him was August 18th of 2021.
I believe so. Yes, so whatever date that was, it's 2 months.
Right. And then, so at some point, you then file this order appointing an attorney on
Mhm.
October 22nd of 21.
That's right.
Mhm. And your order says that you're appointing Miss Angel White to represent Miss Mercado
Mhm.
to be paid from the indigent fund.
That's what it says.
Okay, what's the indigent fund?
Well, that was the term used by Bonnie when it was drafted, but ultimately it's a legal fund. So I have a budget that I utilize for the services and operations of the probate court, and the Board of Commissioners authorized me a legal fund. So that's where it would come from. So it's not indigent, it's a legal fund.
Do folks for whom you're making this appointment using those funds need to meet a certain income threshold, or it's purely your discretion? Bill Gates, you would have the discretion to give Bill Gates someone paid from the legal fund.
Yes, it's my discretion. It's not a threshold, it's not indigent, it's just legal services.
So you can, in your discretion as probate judge, appoint an attorney to anyone you want.
When the interest is, yeah, in my discretion, yes. That's my budget authority.
I thought you didn't have a budget at this time.
No, I got a budget.
When did you get the budget?
So the budget that I had, I advocated for my budget before I ever got sworn into office.
Right, but we heard about all the obstructions.
Right.
When did you get a budget?
At the beginning. So I got the budget that I wanted for my operations, not the salary budget.
Got it.
Yes.
So I understand you're saying you had the authority pursuant to your budget to appoint this attorney. What is the legal authority to support appointing an attorney for an heir that lives out of state in New York?
There is no legal authority not to. So it's kind of silent on it.
What is the legal authority to support the appointment of an attorney in this circumstance?
In the interest of justice that she needed, there was petitioner's request for discovery. This caveator or unrepresented didn't know how to respond to get that. So in the interest of justice, I made the discretion to utilize my legal services budget to authorize an attorney to assist her with those discovery responses for petitioner. There's no legal authority to the contrary.
Judge, if I may, so in the interest of justice, you appointed an attorney to assist Ms. Mercado with discovery, but it did not dawn on you to appoint an attorney when you're about to hold someone in contempt and put them in jail for 20 days in the interest of justice.
Are you asking me a question?
It did not dawn on you at that time that when you're about to hold someone in contempt, that in the interest of justice, you should use your fund that you had available to you to appoint an attorney to represent that person before you held them in contempt?
As I stated previously, when it was occurring, I believed she was in direct contempt, and I didn't believe that there was attorney or hearing to be necessary. Again, thinking about it in retrospect, I would have handled it different. But as I'm going, I'm learning and I'm growing, and I'm making better choices in the probate court.
Thank you.
Ms. Veal, we need to break for lunch now. I know you're not done with this particular set of questions, but we need to break. So if you don't mind making a mark in your set of questions, we can pick back up. We will, all of us should try to be back. We said an hour and 15. Was that seemed to work for Judge Peterson's team? Was an hour 15 enough for director's team?
Yes.
As well? Okay, so.
No.
Yes.
Need to deal with those emails, that email situation too.
Okay, well, what you can, consistent with also eating. We are clearly going to be reconvening next week, so there's also that gap of time. And we're open. It may well be that Ms. Veal needs to reopen something when she gets those documents, and we'll be open to that concept. So let's aim to be back here at 110 plus 15, 120, 125 to pick up again with the cross-examination of Judge Peterson. Thank you, everyone. I like it.
I don't want to.
Either send them to us.
Okay.
So we can have on.
Do you have a Dropbox that I can copy? That's a thing. I think it might be on this computer, should be.
What is this?
Looks up on and the security portal, you'll be able to exit, but once the door closes. Okay, all right, right.
I'm trying to find it. Probably have to ask him to connect. He put it on my other computer, the PDFs. Where did he put it?
1 minute.
Oh, here it goes. I don't know how to. Let me see if I can, did he put it on his computer? Just leave it up. Stay connected. In the same folder? What happened? I didn't turn off the camera. I'm gonna stay here so I can. Make sure they get all the email. So. Or you think I could leave it? Are you, I can. So if I do, are you able to lock it when you're done? Then it's gonna lock on it. What do you think I need to do? If I lock it, you can lock it? Okay, like that. Okay, thanks.
That I've got. records, right?
Mhm.
Like a document, we asked for like the motion to strike, right? They left off the exhibits.
Actually, they may not have. I don't know, because that was part of this. Oh, well, that may not be on that. I think on something had a birth certificate. That was part of the birth certificate. It was an exhibit instead of something else. And I think that may be what they didn't give you. So I don't doubt that it's the real thing. If you want the exhibits, I can.
Well, so. Yeah, so I guess, so these are already in, but
Mhm.
I just didn't. When I got them, I just assumed it was the entire thing.
Let's
Are
look,
you
let's
fine
look and
with
see
me
what they, let's,
Supplementing.
Yeah.
This, like we get the exhibits and supplement them.
yeah.
Just seems like maybe.
They're gonna care that much, but I don't have a problem. I don't have a problem with that. Yeah, I mean, I guess if she might, you,
You're a great man.
Yeah, it's true.
20 minutes. Good afternoon, everyone. Please be seated. Ms. Womble, you ready? Okay, we're back on the record in the Peterson matter after the lunch break. Judge Peterson is still on the stand, and we were in the midst of a cross-examination concerning the episode involving the Richmond petition for years support. Before we dive back into that, Mr. Tate, any procedural?
I was gonna talk a little bit about schedule and some stipulation, stuff like that, but I didn't mean to cut you off by.
No,
You're very kind to recognize me so quickly when I stand, but I don't mean to interrupt you, just to get in line, if you will.
okay, well, you got in line, and what I was gonna ask next of both sides was there anything we needed to cover before we had Judge Peterson return to the stand?
So a couple of things that Ms. Veal and I talked about a while ago. You had indicated that I would be entitled to, I guess it's direct examination of Judge Peterson after she completed that. But noting the time sort of today and the length of this cross-examination, I still want to do it in their case in chief. But I think Ms. Veal has several witnesses are going to be out of town next week or whatever. Perfectly agreeable for her to take those ahead of time if she wants to, and then I can come back, next week and do whatever examination I want to do on that, if that's agreeable with the panel.
It's 100% agreeable. We had to do that in our last lengthy proceeding where I think we even had to pause a witness's testimony so a couple other witnesses could go for scheduling purposes. And so I'm going to offer up to Ms. Veal in just a moment. It may be that she's not quite done with her examination of Judge Peterson, but wants to make sure these other witnesses go. And so we might have to pause that examination. I say have to. The director may ask to do that, and we are able to connect the segments. And so if Judge Peterson gets a break and isn't on the stand for a while, but witnesses A, B, and C are, we're able to pick up where we left off with Judge Peterson. So I want both sides to have that flexibility, even to the extent, and we've done this before, you might have a witness, Mr. Tate, and you're not waiving a directed verdict motion who needs to testify on the 14th, who couldn't be there on the 15th. And so we take that person out of order. It's really getting as complete a story as we can.
I've been doing this long enough. I know what goes around comes around, and I don't want to mess anybody else's case up because I want to get the same latitude
Sure.
and courtesy, and Ms. Veal has done that for me too.
Okay. Did you have anything else?
Only one other thing that I sort of wanted to mention. It's a stipulation she wanted me to make, but I wanted to make it sort of an explanation. There was last week in getting things ready, some folks at the JQC went out, wanted some certified copies of various documents, some of which have already been admitted, but admitted without exhibits. And I was sort of called in the middle, but what happened was Judge Peterson talked to another probate judge who told her that they couldn't certify the exhibits. I'm not sure I understand that, but that was the instruction she got. Ms. Veal and I talked, and I was like, I'll get whatever you want or stipulate whatever you want. You look at these, and I think it's one of them is the motion to strike the caveator or whatever else. It does not have exhibits. Ms. Veal's told me she's got those exhibits. We don't have any objection to those. If she didn't have them, if you all told us to release it, we would have been happy to, put those there. But I wanted to let you know why we didn't produce them last week and what we talked and worked out. Got no problem whatsoever with stipulating those. She'd asked about, supplementing it like we were doing with other stuff. And I'm certainly agreeable to that as well.
Okay. The only thing you said about that confuses me is you were saying they don't have exhibit numbers, or it's that they're not certified. Like exhibit 21, as I understand, would be the motion that Ms. Richmond's lawyer filed to strike the caveat.
I'm gonna put this up real quick and it'll show you. I'm not talking about exhibits in this trial. I'm talking about exhibits to the brief and whatnot that were filed.
Got it.
So for example, I've thrown one up here. And thankfully, Ms. Veal is assisting me with the technology here. But you'll see if you look down through there, exhibit A, exhibit B, exhibit B, whatever that was.
Got it.
It was not certified with the rest of it. We have no reason to believe that it's not the same. We're happy to stipulate.
Now I understand. So it's attachments, exhibits to exhibits
Exhibits.
that the director has been tendering.
I used exhibits more loosely than I think you interpreted it.
Okay.
So,
Are the attachments necessary for the exhibit to be complete, or, I mean, because if it's not important to the proceedings, I'm not sure we would need those.
It's important to me to have that evidence presented.
fine.
And I have copies. It's two different documents that were certified by her court. And I just assumed the exhibits were attached. I was looking through it earlier and saw that they weren't. I have copies of the exhibits at my office, and I'm fine to just supplement them because I would like it to be part of the record.
Does all of this get sent, Ms. Tatum? Does all of this get sent to the Supreme Court?
I believe so.
But the record that we're making, anything that is admitted,
Even
will,
these attachments they're talking about?
well, if they're admitted, and so, well, two things. One, I think they were intended to be admitted, they were unintentionally omitted. But if an exhibit is admitted and there are attachments, all that will be part of the record that will be transmitted to the Supreme Court. And there may be some things that we transmit to the Supreme Court that aren't necessarily part of the corpus of evidence we agree we're going to consider because, for example, the transcripts, you're making that up. Maybe we won't look at the transcripts, but they ought to be part of the record because there was a debate about them. And so the Supreme Court ought to get that kind of thing.
Right.
But we'll work through what goes up if there's anything in addition to what we consider at the close of all the proceedings.
Yes. Sir. Thank you.
Okay.
Thank
Ms. Veal, procedural things.
What I intend to do, because I have 4 witnesses that are either here or en route that have conflicts for next week. After I finish covering the petition for your support complaint with Judge Peterson, I would like to break to ensure that I get those witnesses up.
Okay. Makes sense. And like I said, we will roll with that. No problem.
Thank you.
Anything else?
No, Your Honor.
All right, Judge Peterson, if you would please return to the stand, you know the routine by now, you remain under oath. And it sounds like Mr. Tate, your direct examination of your client probably won't happen today, but it would follow naturally still after Ms. Veal saying, I have no further questions for Judge Peterson. We're just going to sandwich some witnesses in between that.
Perfectly agreeable.
Okay. So we had wrapped up talking about the legal fund and Judge Peterson's ability to appoint a lawyer when, I'm going to get the words wrong, when the ends of justice require to include Bill Gates. That was my example, but he could get a lawyer because despite it saying the indigent representation fund, it's not needs-based, it's discretionary.
Correct. There is an issue I would like to revisit on exhibit number 22, just to clarify some understanding here. Judge, exhibit number 22, this is the order appointing administrator or the order appointing a guardian ad litem.
Okay.
This signature on exhibit number 22, is that the stamp that you were talking about earlier, or was that your wet signature?
If I can get the file, I can give you a real answer. Just let me get the file. It looks more like the stamp, but I can look at the file to give you a definite.
Bring it up.
Please, if we've got the file here and you don't object.
Make sure I'm hauling the right thing.
Yeah, it's in there.
And just if I could have an opportunity to look at it too, Judge.
Sure, of course. While Mr. Tate is delivering that, did you all sort out, Ms. Veal, the question about emails that Judge Peterson had her IS people produce to her?
Received from Mr. Tate what the Excel spreadsheet. Essentially, it's a timeline and it summarizes email.
Okay, but not the actual emails, okay.
And
Which you don't have either.
no,
Yeah, right.
that's correct.
Yeah.
That's correct. And what Judge Peterson has done, she got those from the IT folks. And she's having them go back and collect them so that we can provide them. There is on that spreadsheet, I'm not representing it's 100% accurate, but there is text for what was in those. And I say that not as a subject, obviously, to the original, but it will give them some idea of
Sure.
what that
Right.
is.
Sounds like it's a good guide.
Yeah, and I apologize for butting in earlier, but I just didn't want us to go round and round about that phone number with that
Nope.
out there.
Appreciate it.
So to respond accurately, it was a signature. It was a wet signature.
Okay, on exhibit number 22. Okay.
So the panel is processing this. So the somewhat lengthy discussion we had before lunch about how things get stamped and there's a stamp and the previous judge had a stamp, all that stuff actually doesn't apply to 22 that appointed someone who was on medical leave to be a guardian ad litem as opposed to an attorney to
Right.
represent not one, but two people who might have interests that are adverse to each other. That order was actually physically signed by you, Judge Peterson, and not stamp signed by one of your clerks.
Right.
Okay.
It was prepared by my clerk and I signed it. That's correct.
Did you read it before you signed it?
I generally don't, they're usually forms, so I generally sign it if I ask to appoint something. Generally, it's a standard form. This is a standard form with the probate council, so I didn't notice that it was a guardian ad litem as opposed to a court-appointed attorney at the time I signed.
Right, I want to now show you exhibit number 25, which is your attorney appointment order.
Yes,
That signature on the attorney appointment order, that's a wet signature, correct?
I didn't pull it, but I would say so. Yes,
Do you have it up there with you?
I can look. Yes. Yeah. Okay, let me see. Yes. It was a wet signature.
Okay,
I'm assuming by wet signature, we mean actually
signed it,
signed
yes.
as opposed to, I'm not familiar with that as a term of art.
Yes, it was a
Now you
sign.
are.
I signed it, yes.
all right, Judge Peterson, and we fleshed out a little bit this whole indigent fund, which I now today understand is not an indigent fund, but that money is pulled just from a legal fund
Legal services, yes,
that you have in your budget.
yes.
Okay. And based on your prior testimony, it sounds like the way that you operate is that you just identify somebody that may need an attorney and you'll give them an attorney to be paid out of that fund, right?
I haven't done it often. There's been certain occasions I've done it, but yes, if there's somebody who's identified that need assistance, in order to push the case along without any delay, yes, I've done it.
Ms. Mercado never made a request of you to appoint an attorney for her, correct?
She indicated to the court that she didn't know what discovery or how to respond to discovery. The case had been sitting. We've been looking for service to effectuate service and to get this year's report possibly signed. So in order to avoid delay, that was the discretion that I made to appoint an attorney to assist her at that time. with her discovery that was requested by the petitioner.
Okay, my question was, Ms. Mercado never made a request of you to appoint an attorney for her.
No, she did not.
And there was never any indigency determination made related to Ms. Mercado.
No, this wasn't an indigent case or indigent consideration.
You, after hearing the petitioner's motion to strike Ms. Mercado's caveat, you ultimately entered an order denying the motion to strike caveat.
I did.
Okay, and you found that Ms. Mercado had filed a timely objection,
Yes,
correct? Within the time that the court extended the time for any objections.
that's right.
You also found in your order that the petitioner was served a copy of the caveat by the court in order to duly respond to the caveat. Therefore, the lack of service to the petitioner does not warrant that the caveat be stricken.
That's what I issued in the order.
You mentioned earlier, the petitioner made a request to conduct some discovery in the case.
Yes,
Okay, and so that occurred, and ultimately, the petitioner, after receiving discovery, filed a motion to recuse you, which was filed on January 10th of 2022.
okay.
Is that correct?
I know that it was, I don't have the exact date, but I know there was one filed.
All right, I'm showing you exhibit number 26, which is the motion to recuse you.
Yes,
And you, in response to this motion to recuse, you issued an order denying it, correct?
yes, it was untimely.
Okay. And then the next day, you issued an order of voluntary recusal.
I
correct?
did.
Judge Peterson, if you know, I clearly don't. What does F1 and what do F1 and F4 say? This lawyer cited to a couple of uniform probate court rules in connection with the recusal.
I don't.
I don't mean it as a quiz.
I don't have it, yeah, I don't have it pulled up, but that's the general section speaking about recusal and I guess the stent procedures that are
Okay.
involved in it.
But it's not like F4 isn't on the grounds that you haven't been moving quickly enough or
No.
you're related to one of the parties. It's just, that's what people would cite to say, hey, we're trying to follow the uniform rules. And so we are citing to them.
Right, it's the same thing. It's you have to file it within 5 days. It's the same as,
Have the affidavit,
Yeah.
all the stuff we deal with.
Right. it's the same.
Okay.
The order of voluntary recusal that you entered the day after you denied the motion to recuse, why did you ultimately decide to voluntarily recuse?
Because I didn't want to be bothered. It was my discretion. If somebody makes all of these allegations stating what they stated, I felt like it was best to remove myself from this case. I spoke with my staff and asked them, there was a lot of allegations made, and I asked them about it and they denied them and said it never happened. So I thought it would be best, even though she didn't meet the qualifications for recusal under the timeliness, I felt like I could voluntarily recuse, and that's the discretion that I made.
Okay, you mentioned that you didn't want to be bothered. Are you aware that the law in the state of Georgia provides that judges have as much of an obligation not to recuse when it's not legally required as they do to recuse when it is?
Your Honor, I'm going to object to that. I don't think that's relevant to any charge that she has. She's not charged with improperly recusing from, from a case. And judges do have a duty to can't recuse from every case, but there are cases like this where the allegations may not be timely raised, but you don't feel like you need to be in it any longer. So.
Okay, what's the relevance on this line to the allegations set forth in the amended charges?
Well, it may not be directly related to one of the amended charges, but what has come out during the course of this proceeding is a kind of general, nobody helps me, I didn't know, my clerk did it. Here is all different explanations for why many things were done. And Judge Peterson has practiced all kind of law. She went to a great law school, graduated top of her class. And so I would like to explore, she said she denied the motion because there was something legally insufficient about it. Then she turned around and voluntarily recused, and I think I should be able to explore whether or not she knows the law in that area.
Okay, in terms of being relevant to the allegations in this part of the formal charges, I'm going to sustain the objection, but that doesn't mean you can't probe more as to why the day after denying there was a voluntary recusal. I don't think we need to get into the depth and scope of her knowledge at the time of recusal obligations and not recusal obligations.
I understand. Judge Peterson, I'm going to now direct your attention to exhibit number 27.
Yes.
After you issued your voluntary order of recusal, you then issued an order where you transferred this entire petition for year support matter to Superior Court, correct?
No. I transferred all the outstanding matters to be decided to the Superior Court. So not the entire file.
Okay, well, I'm looking at the order that was filed on February 10th, and it says, and this is exhibit 27, pursuant to probate court rule 6.10C, the case is hereby transferred. So it says the case, it doesn't identify any specific issues. You transferred the case to Superior Court
Yes.
for hearing or trial.
Yes, and I ordered the clerk to prepare an exemplified copy of the records of this course relating to the petition for year support. That was the remaining outstanding matter to be considered by the court or whatever court it was going to. The Superior Court judge can either transfer it to another probate judge or handle it himself.
Was there something you didn't transfer by way of this order? Like in your mind, I'm keeping all these things here in my office and I'm just giving this piece to the chief judge, or?
Well, in accordance with, before I transfer anything, I consult with every other judges, and I consulted with other judges, and they stated that only outstanding matters that are unresolved shall be transferred because they're not an appellate court. They only can rule on things that's not ruled on. So I transferred the outstanding petition with the outstanding caveat to be considered.
When that got ruled on, was there anything more in this case, or would that close the case? Let me ask a better question. Did this case for you open when the petition for year support was filed?
Yes.
Okay.
Yes.
So ruling on that would actually
Close
close the
it.
case and there's nothing left.
Right.
All right, so you transfer according to your testimony, just to Superior Court, the ruling on the petition for year support.
No, I didn't make the ruling. It was for the Superior Court judge to make the ruling or another judge that he assigned.
I'm clear. I'm sorry. That was a bad question. But I understand that what you intended to send and perhaps this is the explanation for why the entire record was not sent, was just the petition for your support for him to have a hearing on that petition.
And the caveat should have been, so in my rulings, I allowed the caveat. So the caveat should have been submitted and the petition for your support should have been submitted.
But not the whole record.
Mr. Tate?
With a probate case, and this is part of my objection here, because I think the way the question's being asked, it's sort of misleading. With a probate case, even though all the money is in the estate and the year's support, all of the contested things that are going on are going to be ruled on by somebody else. There's still administrative things that have to be returned to get the letters of administration to finally get dismissed, which are not contested at all. And I think these questions are conflating those two. And I think the questions are imprecise because everything that was contested, which is the only thing you would care about on probate, was transferred. So I object to the implication of that question, I suppose.
Okay, I don't know that you can object to an implication. I think we were just trying to get clear, the panel, what gets transferred and what doesn't. It sounds like this case, 21E0047, was all about the petition for years support. And the question that got handed over to a superior court judge or some other probate judge was what to do with the petition for years support because the caveat got filed. So in my simplistic mind, the case got transferred. There may be some technical things that would flow if the petition is granted that might bounce back to Judge Peterson and her staff to execute. But
Get the point of my objection, even if you don't sustain it.
Got it. Well done. Ms. Veal. Oh, actually, your question never got. Remember your question?
My question was, I thought that's what he objected to. So he didn't object to my question, it's yours.
Sure, it was mine. So what's your?
My question, because they have concurrent jurisdiction, my question was, seemed to me, the entire box of the file goes, you don't know to who, but it gets out of your office and goes to the Superior Court and they can do what they want to.
No,
Start over.
no. So the case, when I recuse myself, they are to rule on unresolved matters, all unresolved matters. Whoever goes, it can go to Superior Court judge or he can sign to another probate, but it's all unresolved matters. He doesn't have, it's not in his purview or jurisdiction to appeal or override my orders. So when I was determining what's to be transferred, I consulted with the probate counsel and other judges, and they said all unresolved matters should be transferred. So it would be the petition for year support, any documents concerning any caveats or any appointments, those things would have been sent with the petition file.
Do you agree with what Mr. Hyde stated, which is that the Superior Court has concurrent jurisdiction with the probate court in a petition for your support?
No, some matters we have concurrent jurisdiction over.
But this is one where you have original exclusive jurisdiction, correct?
Yes,
Okay, so then the matter is not transferred to Superior Court,
right.
correct? It remains a probate court.
That's
matter.
right.
Okay, and did you know that at the time that you issued an order transferring the matter to Superior Court?
Yeah, well, I issued an order transferring it to the judge to hear or assign the matter for trial pursuant to the rule. So I didn't transfer it indefinitely. I transferred in accordance with the rule to get ruled on in accordance with the probate rules.
We agree that this matter, regardless of the fact that Judge McLean is a Superior Court judge that ended up hearing it, we agree that it was and always was a probate court.
That's right.
Okay. At the bottom of exhibit number 27, there's a certification by Ms. Fazick where she has indicated that she certified that the copy of the record that was sent was a true and correct copy of the record on file in your office,
Yeah, I see that.
right? But the entire record was not sent,
Right.
okay? And I'm going to show you exhibit number 28. Judge McLean ultimately entered an order directing your office to transmit the entire record to him. Correct?
I would have to see what you're referring to.
Okay. This is exhibit number 28.
Okay, okay.
I'm on page 2. So if you just want to read that to yourself, that paragraph at the bottom of page 2.
To myself, I read it. Okay,
Okay. And I'm now going to direct you to exhibit 29.
okay.
Filed on May 12th of 2022.
In the Superior Court, right? For probate, okay. We didn't get notice until after, but yes, okay. Can you go down for me?
You didn't get notice of what?
He sent this to me, but yeah, when it was filed, I wouldn't have known until it was sent over to the probate.
Okay, well, there's
Okay.
a distribution list here, but
I'm not saying I didn't get notice, because I submitted the record as requested,
okay.
but that wasn't what the authority is. So there's a lot of authorities that he made in his orders that were incorrect.
Judge McLean had to issue an order directing you to submit the complete record to him, correct?
He didn't have to issue anything. He had the case in order to decide the outstanding matters that he had the jurisdiction to decide. The extra stuff they were not to be considered in his ruling for petition for year support.
In your opinion,
By law and by other probate judges that I've consulted with.
but you agree with me that your order transferring matter to Superior Court says that you have transferred the case, the matter to Superior Court, and you've certified, or your clerk certified, that what was sent was a true and correct copy of the record on file in the case.
In my order I issued that concern that I wrote, I said the matters relating to the petition for year support, which was outstanding. Those were the outstanding matters. The motion to recuse was not an outstanding matter. That judge didn't have any authority to make a ruling on it. The motion, any other motions, the motion to strike caveat was not an appealable matter. There was no appeal issued. So he wouldn't have the authority to override my order.
In your opinion,
Why not? I'm not following it's like this game you're playing. Whether you were required to do it or not.
Right.
You've asked another judge to help you out with a case where at first you said, I'm not going to recuse. Now I am going to recuse. And then the judge says, I need this other stuff. And your answer is, why say no?
No, I didn't say no. Once he issued this, I gave him everything requested. But when I'm preparing it, I want to do it right. So I consulted with other judges and asked what is appropriate to transfer once it's a recusal. And that's the answer I got. It's not me being egregious or belligerent. It's me asking for clarification. And that's the information. I did what I was instructed to do by the judges that have been doing this.
Is the law and as a printed unclear? I don't know anything about probate.
It's a lot of things that are not clear.
You seem to be asking people. to help.
Yes, it's not specified that specifically in the code. So we're left to really heavily rely on our listserv and the other probate judges.
But did you come across anything that said it would be error on your part to share more when the judge who's covering this for you says, I'd like more?
I didn't look up, I wasn't searching for law in that. So I wouldn't have come up, no, I wouldn't have come up with that.
I thought you said that's what you consulted the listserv and other colleagues for, is getting guidance on what does the law
Right,
require me to include in the transmittal
right.
to the judge. And you've been very clear that you were told you only have to do this much. My question is, okay, you only have to do this much. Did you come across through the listserv or any other place where someone said, you better not do more than just that much?
No, no one said that. No,
Okay.
no.
Then now I have a question for Ms. Veal. You scroll through these things real quickly, but my read of the two orders was that this isn't the first time Judge McLean said, could I please have the whole record? Did I misread the combination of 28 and 29 such that 29 is not the first time that Judge McLean was saying, could I please have more information? Because what I heard Judge Peterson just say is, this is the first time I knew he wanted it. And so of course I gave it to him. All he had to do was ask. He didn't need to enter this order, but this is the second order, several weeks or a month apart, saying, could you please give me what I think I need to make my ruling? And then Judge Peterson says, hey, he doesn't have the ability to reconsider my denial of the motion to strike the caveat, which isn't the issue. It's
Right.
a judge saying, could I please have more information?
So
Did I misread 28 and 29 combined?
exhibit number 28 is a order scheduling a status hearing. Within that order, McLean identifies that the entire record was not transmitted to him. However, he does not order Judge Peterson at this time via the April 29th order to transmit the record.
He's just noting, gosh, I don't have the whole record.
That's
Okay,
correct.
so I saw that language, but it's not a request, because it would be a request, not an order. It's not a request to a colleague. It's just noting, I don't have the whole record.
That's correct. The request did not come until exhibit number 29 on May 12th.
Okay. And your testimony, Judge Peterson, is that this order was the first time it was brought to your attention that Judge McLean felt like he needed a little bit more
Yes.
information. And I didn't have to issue an order. You could have just called me. And
Yes, he could have.
I'll give you,
He could have.
I'll probably give you whatever. you think.
I would have. He could have called me. He could have sent an email. But yes, he issued that and it came through office mail. So I submitted it after this came through.
Got it. Thank you.
You've mentioned some relationships in the courthouse. How would you describe briefly your relationship with this judge?
I thought we could communicate. I can email him. I emailed and asked a question or two and he's responded. So when this came through, I wasn't sure why he would not, send it. Like we didn't even have to wait to this order. When he did the status, if I was alerted, he could have sent me an email or called me. It wasn't a big deal for me. Judge McLean is the same judge that we started, when I spoke about starting the felony drug court, that was the judge. So we've known each other since about 2015.
Thank you.
Ultimately, Judge McLean on May 31st of 2022 enters an order on the final decision in this debacle, where he has disallowed the caveat and granted Ms. Richmond's petition for your support, correct?
I think so. I believe so. And a lot of his findings were contrary to the established law and precedent.
Judge Peterson, have you ever heard the saying that if everybody else is always the problem, maybe the problem isn't everyone else?
No.
If I could have just a moment, please.
Yep.
I do not have any further questions at this point about the petition for your support complaint. So that's 2021-307. So my request proposal at this time would be to break in Judge Peterson's testimony so we can get some of the other witnesses.
Okay, and my understanding, Mr. Tate, is that you are amenable to that slightly unorthodox flow so that we can get these other witnesses up. The director will have the ability to recall Judge Peterson to cover the remaining areas. You maintain your ability to conduct a direct exam during the director's case in chief, while still having the ability to call your client should you put up a case, provided you don't plow the same ground with the redirect.
Of course, Your Honor. I've
Excellent.
tried to make a whole career out of getting along with other lawyers and judges, so I have no objection to that.
Yes. All right. Judge Peterson, thank you
Thank you.
for all your testimony. We will see you again, I know. While we do this transition, I've been asked to have us take a very short break. We're going to be back in less than 5 minutes, so you may want to get your next witness teed up. But we're going to pause for 4 minutes and 45 seconds. Thank you. You're welcome. You still can't figure that out. It stops. You should just- What's your source? Like, what's the Peace officer. But if I am Officer Jones from I'm Officer Jones from DPD, I get search warrant for that trap house. Yep. Good. Ms. Murphy, nobody's introduced you to anybody.
I'm sorry?
Nobody introduced you to folks when we started.
I mean, she did stand and say my name is.
But we didn't say deputy director and.
She did.
Oh, she did? Well, I wasn't listening. No, sorry.
Because it was early. You were
I missed
still
it.
one of these things.
I was asleep. Probably so.
Are you going to be allowed to take any witnesses?
Yes, Judge.
Excellent.
I know, I feel like at some point I should stand up and say something. So remember-
Just yell.
Yes.
Okay. Only during pauses.
Right.
If it's talking to a witness in the hall, I can let her know you're back, or we can wait.
She has 1 more minute.
Okay.
May need to happen. Can you check on Ms. Veal, please? You may get to do the next witness.
We just ought to be a way to keep them moving.
Yeah. Swambo, you ready? Okay, let's get back on the record in the Peterson matter. Ms. Veal, your next witness is?
Miss Shannon Paul.
You swear people in? Or the trooper was maybe gonna do it. Trooper, you want to swear in the witness? You said you were gonna rehearse. Ms. Paul, you can come, witness stands way up here.
I have some notes that just prepared my own timeline that I was going to bring up if it's allowed, because I need to refresh.
So as long as both sides have a chance to look at what you're looking at, and you aren't reading aloud, but you're saying, you know what, it would help me to answer that question by looking at my notes, then that's A-okay. We just need to make sure, if not right away, before you're done for the day, we make sure a copy is made available to lawyers for both sides.
I think I need to get more comfortable with it off the stand, only because I have my own commentary and notes in this also.
Okay,
I'll just leave it there. Thank you, Judge.
you're welcome. Thanks for asking. Trooper, you've been saved. We're gonna have the deputy do it.
I do.
Could you start by spelling your name for the record, please?
Certainly. First name is Shannon, Shannon. My last name is Pauley, Pawley.
Thank you.
Miss Polly, can you tell us how long have you been a practicing attorney?
I have been practicing and licensed since January 6th of the year 2000. I'm dual state licensed in Michigan as well as Georgia. And I was originally licensed in Michigan.
And that was in the year 2000?
Year 2000, that is correct.
Okay. And when were you licensed to practice in the state of Georgia?
May of 2019.
So between 2000 and 2019, did you live in Michigan and practice law there?
I lived in Michigan. I worked for a national collection law firm where I was the vice president of litigation operations. Prior to that, I was practicing individually in the state of Michigan.
Okay. And when you came to Georgia and were licensed in 2019, can you tell us the nature of work you have done since that time?
Yes, ma'am. I currently own a estate planning and elder law firm that, as part of the estate planning journey, we assist clients with probate also.
I want to direct your attention to February of 2021. Did you file a petition for your support in the probate court of Douglas County on behalf of Diane Richmond?
I did.
Okay. And can you tell us about, I'm sorry, can you walk us through just generally, not every single detail, but when you as an attorney prepare to and then file a petition for your support, what is the work that goes into that?
So we are sitting down, we are trying to ascertain if there is a will to appropriately attach that if there is one. In addition, we're trying to ascertain what the decedent's assets were, any known creditors and any known heirs, so that we can properly complete the standardized court form and file it appropriately with the court.
Ms. Polly, I'm going to show you the dates. Heavy and been admitted. You should be able to see it right up there on the screen.
Yes,
Is that the petition you filed for Ms. Richmond?
that is.
I want to talk to you specifically about page 6 of that exhibit. And the people that you have listed on page 6. Those people are interested parties or heirs.
Correct.
Okay. And I see on page 6 that you've placed addresses for those individuals on this document.
That is correct.
Okay, and I understand that that is your obligation as the lawyer preparing the petition to provide those addresses for the court.
Yes.
Okay. After you file the petition, the next event in the case, as you recall, was what?
After it was filed, then at that point, notice would be sent out to the heirs. In this case, notice was provided by the court, where the court had sent it out by certified mail, making sure that all interested parties were placed on notice to appropriately respond as they deem appropriate once served.
Okay, and I'm showing you exhibit number 16, and again, this has already been admitted. That notice that went out that you referenced is kind of the next thing happening in the case. Did you understand that the date for objections was May 3rd of 2021?
That is correct.
Okay. And to your knowledge, were there any objections submitted to the court prior to that deadline of May 3rd of 2021?
No, there was not.
Right? Will the court ever notify you that that there was issue with service on Ms. McCarter?
No, we were never contacted by the court. I will emphasize that on, I believe that it was March 30th, we were contacted telephonically by Ms. McCardo. And we returned her call on the 31st. And that was handled by my paralegal pursuant to the business notes there too. The conversation was just trying to understand what was received and what she needed to do. And my paralegal responded, as is our standard operating procedure, that we cannot provide legal advice and advise them to seek out their own counsel.
Okay, so just so I'm clear, on March 30th of 2021, Ms. McCardo called your office?
That is correct.
Okay, and when you say there was conversation about, notice and what to do, you mean, who was that expressed by?
Ms. Mercado, when speaking with my paralegal, Ms. Joanne Cabral.
Okay, and Mr. Cabral advised that you all could not give legal advice or assistance.
That is correct. That is our standard business procedure.
And did you understand that Ms. Mercado at that point had received notice of the petition?
That is correct, because that is what she was calling in regards to understand what she received and what she needed to do next.
Did your office receive any additional correspondence from Ms. Mercado?
No,
Okay, and did you receive an objection or a caveat prior to May 3rd?
no,
So after May 3rd came and went, what was your impression as the attorney who had filed the petition for your support?
That there had been no timely response. As such, it would move the standard progression of being before the judge for judicial review and signature.
Is that what happened?
No.
What happened?
Pursuant to the instructions that I was giving to my paralegal, she was contacting the court on a repeated basis during the month of June to try to determine the status of the entry of our order for a year's support. The limited times that contact was made, it was presented that it was in judge's chambers for review and signature. Then other times messages were left to no response.
Yeah, I'm gonna object to hearsay responses here.
Okay. The no response, I'm not so worried about, but
Sure.
this is what, I mean, I think we've got two layers of hearsay because this would be the paralegal relating to Ms. Polly, what the paralegal believes she was told by Judge Peterson's staff.
Sure. And I can direct my questions more specifically. Ms. Polly, were there times that Ms. Cabral contacted the court and there was no answer?
Yes.
Okay.
Your Honor, unless she's on the line with that, that's a clear hearsay response. And we do have an attorney on the witness stand who's familiar, I would assume, with the hearsay rule as well.
Okay, so I'll sustain it. We need to have this witness talk about not what other people told her, but what she did, saw, heard, et cetera.
During June, did you receive an order from the judge on the petition for your support?
No.
Okay. During the month of June, were you notified that a second or a subsequent notice had been sent out to the heirs?
No.
At some point, did you become aware that a second or subsequent notice had been sent?
Our office was, it was brought to the attention of our office. Yes. Once again, I'm referring to my business notes. And that was on July 7th.
What do you mean by office? It was brought to the attention of your office. What does that mean?
Oh, in regards to the business records that we have where we keep notes as an entire office of happenings, it is the business notes that I'm referring to there because I did not have direct conversation.
I was looking more for the name of a person.
Joanne Cabral.
Best evidence would be those records.
Okay, well, maybe we'll get there. And if we don't, we need to stay away from hearsay. But if there were pleadings or anything that notices that the office was receiving, we can use those exhibits.
I'm showing you exhibit number 19, a notice of petition to file for your support with an objection deadline of July 10th of 2021. Did you ever receive a copy of this notice?
A copy, yes. Through standard means, no.
Okay. Did the probate court provide you with a copy of this notice?
Yes, upon request.
Okay. And who made that request?
Joanne Cabral.
Okay.
When you say standard means, was something non-standard happening here that when you handle these years support requests typically happens and it wasn't happening here?
Normally we would be receiving copies as an interested party of any pleadings and notices such as this, and our office had never received it.
And when you say normally with Douglas County probate or probate courts around Georgia?
In my general experience across Georgia with these type of motions.
That when something's filed in a case where you represent the petitioner, you're going to get a copy of that.
Yes, as an interested party.
Why would it be important as an interested party to get a copy of this notice?
So that we can truly understand, A, if there's been any timely response made. And really, that's the big focus here, is to confirm that there was a timely response made after service.
Okay. At the time that your office became aware that a second notice had been sent out, had you received any objections or caveats?
No,
What did you do as the attorney when you realized that a second notice had been sent out in the case?
we proceeded to reach out to confirm if a timely caveat had been filed under this new objection date.
Okay, and had a caveat been served on you prior to July 10th of 2021?
No,
Was an objection or a caveat ever served on you?
no,
Was that atypical from your experience either in Douglas County or throughout doing this kind of work in Georgia, that you didn't get a copy of a caveat that was entered in a case where you represent the petitioner?
yes, that is not standard.
You objecting to my question?
Well, I've heard lawyers say, if you ask it on my behalf, I withdraw it. If you ask it on my behalf of my opponent, I object to it. I would just like a clarification where she's talking about cases where a lawyer is filing it versus a pro se. That seems irrelevant.
Filing the caveat.
Yes, yes.
Okay, no, that's a great point. So this is not an area of law which I'm in any way familiar. Ms. Polly, when you are in your typical your support litigation and you're representing the petitioner, when you say you're getting copies of notices or a caveat if one is filed, is that coming to you from opposing counsel, or is it coming to you from the probate court of County X?
If there is counsel involved, is coming from opposing counsel serving me as an interested party. If it is a pro se situation where the pro se may not know the specific court rules for service, what has standardly happened as a courtesy is that the court, if they're not seeing any type of proof of service of notice upon myself, they'll provide copy of whatever was properly filed with the court.
And that did not happen in this instance.
That did not happen.
You eventually obtained a copy of what Judge Peterson considered to be an objection in the case.
Correct.
And I'm showing you exhibit number 20. And I'm on the second page of exhibit number 20. What is that document?
That is what was presented to us by the court as Ms. Mikado's caveat, which does show a date stamp of the court of July 14th, 2021. That date stamp is 4 days after the expiration to file an objection.
Okay. And Ms. Cabral's going to testify, and this exhibit is already in evidence, but I'm going to ask you, I recognize that you're not on this email thread, but are you familiar with the email that I'm showing in exhibit 20 from Madison Beasley to Joanne Cabral?
I am familiar with it.
Okay. And can you tell us what this email is?
This is a copy of what was presented and accepted by the court as the caveat.
Okay. Did this email come to your office based on a request from your office to the probate court?
A
I'm gonna
request.
object unless she's the one that made the request. I've got a great staff. I depend on them. I know lawyers do, but I can't testify about what they know.
Right, and it sounds like we're gonna hear from Ms. Cabral, so if you don't know, Ms. Veal, you should ask specifically, did you get involved with this? If you know this is in Cabral territory, let's save those questions for her.
Did you have any involvement in Ms. Cabral reaching out to the court to get a copy of this?
I instructed her to get us a copy of whatever was accepted by the court as the caveat for our records.
Okay. And just to be clear, the court on its own did not provide you all with a copy of this objection.
No.
after receiving this screenshot of the objection that was filed in by the court on July 14th, what did you do as the attorney next?
At that point, I was trying to confirm if it was truly being accepted as a timely caveat. Once when it was confirmed as such, shortly thereafter, it was scheduled for a trial/hearing. And I prepared a motion to strike.
And why did you prepare the motion to strike?
I founded it on basically 3 reasons. Number 1, it was not timely, not only because it was confirmed via the court's own records with their certified receipt that when you went to USPS, it confirmed the date of service back in March. Secondly, because of the date being date stamped 4 days after the deadline. And lastly, that it was not served and filed properly with the court. As this was, as acknowledged by the court at, I believe it was that first hearing, that this was received by email. It was never mailed nor received. Ms. Mercado did reference that she had mailed it, but had no records to support same. And upon last conversation on this topic with the court, I was unaware it had ever been received.
Okay, all right, so you filed a motion to strike the caveat. Does filing that on August 4th of 21 sound about right?
Yes, ma'am.
Okay, and then the court scheduled a hearing where you had a hearing on your motion.
Correct.
Okay. Was that hearing virtual?
Yes.
Who do you recall being present for that hearing?
Of course, the court, myself, I did have Joanne Cabral from my office also attend, and the cavator, Ms. Mercado.
Okay, was Mr. Richmond in attendance?
No.
Okay. During that hearing, was there inquiry made by the court to Ms. Mercado regarding whether Mr. Richmond had gotten notice of the
Yes, there
petition?
was.
Okay, and what was that inquiry? Can you describe it for us?
The court asked Ms. Mercado if Mr. Richmond had received notice. She expressed she did not know. And at the court's request, she did contact Mr. Richmond. And when she came back after her,
Let me stop you there.
go
You
ahead.
said at the court's request.
during the oral argument of this hearing,
Okay, but what request did the court make in particular?
the request was made to Ms. Mercado to confirm if Mr. Richmond had received a notice.
Okay, and when you say the court, is
The
that
judge.
Peterson?
Judge Peterson.
Okay, what did Ms. Mercado do in response to the request from the court?
She stepped away to do a phone call to Mr. Richmond.
Okay, and without going into what Ms. Mercado said when she returned, was there ever a determination made about whether Mr. Richmond received notice?
Ms. Mercado summarized her conversation with Mr. Richmond, and in that summary, acknowledged that he stated it had been served and he was opening it as she spoke to him.
Did Mr. Richmond ever file an objection or a caveat?
No.
Were there any further dealings with the heir, Mr. Richmond, after that hearing?
Yes.
Okay. Can you tell us about the next time there was a dealing involving Mr. Richmond?
There was a point at a subsequent motion where The court was ready to proceed and I asked for discovery based upon the defenses being raised by Ms. Mercado. And when the court granted my discovery for 60 days, the court at that point appointed a guardian ad litem for both heirs.
One person for both, or each got his or her own guardian ad litem?
One for both. I believe his name is Joe Gable.
Based on your experience in this area of the law, was that normal or abnormal?
That was abnormal. The court did interchange the term guardian ad litem, then appointed attorney. Ultimately, the court, as they speak through their orders, the court's order did say guardian ad litem. And what it was so odd about this to me was, number one, neither of these were protected individuals.
And why is that significant?
Because normally a guardian ad litem is appointed to protect the interest of an heir that cannot basically properly present their own defense, very often due to a deficiency, a mental deficiency, very often,
Okay.
or by age.
Okay. And was there anything else about the order appointing the guardian ad litem that was abnormal to you?
It was also odd that it had given notice. I may be getting my orders mixed up. I apologize.
And I'll show you, I can pull up,
While she's pulling that up, is it typical to have one guardian ad litem for two people who may not have aligned interests? Or would there typically be guardian ad litem A for me and guardian ad litem B for you? Or there's no typical?
There's no true typical. I would say I see it more often that an independent is assigned to both for the risk of any perceived prejudice in the joint representation, but I have seen it done both ways.
have you seen a guardian ad litem appointed for a potential heir that has not filed any objection or has not been involved in the proceeding?
No,
Okay, so did that strike you as odd?
that was extremely odd. Yes.
What did you do once you realized that the court had appointed a guardian ad litem to both of the potential heirs?
I instructed Ms. Cabral to reach out to the court to confirm if this was an intentional portion of the order or if this was a clerical error. And Ms. Cabral can testify as to her conversations.
Have you ever served discovery on a guardian ad litem?
I did.
Okay, is that normal or abnormal?
It is abnormal because normally discovery is handled by counsel or party. But because I had asked for discovery and because Ms. Mercado was now being represented by an attorney, I felt it was improper for me to send discovery directly to her. And as such, I sent it through the guardian ad litem.
Okay, and that would have been Mr. Gable?
That is correct.
Did Mr. Gable ever respond to your discovery requests?
He did not. My first contact to him was trying to get a status for the return of my request to admit.
Are you aware of Mr. Gable at some point during all this having some kind of medical leave in place?
When I spoke with him, the conversation I had with him, he had emphasized, A, he thought that the discovery was provided to him as a courtesy, and he was unaware he was supposed to respond. B, asked if I would grant him an extension. I stated I could not in the good conscience of my client. And then lastly, he had referenced that he was going to orally petition the court to be granted an extension due to a medical leave that he was about ready to take.
was the discovery issue with guardian ad litem Gable eventually addressed during a hearing?
It was. Mr. Gable orally petitioned the court. At that point, the court acknowledged their error on the order, referencing that it was an appointment of a guardian ad litem. And also acknowledged the error of including Mr. Richmond. And thereafter appointed an attorney. I apologize. I do not know if the first name or last name is Angel. But appointed Angel to now serve as the court-appointed attorney, and that was being funded from the poverty fund.
What fund?
The poverty fund for individuals.
I thought you said pottery.
Oh,
That's a different fund.
Ms. Polly, I'm showing you. Sorry. While I'm finding that order appointing attorney, how did you become aware that the attorney you referenced as Angel, how did you become aware that she had been appointed in the case?
25.
ultimately through an order, if my memory serves me correct. And that was an order that,
On your screen.
yes, thank you.
Did your office have to request a copy of this order?
I do not recall independently on this one.
Okay. Well, the order was signed and filed in October 22nd of 21. At some point after October 22nd of 21, did you serve the discovery on the attorney that had been appointed, Ms. White?
I did.
Okay. And you said poverty fund earlier, and I know that it's been a while. The fund identified in the order was actually the indigent fund.
Thank you. I stand corrected. Indigent fund.
Okay. And to your knowledge, there was no indigency determination that was ever made?
No, nor was I ever served a petition for the appointment of counsel.
Okay.
And I do emphasize that Ms. Mercado is a New York State resident.
Right. Was the appointment of this attorney from the indigent fund a piece of what you explored with your discovery?
Yes, I did ask. I did specifically ask if the appointment had been specifically requested, and if so, produce any documents to support the indigency.
Okay. The purpose of asking the court to allow you time to serve discovery in this circumstance was what?
So that we could continue to flush out issues and the defense being raised by Ms. Mercado.
So-
Though,
Sorry.
though the caveat was not very specific, only referenced that it would be excessive, I was trying to flush out that term excessive, as well as other facts and issues that I felt I needed to diligently pursue to the advocacy of my client.
We can't read the objection because it's a photocopy of an email of whatnot. I don't know if you were ever able to read it. It sounds like you were because of you quoting the word excessive. In essence, what was Ms. Mercado saying no for? Don't want her to get the money because.
For her to receive it would be excessive. I also had difficulty reading. And the only reason I remember specifically excessive, because when I asked the judge to strike for failure to state a claim, the judge stated specifically from the bench that she believes that she did have a claim because she referenced that the petition was excessive.
And when you file a petition for your support, you are asking for a specific dollar amount on behalf of your client to come out of the estate.
Yes, in this case, we were referencing the home here for the purposes of not only her contribution she had done towards the home, but also as that was her home.
But there was something in the petition to which someone could react. That seems excessive.
Yes.
Okay.
We would have listed the assets, which would have included the home.
Did you have a court reporter at that hearing?
No, I did not.
Why is that?
I did not, I did not strategically decide to take one at that time.
Did you plan that you were going to have to prepare and serve discovery in this case?
Initially, no.
Right? Is that having to go through the discovery process in a year's support matter for you? Based on your experience, is that normal or abnormal?
It's more abnormal. Actually, this is the only time I've ever had to do discovery on your support.
When Miss Richmond originally retained you, did you build into what she paid at that time? Having to prepare discovery requests?
Before you answer that, Mr. Tate?
The matter of fees is always, attorney's fees is always interesting to other folks, but I don't see any relevance as to what her fee arrangement was with her client, whether it was favorable or unfavorable to her as it pertains to Judge Peterson.
Right. So what's the relevance? I understand there are consequences to how this played out for Ms. Richmond to include a year's wait to get a year's support. But what's the relevance?
So I think it is also important to note that there was impact to the attorney involved. And when we are dealing in a space where we have alleged violations of Rule 1.2 and I think hearing from the parties impacted is important. I mean, what was the harm, if any? I think that is relevant to considerations regarding that.
So let's do this. We don't need to get into specific dollar amounts, but if you want to explore whether the overall profitability of this representation was affected by some of the ways this played out at a high level, you can do that, and then let's move on.
Okay. Did you build in on the front end when Ms. Richmond initially paid you? Did you build in having to, and I'll just go ahead and encompass everything, prepare and serve discovery, go through the discovery responses, file a motion to recuse, and any of the other matters that you had to address and file after the time of the second objection?
No, the amount that she paid me for was for a basic year's support. Once when this started to proceed, I did not feel in good conscience I could step away as her counsel. So I proceeded with no additional fees taken from Ms. Mercado, Ms. Richmond.
And you are a sole practitioner?
I am, yes. Correction, I'm sorry. I do have an associate attorney that works with me, but it is myself, my associate attorney, then my team of paralegals in front office.
In your experience, approximately how long do petitions for your support, where there are no objections filed, normally take to resolve?
You're looking at usually between 4 and 5 months. It's usually very prompt.
Okay. What about when there are objections filed?
If there are objections, those are usually flushed out in one hearing. So it may add, if the objections are denied, then it may add an additional 6 weeks approximately to allow the time for the hearing.
Okay. And then what about if the objection is granted?
Then
Your
at that,
Honor, I mean, I think what she's asking about is the vagaries of litigation. This is not a non-adversarial proceeding. That's why you have service about that. So the fact that various people may contest it, may raise issues that require litigating, may require an appeal, whatever else is wholly irrelevant to breach of the judicial canons.
I'll ask
Okay.
my next question.
We'll move on, or you'll ask your next. I think it is relevant to hear from this regular practitioner in this specialized area of the law, how long a typical year support lasts. And I think the way you were asking it actually addresses Mr. Tate's concern. Garden variety, no issues, 4 to 5 months. This wasn't garden variety, no issues. There were objections. Were they timely filed and whatnot? Work through all that, but you were asking, it would take longer if there are objections. So if you want to explore that a little bit more, you can.
Okay, so you said that when an objection is not allowed or it is denied, and you have to go through a hearing on it, that may add 6 weeks. So,
Approximately.
okay, and if an objection is allowed, what time would that generally add?
It will vary based upon the foundation for the allowance of the objection.
Well, let me ask you, have you ever had a petition for years support that lasted for 15 months?
No,
I'd object and move to strike. She's already, or ever having a petition for year support that may or may not be like this particular case.
So you, I think very soon are going to have your first opportunity to examine a witness, and you're free to explore that
Okay.
with Ms. Polly.
I want to ask you about, just briefly, the motion to recuse Judge Peterson that you filed.
yes,
I'm showing you exhibit number 26.
yes.
The event that you identified as triggering your time obligation pursuant to the rules related to recusal and when you have to file them, what was that event?
It would be the entry of an order.
Okay, which order?
It would have been I believe it was the final order. I do apologize.
Here, would it assist you instead of me scrolling? Would you like to look at your motion for recuse?
If I may, thank you.
Are you talking about the motion or the intro, something called the brief in support of? Was the motion? Okay, that. Is this the document you're,
I'm reviewing the brief at this time.
all right?
Was it filed along with the motion?
It was. They were filed jointly.
And your affidavit?
Yes. So we were notified, as stated in paragraph 24 of the brief, on January 4th of 2022, that a formal investigation was going to be initiated based upon my client's complaint with the JQC. And at that point, I felt we needed to recuse Judge Peterson based upon the JQC investigation.
So is it your opinion that if a judge has a JQC complaint filed against them, and the party that files it is also a party in litigation for the judge, that the judge is off the case?
I'm of the opinion that that is best practices, yes.
What's the authority for
I have no authority in front of me. It's just the perceived prejudice, and I never want to put an opposing counsel, a defendant, my client, or a judge in a position that could be perceived as prejudicial.
Could you see though that that could be abused rather easily?
I can see that could be abused easily.
And in your brief, you put that you filed a JQC complaint. Why did you put it in your public brief?
I did not file the JQC complaint.
Uh,
My client did.
Okay, well, if you want to quibble about that, but what I'm saying is, in the third paragraph of the introduction, you say, well, you say it in the second paragraph and the third, that you filed a complaint, of the petitioner filed a complaint to the Judicial Qualifications Committee.
Yes,
Why did you feel the need to put that in a public file when it's supposed to be confidential?
I was using that as my foundation for recusal
Of which you have no authority.
at this time, yes.
Okay, thank you.
Ms. Polly, indicated that Ms. Richmond actually filed the JQC complaint.
Yes,
Was that complaint actually filed several months prior to your motion to recuse?
I don't know the exact timing of when it was filed.
It was not in January 4th of 2022, correct?
Yes, my understanding that it had approved before investigation at that point.
Okay, your understanding regarding being moved to formal investigation, was part of that understanding, part of what was built into that understanding, the fact that Judge Peterson was being notified that your client had filed a complaint.
I don't object to her leading the witness.
I don't think that calls for a particular answer.
Well, the question was part of your decision.
I heard what the question was. But why don't you ask it again?
Your understanding, you've used the words formal investigation, right? Can you tell me what your understanding of a formal investigation was at the time that you filed this motion to recuse?
That at that point, the JQC had found merit in the foundational claims made by my client in their original complaint and was prepared to investigate further to confirm the validity of the allegations in the complaint.
What about to prove that it's not true?
Or to prove that it's not true.
Gotcha.
And did you understand at the time that you filed this motion to recuse that Judge Peterson would be notified of the JQC complaint that had been filed?
Yes,
Okay. And did that fact inform your concern that led to the filing of this motion to recuse?
yes, based upon the prior actions that I felt is abnormal by the court, that I felt were directly prejudicial to my client in my professional perception. I felt that now there's an even, in my perception, a bigger target upon my client's back at that point.
If I told you that Ms. Richmond's complaint was filed with the JQC on August 11th of 2021, do you have any reason to dispute that's the date that she filed it with us?
I have no reason to dispute.
And what I want to be clear about, following up on Mr. Hyde's question, in your filing this motion, as a practicing attorney, getting to the point that you're filing a motion to recuse, was your concern just about the notification of the JQC complaint, or did you have more concerns?
I have been practicing, like I stated, and licensed since January 6th of the year 2000. I have never filed a motion to recuse. It has always been my goal to show deference to the court and allow the court to proceed accordingly to, even if at a later time, correct anything that may have been improper under law. I felt at this time that I had to step up for my client to have her matter heard before a different judge, to allow her to have the facts examined and then appropriately adjudicated upon.
You said you've been practicing since year 2000, and this is the first motion to recuse that you would ever file.
Correct.
The matter ultimately is heard by Superior Court Judge McLean.
Yes.
What did you have to do to prepare for the hearings in front of Judge McLean?
At that point, we were ensuring that the court received the full probate court's file. And then at that point, when it was scheduled for hearing, we represented a motion to strike and for the court to make their determination upon the facts being presented at that time.
Okay, so once you got in front of Judge McLean, you made the decision to either file or make an oral request of the court that the decision regarding the objection be reconsidered.
Yes,
Okay, and was he willing to entertain that motion by you?
he was.
Okay, and what happened as a result of that motion?
The judge proceeded to ask questions directly to the cavator, Ms. Mercado, wherein she acknowledged on the court record that she had been served back in March of 2021, that she had contacted our office and she had,
I'm gonna object to her. I think there's a record of this verbatim transcripts in Superior Court. And so for her to relate what others said in that hearing, I think is improper.
Okay.
What was the judge's decision on your renewed motion to strike the caveat?
the caveat was stricken as untimely.
And the matter was finally concluded on May 31st of 2022.
Correct.
That's all I have. Thank you.
Thank you.
Mr. Tate, do you have more questions for Ms. Polly?
Good afternoon, Ms. Polly.
Good afternoon.
I'm Lester Tate. I practice law up in Cartersville, Georgia. And I've just got a few questions for you.
It's a pleasure to meet you.
Pleasure to meet you too. I'm not a probate lawyer. I'm a trial lawyer and do have a little familiarity with the year's support. And would it be fair to say that what a year's support is doing is to try to set aside money for usually a surviving spouse or children that's outside the estate, and it puts it outside of the reach of other heirs and other creditors?
Yes,
Okay. And so for Bill Gates, we've had some mention of Bill Gates. For Bill Gates, a year's support might be a small percentage of what his entire fortune is. But for others with less substantial fortunes, you might be able to set aside the whole estate. Is that correct?
That is correct.
And that is set up to be a contestable proceeding, true?
True.
And it's frequently used to try to allow people to keep houses, cars, things like that, and to keep it away from creditors, true?
One of the focuses is to be able to preserve the home.
Yes.
As you state, that is correct.
Yes. And in this case, you had a stepmother and what was it, one or two stepchildren?
She has a daughter that I'm aware of. I'm unaware if she has other children naturally of her own.
Okay, I'm talking about I'm talking about Miss Mercado and Mr. Richard.
Oh, I apologize. Those were the
Maybe I didn't
biological
word
children
that
of her
very well.
spouse.
Yeah.
They were the biological children of her spouse that
So-
deceased.
Neither were her biological children, correct?
Correct.
And would you agree with me, there's more likely to be a fight about that where it's not their mother, but a stepmother, or not their father, but a stepfather?
That, in my experience, that is a standard participant in that files a caveat. It is very often in a blended family situation.
Okay, and in this, you were trying to set aside a house amongst other things, correct?
That is correct.
And so the term, and I wrote this down, you know, the term that was used in the caveat was that it was excessive, the belief that it was excessive. That is in fact an actual ground to caveat a year's support, correct?
If specifically referenced, yes.
Okay, and the idea is it's enough money, property, whatever else to support that petitioner for a year and in the style to which they have been accustomed, and they would be in the interest of the petitioner to make that as large as possible, correct?
It is in the interest of the petitioner to maintain their quality of life. That is correct.
Well, it would be to their financial advantage if their pure goal was to get as much as they could, to claim as much of that as they could, as this is what's going to take me for a year, correct?
Yes, you want to be it's better to go a little higher than significantly lower for the detriment
Okay.
of
Now,
here.
I'm sorry. If I cut you off, just stick your hand up. I don't want to do that.
Yes, sir.
Now, I want to ask you a series of questions about something here, and I want to make sure that you know up front, you will never hear me criticize a lawyer for doing every single thing they can for their client. But it's fair to say, if you're representing the petitioner and you file this petition and then the time runs, and if you can go in there right after that and say, there's no caveat here, that's an easy case to win, correct?
I think that's an appropriate case under the court rules.
Okay, well, I didn't say it was an inappropriate case, but I'm saying it's a very easy case for somebody to win, correct?
As someone being an advocate for their client, that is what you would do.
And that's what you did in this
Yes, sir.
situation. And so you wouldn't like it very much if you're the advocate, if I'm the advocate, if the judge gives them more time, correct?
The focus is to make sure that proper notice is provided and that the objection or caveat is filed timely after notice.
Wasn't exactly what my question was.
I apologize. Please restate.
Yeah, my question for you is, you wouldn't, if you've got a deadline and it's coming up and you know after September 30th, I'll say hypothetically, I win if nothing's been there, you would not be particularly happy if the judge came in and said, we're going to give them till October 30th. We're going to give them more time to respond, correct?
I don't think anyone would be happy if they feel that they have proceeded forward appropriately and now additional graces are provided to another side unfounded in your perception.
I totally understand that. I totally understand that. And I said, and I mean it, I'm not criticizing you for feeling that way. You're generally familiar with the probate code.
Generally, yes, sir.
And do you agree that that probate code allows it allows judges to expand the time for which caveats and other things can be filed?
There is discretion to the judge. That is correct.
Okay. And I had that statute here a minute ago. I think I've still got it here. I don't think we disagree. I'm gonna read it to you instead of trying to go super high tech here, but would you agree OCGA 5311(5) says on the motion of any party in interest or on its own motion, the probate court may direct any additional service of citation. That would be additional service in addition to what you've done already, what the probate court's done already, correct?
Yes,
Or notice, or extend the time to respond with respect to any proceedings covered by this chapter as the judge may determine to be proper in the interest of due process and reasonable opportunity for any party or interest to be heard. You agree that's the law?
what you are stating, as you're reading verbatim, there's nothing for me to state in regards to it. You're reading the statutory.
And you agree as an experienced probate practitioner that that's the law, correct?
Yes.
And it says this applies to proceedings that may be brought under this chapter. It's the probate chapter, and you agree that petitions for your support fall under that chapter, correct?
Yes,
And so Judge Peterson had every right under that statute to extend that time if she wanted to, correct?
under the statute. Yes,
Okay. And she's a judge. She's sworn to uphold the law, right?
true.
And that's the law,
Well, the law isn't you must, it's you may.
right?
Okay.
Right.
So she'd be upholding the law by not.
I'll rephrase my question. She wasn't violating the law, and that's the point I seek to make. Your point is well taken. And you indicated that when she appointed a lawyer, you said, and I want to emphasize this was a New York resident.
Yes,
You did say that, correct?
I did.
You were not, I assume, implying that because they were a New York resident, they weren't entitled to equal consideration under the laws of the state of Georgia.
No. However, they're still held liable and accountable to the laws of Georgia.
I understand that. And there's nothing in the probate code, any place that prevents her from appointing a lawyer to assist if she has the funds to do that, correct?
Nothing that I have seen to state yes or no there.
I want to ask you one other thing. At this point, when she did appoint a lawyer to try to assist, that assistance she specified was to help answer discovery, correct? Or to assist with the discovery.
I do not recall her specifically saying to assist in discovery, but to provide legal guidance to Ms. Mercado.
Okay. And you had asked for discovery, though. It was at the same time that you asked for this 60 days for discovery, correct?
The initial, yes, we were told it would not be extended. And then when Joe Gable was allowed to withdraw and the new attorney was appointed, then at that point, I did request to restart the 60 days to allow timeliness to file discovery and give them opportunity to respond.
Well, I know you did not agree with the fact that she allowed the caveat to be filed, and you relitigated that later in the Superior Court. But you requested discovery and she did grant that, correct? And at that point, you and your client were anxious to try to move the thing along, correct?
Correct.
So it is not beyond the realm of possibility that she appointed this lawyer in order to try to keep things moving along, true?
I don't know what a judge is thinking, so I can't answer that.
Okay. Well, that certainly would not be inconsistent with trying to move things along, would it? Now, you have indicated that your client filed this JQC complaint. Were you aware that the JQC complaint had been filed?
The question was asked to us and we directed to the JQC website. Beyond that, I was not aware when she filed, what she stated, etc.
Okay. And at what point did you direct her to the JQC website?
When she had raised concerns about what was being perceived as prejudicial acts against her by the judge to the benefit of Ms. Mercado.
Okay.
What's an example of, if she articulated what that was, what Ms. Richmond would have said, this seems like this is a prejudicial act that benefits Ms. Mercado.
Oh, the fact that she was timely served on the first petition and the additional bites at the apple, basically, in order to present and file a defense.
I would have asked that. I was afraid I'd get an attorney-client privilege objection, but I guess that's okay. Your client, Ms. Richards, she didn't know what the probate procedure was. So if there was an extension of time, this is all you relating that back to her, correct?
As an advocate, when you're dealing with people that are not familiar with the court system and the proceedings, you have to explain to them what is occurring and what to expect as things are occurring along the way.
And I suspect most lawyers, and I suspect at least Judge McBurney and Judge Lopez are familiar with this, when it's not going as quick or the way you want, sometimes you blame the judge for that with your client. You would agree with that? Sometimes it's the judge's fault and not your fault as the lawyer.
I'm not sure what you're asking.
Did you believe that it was being delayed by Judge Peterson in this case?
I believe that bad decisions were being made by the bench, yes.
And did you express that to your client?
Yes, as we were explaining the next steps we were having to step through.
And did you explain that to your client before your client filed the complaint with the JQC?
I cannot independently recall.
Okay. In this case, the year's support would have been 100% of the estate, correct?
Correct.
So there would have been nothing left in the estate for either Ms. Mercado or Mr. Richmond Jr., correct?
Correct.
And are you aware, sitting here today, that the green card for out-of-state service, the certified mail card, came back for Ms. Mercado, was not signed by Ms. Mercado?
Conversations were had by Ms. Joanne Cabral, specifically concerning the certified mail receipt. As I did not have the direct communications with the court based upon hearsay, I can't state anything here.
Yeah, would you agree that if they're serviced by registered mail, the actual party in interest has to be one that signs the return?
That is the standard expectation, yes.
Okay,
Let me follow up on that. Standard expectation is different from, that's what the law requires. If my roommate is the party in interest, and I'm the one who signs the little certified mail card and sends it back to the court, does that mean that service was insufficiently perfected or not perfected? Because a competent adult, let's pretend I am, signed it, I just wasn't the actual recipient.
I would not view that as proper service.
Okay, so it's not just the standard, but the law is, it needs to be signed by the party in interest. If it's an out-of-state certified mail delivery as the basis for service.
Yes, it should be certified restricted.
Okay.
if you'll look on the computer screen there, I've laid the green card up there. You see the name Miss Wakita Mercado,
I do.
and you see the received, who received that and who printed their name underneath.
I see.
And what is that name?
JOSE Mercado.
This would not be proper service, correct?
As I don't know who Josie or Jose or Jose, I'm not sure how that would be pronounced, Mercado is. It is not matching Wakita. You are correct there.
Well, regardless if you know who Josie Mercado is, you know it's not Wakita Mercado, correct?
Yes, and I see that they checked off signing as their agent.
And what's the date of that?
3/29/21, the day that we were contacted
Okay.
by Ms. Mercado.
And do you know, and you may not know, I'm not asking for a hearsay response, do you know whether or not someone in your office left a message for her?
Who is the her you speak of?
Ms. Mercado?
That can be testified as to Ms. Joanne Cabral.
Okay.
Is the fix for a situation like we just encountered here, where it sounds like you learned that Ms. Mercado has in fact received what was sent, but then her husband, Jose, signed for it, to try to seek an acknowledgement from Ms. Mercado? Or do you have to go back to square one and get a new notice sent with a new card saying, I need you to sign for it, your husband can't sign for it?
How I have seen it historically is gone one of two different ways, because the whole focus for service is to put a person on notice. And she was obviously placed on notice when this was received, because she made the affirmative act of reaching out to our office. And therefore, even by her own acknowledgements, this, under the guise of being placed on notice, she was clearly placed on notice, is the underlying focus of service.
So you'd have Ms. Cabral prepare an affidavit. How do you just shore up what you're saying if you're trying to preserve or prove up that as of the 29th of March, Ms. Mercado had notice?
This is my first time seeing that green card. We were told, and Ms. Cabral will be able to testify, that it was never returned, is what was presented to us.
Well, I don't want to quibble over semantics with you, but it
Yes.
was never, a proper service card was never returned, correct?
Based upon what you're showing here, it appears so.
Is that, so are you saying this is news to you that Jose Mercado signed for it instead of Wakita Mercado?
100%.
And I guess I'm kind of puzzled by that, because there was all this thing, we want to have the file, we want to get an order, we want to have the whole file up here. And I would just assume a lawyer would have gone through the file and looked at the card and seen that, you know, the restricted service wasn't on there.
I don't understand your question.
Well, when you went it up to Superior Court, you you asked for an order, getting the whole file sent up, correct?
That was part of the recusal when it was moved up to the other judge to handle.
Yeah, but you said today was the first time you ever saw that the wrong person had signed the return of service.
Oh, that's correct.
I'm just curious as to why you never saw it before since you had the whole file.
I never had possession of the court's file.
Did you ever go over and look at it?
No, I never did.
How did you all know? You testified, I believe, that on March 30th, that your office reached out to Ms. Mercado, correct? And how did you know to reach out to Ms. Mercado?
Because she had called and left a message.
And that message could have well been, just as Judge McBurney hypothesized, that it was some partner, it wasn't the right person. Wasn't the person in interest, but it was some other adult at her residence, correct?
I don't understand what you're asking. I apologize.
She could have come home and her husband, boyfriend, companion, partner, other person, look what came in the mail today. Your name would have been on that. She could have called your paralegal on March the 30th after March the 29th, correct?
Whatever the facts may be, there was a phone call that was made.
Okay. And did your office, did you as the lawyer ever prepare an acknowledgement of service for her to sign, or ask her to sign an acknowledgement of service?
No,
Did you ever instruct anyone in your office to see if she would sign an acknowledgement of service?
no.
And if she had signed an acknowledgement of service, it would have short-circuited a lot of the time that later came, true?
I emphasize that we were unaware of the certified mail, the number to do the verification off of USPS until I believe it was January 7th, when we kept following up to figure out what was happening. Prior to that, we were unaware of how she was served prior to that. That is when we had asked the question in regards to service. We were told that it was sent out by certified mail. And that's when we had asked for a copy of the certified mail receipt. And that's where we were able to confirm the delivery off of the USPS website, not necessarily seeing the signature on the green card.
So you were under the impression that it had been properly and sufficiently served because it went to the correct address, and Ms. Mercado called your office.
Yes.
So why would you get an acknowledgement?
I wouldn't have thought of any need to do so. It all seemed to do a logical flow.
Okay, and so I'm assuming, question Judge McBurney just asked you, that's what you think happened, correct?
That was my perception, yes.
Okay, but you've acknowledged here today in your testimony after seeing this card that what happened was that whether it went to the correct address or not, it wasn't Ms. Mercado who signed for it, correct?
The card that you provided is not the same first name. You are correct.
And it has to be the same first name. I mean, not the same first name. It has to be the party in interest who signs for it under the law for it to count as service, correct?
To my understanding, yes. And I
Okay.
do emphasize, however, that whoever the gentleman was that signed, what I did think was very peculiar on that is he acknowledged signing as an agent. Once again, this is my first time seeing this, but that is one of the things that did pop out to me on that green card.
Okay. And so you, I am assuming, told your client, who later filed a JQC complaint, I know they had service, correct?
Based upon the information provided to us by the court, which was never the green card, the answer is yes.
I'm not saying you misled anybody about that, but based on what you know now, you know there was not proper service, correct?
But there was acknowledged receipt of notice. Because when questions were asked, once again, you can review the recorded testimony. She acknowledged receiving, acknowledged contacting, and acknowledged trying to determine what to do with this pleading upon her receiving it.
But that wasn't valid service under Georgia law. You've already testified to that, right?
It sounds like Judge McLean viewed it otherwise once someone took the time to get testimony from Ms. Mercado.
I'm not contesting anybody else's decision, but well, I think I've made my point.
You have.
May I have just one?
Sure. See those last five.
One last little bit of inquiry. You know the difference in an Article 6 court, probate court in Georgia and then all the other courts?
Yes, it's the number of constituents.
Yeah, well, you know where appeals go from that, on Article 6 court?
I apologize as I don't have, I always refer back to confirm where things flow by looking at the court rules. I don't want to
I'm
present
not-
myself as a expert knowledge and photographic memory.
You're not alone in that.
I'm not a law professor, administering an examination here. But if I told you that Article 6 appeals go to the Court of Appeals and the other probate courts go to the Superior Court, you wouldn't dispute me, would you?
What's before me right now, I have no foundation to dispute what's in front of me today.
Thank you.
Thank you.
Is Veal any redirect?
Did anybody ever call you from the court to let you or your paralegal know that service was not good on Miss Mercado,
Yes,
right? And they contacted you?
we contacted them and they responded back, giving us the update. And once again, this will be better fleshed out through testimony with Joanne Cabral.
Okay. What I'm trying to get at is, were you ever asked, you or Ms. Cabral, on initiation of communications from the court to your office, were you ever asked to get them an additional address or to get an acknowledgement of service from Ms. Ricardo? Were those kinds of things ever asked to you?
No,
Okay. In the way in which you found out that service on Ms. Mercado, or according to the court, was not good, was based upon a phone call from your paralegal to the court.
correct.
Did the court ever reach out to your office to let you know that service was not good and that they needed a different address or an acknowledgement of service in reference to the heir, Mr. Richmond?
No,
In your experience handling your support petitions, do courts typically reach out to petitioners' counsel to assist in perfecting service on interested parties?
we will be asked if we have an updated address through skip tracing, if we are able to do our own skip tracing.
But that would be if there's a request or an inquiry from a probate court, it would be, hey, do you have a better address for John Doe? Because this thing has bounced back.
Yes.
Mr. Tate? Nothing. All right, Ms. Polly, thank you for your time.
Thank you very much.
So we've gone more than 11 minutes, so we need another break. We're going to try to keep this to about 5 minutes as well. Your next witness is ready?
Yes.
Great. So let's be at ease for about 5 minutes.
Well, that's why that went on.
Yeah.
Which judge, you gonna go yell at her?
Judge Harris?
I had sent it to Dee. Yeah. I think she should already have it. Sorry. What do you need? That's from Dee. In an email. Okay. So these are the emails.
Attachments?
Yeah. Guess I can separate them.
Probably.
Maybe. Zip 'em off.
Well, you have to save them off, and zip them, or you can just forward that email.
I did, and she's.
It's too large.
That's too.
Too large.
So
You have thumb drive?
save them off and then separate them. I've got a.
Yeah, you have, yeah, let's do a thumb drive. Just load it
Well,
down.
here's one.
Just download them under that. Yeah.
That's there.
No, it didn't.
I suspect you're glad to not be at Fulton County Courthouse.
In a long time. It's nice of you to host this. It was good. So there was dancing. So get on out there. Go dance with that.
Okay,
I'm good. Thank you.
there we are. All right.
So.
And then-
If you do want to go to the stuff I have. Yeah. I think one of the lawyers back. Thanks. Oh, and. I didn't give it to what.
Oh, are these emails need to be. Or they need to. Have them copy the email you wrote in.
Sure.
This, then they need to be handed. Back.
Okay. This jet should touch down. This is all. Tony, are we?
Well, I just need to. Somehow they need just to get the emails.
Delete that stuff. I already have.
Okay.
I'll make sure all of this.
Yeah, just the emails. Well, they were gonna give you that, that thing back, but that's.
Yeah, I'm gonna do
Whatever.
documents you provided.
Okay, all right. And you want that thumb drive back?
Sure.
Oh, okay. So we'll be giving them. Because it's hard.
I can't vote him. I'm sad. Yeah.
No, he's the president of the state. No, because there is several.
Yes, absolutely.
I'm aware. We are the ones. It's 12 people that give us.
Did you give him a copy of himself? Oh, no. Make sure you give him a copy, because that way he will know potentially which ones we may want to talk about. He was clear.
All right, Ms. Womble, are you ready? Then everyone else is ready. Ms. Veal, if you or Ms. Murphy would call the next witness.
Deputy Alan Clayton.
I know. Pastries. But the answer, he didn't come to lunch today. Man. Santa Claus. No beard.
Oh, the ones in the break?
Yeah.
Yeah, I do have the ones in the break. Yeah. I just wasn't sure if you were talking about that or.
All right, we need someone to swear the witness in, so I don't know if that's gonna be our deputy or our trooper. The deputy's moving faster, all right.
Raise your right hand for me. The truth, the whole truth, and nothing but the truth, so you got.
Thank you, sir. If you would spell your name for the record, then we'll let the examination begin.
Deputy Alan Clayton, ALAN CLAYTON.
Good afternoon, Deputy Clayton. Will you tell us how long you've been employed with the Douglas County Sheriff's Office?
16 years.
Okay. And in what capacity have you been employed with them over the past 16 years?
I started off in the jail. I went to mandate within my first year. I came out of mandate as a deputy and I went straight to the court services.
What year did you begin in court services?
2008.
And job duties and responsibilities at court services?
I'm sorry.
Your job duties and responsibilities at court services?
Secure the courthouse, of course. We work courtrooms, transport the deputies transport inmates back and forth from court services to the jail. Serve papers within our duties there in magistrate and pretty much everything that's available in the courthouse to do with it.
Okay. Do you perform weddings?
I do.
Okay. How long have you been performing weddings?
Pretty much right after I got there, Judge Hamrick was the probate judge at the time. He knew that I was a minister as well. And he asked me if I'd be willing to help out and perform some ceremonies if needed.
And you say right around the time that you got there, meaning the time that you got assigned to court services?
Yes, ma'am.
Okay. When, during the time frame that you have been performing weddings, have you performed weddings at the Douglas County Courthouse after hours, meaning during the week when the courthouse is closed to the public or on the weekend?
I have.
Okay. Is there a time in, within the last couple of years where the security screen point in the Douglas County Courthouse has been moved?
Yes, it has.
Okay. Do you know approximately when that occurred?
Probably more like 4 or 5 years ago, it was moved out all the way to the front entrance.
Okay. Prior to that time, Was it located in an area that allowed for people to come into the courthouse, not have to go through security screening and access like up in the second floor of the courthouse?
Yes.
And perhaps you can explain that better since you know the layout. Will you explain how it was arranged prior to the change?
Okay. Prior to the change, it was further back in the atrium at the staircase. And so anyone could come in, once they got inside the building, they could go down to the first floor, go stay on the second floor, or go up to the third floor, like where the Board of Commissioners, Finance, Purchasing and everything like that is located, without being able to get to the secured side of the building.
Okay, and they could do all of those things without going through security screening?
Correct.
Okay. Once the security screening point was moved in the last couple of years, did that limit the public's ability to access the areas of the courthouse that you just described?
Yes, no one could come in without being screened at that station, screen station there.
Okay, and before it was moved, when you would perform weddings at the courthouse after hours, where would you perform those weddings?
On the unsecured side of the building. So anyone could come in. We'd go up to the third floor, and that's where the archway was built up there, and we would perform ceremonies there on the third floor.
Okay, and after it was moved, where have you performed after hours weddings?
I've still been performing after hours weddings up until recently. I had talked with the sheriff, the chief, and they still allowed me to do the weddings. So I would bring them in through the front. We would go up and do them in the same area up on the third floor.
Do they go through a metal detector to go up there?
I'm sorry,
Do they go through a metal detector before you take them up to the third floor?
not after hours or on the weekends, no, sir.
So post security checkpoint metal detector being moved and you performing after hours weddings, you would bring your wedding party into the courthouse and walk them to the location that you were performing the weddings without security screening.
Correct.
Okay, and were you under the impression that you could do that?
Yes, ma'am.
Okay. And you said that you had spoken to the sheriff about doing so. Was that Sheriff Phil Miller?
It was.
Okay. And when Sheriff Pounds took office, can you tell us what year that was, by the way?
It's probably, I think he's been in office around 11 years, maybe something like that. So 2002, 3.
Right. When Sheriff Pounds took office, did he ever tell you that you had to security screen citizens that you brought in after hours for weddings?
No, ma'am.
Okay. So at the time that you were doing these weddings and not screening your party, did you believe that you were violating any policy or procedure?
I did not.
Okay. I want to direct your attention to April 17th of 2021. That's the date that we're here for today. Did you perform a wedding at the Douglas County Courthouse on that day?
I did.
Okay. And on that day, do you recall what time you were set to perform your wedding?
At 2 o'clock.
Okay. When you got to the courthouse that day and met your wedding party, did you screen them before taking them in and getting them to the location where you did the wedding?
I did not.
Okay. On that day, did you encounter Judge Christina Peterson at the courthouse?
I did.
Okay. And was that a Saturday?
It was.
Okay. tell us where you first encountered Judge Peterson that day.
at the front door.
And when you're saying at the front door, that would be the door that you generally enter, walk through, and then the security screening station is right there after.
Correct.
Okay. And were you planning to see Judge Peterson that day?
I was not.
Okay. Were you aware, that she had a wedding, that she was going to perform that day?
I was, yes, ma'am.
You were?
I was aware that she was supposed to be performing a wedding earlier in the day,
Okay. And what was your understanding about what time her wedding was to occur?
11 o'clock.
Okay.
How'd you know that?
There was an event schedule that had been filled out. 3 deputies were to work the screening station area to be able to let the people in for her to be able to perform the wedding that day.
Okay.
They actually got there at 10:30. It takes us a little while to get everything set up and running. So I was not part of the 3-person team.
You saw the form.
Yes, sir.
And that form is something that the sheriff's team fills out, or the person who is scheduling the after hours event? So in this case, it would be Judge Peterson or her staff would have filled out that form.
I believe that'd be correct. Yes, sir. And that would have went to the office there in the courthouse.
Okay, but it comes from the requester.
I
it's
believe
not-
so. Yes, sir.
So you had seen on the event schedule that Judge Peterson was set to perform a wedding at 11 a.m.
Yes,
Okay. Do you recall around what time you arrived to the courthouse?
around 1:30.
At the time that you arrived to the courthouse, did you encounter any of the 3 deputies that you noted would have been present to perform Judge Peterson's wedding?
I did not. They were gone.
Okay. All right. When you encountered Judge Peterson at the front door of the courthouse, was there any exchange between the 2 of you?
There was.
Okay. And can you tell us what that exchange was?
I don't recall exactly what was stated. I do know that she was trying to bring her wedding party in. I was in the middle of trying to get mine in already. Most of them had already come into the building. And she made the comment that she was there to perform her wedding. And I would assume that I probably said, we thought you were going to be here earlier today and the deputies have already gone home. So now there's no one here to screen and run the screening station for your event.
Okay. Why did it occur to you to tell her, hey, there's nobody here to do screening for your event?
I'm gonna object that. I think he said he didn't remember exactly what he said, but he probably would have said this. And now she's asking, why would you have said that? As if that's what his memory is of what he actually said.
Deputy Clayton specifically related the conversation with Judge Peterson. Do you recall that there was an exchange between the 2 of you about her bringing her wedding party into the courthouse?
Yes,
Okay. And do you recall what you said to her? I'm not asking for exact words.
I do not, other than I was there to do my wedding. And there was no one there from the deputies had already gone home.
So Deputy Clayton, we've had the benefit of watching the surveillance footage of most of what you're describing. No audio, so I don't know what you said.
Right.
But we saw a whole bunch of folks not go through security with you. Why, unless they're somehow screened outside and we couldn't see that, why is it not an issue that 10 people come in with you and here's another county official, an elected official saying, I want to do what you did? Why would she, Judge Peterson, need 3 deputies to screen her folks? But you didn't screen the people who came in. I mean, I guess if the guy had a bazooka on his back, you'd see that, but you didn't pat anyone down. No one went through metal detectors. Let's go. You guys went on upstairs and did your thing. Why is it different? You letting people in unscreened and Judge Peterson letting people. Assume for a minute, she got her time mixed up, that her staff put in 11:30 or whenever it was, and she thought it was 2. Apparently, the people getting married thought it was 2 because they showed up at 2 as well. Why is it an issue that with you there, whatever you were doing to make it safe for your dozen people coming in, could eyeball her people? I said a whole lot, but you understand my question? I'm trying to figure out why it was okay for you, but not okay for Judge Peterson to do precisely what you were doing. It just happened to be a few hours later. You didn't have 3 deputies with you.
That's correct, sir. And I just know that that's what I've always done is brought, and I usually don't have that many people to come in. It's usually me and the bride and the groom, and we're done in just a matter of a few minutes. So I have always felt I had the understanding and was the approval to be able to come in and take care of what I was to do and get them safely out and close the building back down.
But you got a little bit of discipline for that day, didn't you?
I did, yes,
Sheriff?
sir.
And they busted you down a rank even though it was kind of temporary or emergency or whatever.
And no, sir, that didn't have anything to do with that particular day.
Are you a certified law enforcement officer?
Yes,
Is Judge Peterson a certified law enforcement officer?
no,
Did that difference have anything to do with your thought process regarding why it was okay for you but not for
I'm gonna
her?
object her leading the witness and suggesting an answer. She wants to ask what went into your thought process. That's one thing, but to suggest an answer, did such and such play into your decision is clearly leading.
Well, no, because he could say, no, it didn't. I don't know. You and I view leading questions differently. And I think there is, if this question didn't get to it, she could flip the question around and still get to the answer. So do you remember the question?
not at this point.
Okay, try again.
Did the fact that you were a post-certified law enforcement officer and Judge Peterson was not have anything to do with your thought process regarding it was okay for you, but it was not okay for her?
That has everything to do with it, yes, and that I had the approval to be able to do that because I was a deputy. I worked court services, and my command staff had told me that, I was approved to be able to do that.
Okay. So your understanding about why you could do it was directly related to your status as a certified law enforcement officer?
Yes,
Okay. On that day, when you were there at the courthouse, did you at some point receive a communication from Captain Trent Wilson regarding the fact that you had brought your party into the courthouse and did not screen them?
I did.
Okay. And we're gonna hear from Captain Wilson, but in response to his communication to you, what did you say back to him?
He asked me what had taken place. He asked me if I had screened the individuals that came in my party, and I told him no. And he asked me if Judge Peterson was there and if she had a wedding scheduled to be there. And I explained to him that our assumption was she was supposed to have been there at 11 o'clock that day. That was the event schedule, and she is now here, and she's trying to come in the front door with her party.
Okay. In response to what Captain Wilson said to you at that point, did you end up having a discussion about, or did you end up telling him what your understanding was about why you could be in the courthouse with your party unscreened?
Yes,
Okay. Did he indicate to you whether your assumption was right or wrong?
he did not.
Yeah, let's not get into questions he asked you. You can tell us what questions he asked you, but I'm gonna ask Ms. Veal to ask different questions, especially since we know Captain Wilson's gonna be here.
I understand, Judge. Did you complete your wedding that day?
I did.
After the fact, I know Mr. Hyde asked you about discipline that occurred as a result of this. There was actually an internal affairs investigation.
There was,
Did you cooperate with that investigation?
I did.
Okay. And were you disciplined as a result?
I was.
Okay. I want to ask you, had Captain Wilson advised you on April 17th of 2021, before you went into the courthouse with your party, had he told you that is against protocol? Do not take that party in there because there's nobody there to security screen them. Would you have done so anyway?
Absolutely not.
You mentioned earlier, well, let me just ask you, since April 17th of 2021, have you conducted, weddings after hours at the courthouse?
I have not.
You have not?
Not after 5 o'clock, no.
Okay, and why haven't you done that?
I've just made a decision not to do that. If I do a wedding at the courthouse, I get off at 4. I do it between the hour of 4 and 5, out of uniform. And take care of it and make sure I'm gone before 5.
That's all I have at this time.
Deputy, before Mr. Tate goes, like I mentioned, we watched the footage and you were wearing a nice suit. Did you have a firearm on underneath there?
Don't know if I did that day. I usually do. I usually wear a firearm everywhere I go, especially if I have on a suit, so it's not showing.
Okay, no, I didn't have a rifle slung over your back. But you were distinguishing yourself from Judge Peterson because you're certified law enforcement, and that doesn't mean you have to have a firearm, but I was curious if as part of the way you were gonna maintain security in the courthouse, if you had a firearm on you that day.
I feel sure I probably did, sir.
Mr. Tate?
Deputy Clayton, my name's Lester Tate. I'm a lawyer in Cartersville, Georgia. And we probably have met sometime when I've come in and out of the Douglas County Courthouse, but didn't know who you were until today. I've got just a few questions for you, and I'm going to pick up where Ms. Veal left off right there. If you understood, she asked you about if Captain Wilson told you, if you understood Captain Wilson to tell you to do something, would you do it in violation of what you understood he told you, right? You remember that question?
Yes, yes.
Well, if Captain Wilson told you something that you understood you were supposed to do, and Sheriff Pounds told you something different, which one of those two gentlemen would you listen to?
Well-
And I'll remind you, you are under oath.
Poor deputy.
Well, Captain Wilson is in line as my next, ranking officer with being the captain at the courthouse. Sheriff Pounds, he would carry a little more weight. So
Is the answer Sheriff Pounds?
he would make the ultimate decision, sir.
All right. And he is actually ultimately the person that's in charge of courthouse security under the
That's correct. Yes, sir.
scheme of courthouse security that we have, correct?
Right.
Now, couple of things that I want to go over with you. Which you said your wedding was scheduled at 2 p.m. I've seen the internal affairs. This is not a gotcha moment. I'm just curious about that. The internal affairs thing says you said it was at 1 p.m. Do you recall which one it was?
Not for sure. No, sir. I thought that it was 2. It could have possibly been 1.
You were just mistaken about that?
That's possible.
And so you could be mistaken about some of the other details about what went on and what was said that day, correct?
I guess we all make mistakes, but I don't believe so, sir.
Okay. Do you know a Deputy Vargas?
I do.
He does weddings also, correct?
He does.
Are you aware that he's done about 30 weddings in that courthouse?
I'm not sure how many he's done.
If I told you it was 30, would that shock you?
No, sir.
Would it shock you if I told you in all 30 of those weddings, that he didn't put anybody through the security screening there in the courthouse?
No, sir.
Deputy Clayton, is it your understanding that Deputy Vargas is doing these after hours weddings still now, or that he did until maybe the rules changed in April of 21?
My understanding is that he doesn't do them after the rules changed as of that day.
Okay.
And when the question you just asked, answered from Judge McBurney about when the rules changed, that would have been in April of 2021, like he asked you.
Yes, sir.
And so I just want to make sure, how many weddings, after hours weddings? By the way, if I leave out after hours here, I'm asking about after hours weddings. I'm not really concerned about the ones you do while the courthouse is open, everybody. But how many after hours weddings have you done prior to April of 2021 that you didn't put anybody through screen?
I probably performed 100 weddings or more.
Okay. And if Deputy Vargas says he's performed 30, that's about 130 weddings that's been performed without anybody going through screen, correct?
Correct?
And then you say the rule changed in April of 2021, right?
Yes.
And the very first time that rule changed was the one time that Judge Peterson did a wedding in the courthouse without taking somebody through security screening, correct?
Other than the fact that there was an event schedule that had to be filled out, which would have been before that time.
But you never even filled out event schedules, did you?
I was never asked to fill out an event schedule. sir.
And did you hear my question that I asked you a moment ago about when, was it the very first time that Judge Peterson did that this rule change took place?
I heard what you said. Yes, sir.
You agree that it didn't change when you did it 100 times. It didn't change when Vargas did it 30 times. It changed when this county elected official did it once. Right?
Correct. I suppose. Yes, sir.
You didn't forbid Judge Peterson from going into the courthouse that day, did you?
I did not.
Did you see Judge Peterson talking on the telephone that day?
I did. Yes, sir.
And did you know who she was talking with or overhear any of that conversation?
Not that I recall.
You ever know of a judge being barred from entering the courthouse after normal business hours?
No, sir.
If you were in the courthouse after normal business hours, would you deny any judge in Douglas County known to you entrance into the courthouse, be they magistrate, probate, superior?
No, sir. Not if they came in. They have an access card to get in.
Yeah, you don't have to look at that anymore, but you've been there quite a while, as I understand.
What's that? I'm
So
sorry.
you've been there quite a while. You've probably seen some walk through the front door in your time.
Well, they can come through the front door with their access card.
By the way, what was this discipline that was imposed on you?
3-day suspension.
Okay. Was part of the reprimand you got that you escorted your wedding party around the screening station, however, expected Judge Peterson to adhere to proper procedures? This action reflects poorly on the Douglas County Sheriff's Department and gives the appearance that we're not held to the same standards as county officials. Was that in your official
Yes, it
official
was.
reprimand?
It was. Yes, sir.
Now, on these 100 times that you took people around security screening, did you feel like you were endangering the people who work in the courthouse?
I did not.
Would you have done it if you felt like you were endangering the folks in the courthouse?
No, sir. I suppose I wouldn't know.
When you look at what I've related to you, Deputy Vargas might have done, do you believe he was endangering people that worked in the Douglas County Courthouse?
No, sir.
Deputy, you mentioned I appreciate it's an estimate, about 100 weddings you've done, but you also explained that for many of the years, you wouldn't have brought anyone through security because security was actually beyond the point where you did the wedding. So of your 100, how many of them were in the era where no one was breaching any security line by going to that archway you described? Would it be most of the 100 or a minority of the 100?
Minority of the 100, yes, sir.
So most of them were post moving that security line right to the outer perimeter.
Correct, yes, sir.
I want to see if we can get brought up on the screen. What's AT0002? And then the succeeding things here. I've got you.
To
Photograph.
defense PC? Got it.
Yeah, I can figure that one button out,
All right.
not much else. All right, do you recognize this picture?
Yes, sir.
Who is that?
It's a wedding party.
Is the wedding party on the same day you did for Judge Peterson, correct?
If I recall, yes, sir.
All right, let's go to the next one. Is this also the wedding party?
It is a wedding party, yes, sir.
Well, that's not my question. My question is that the wedding party of the folks that you married the day you ran into Judge Peterson in the courthouse on April of 2021?
It's been some time and I don't see myself.
Well, you didn't see yourself in the first one and you told me that was them. What's the difference? We'd slip back to the first one and then over to the next one. I'd like to know.
Okay, again, I don't see myself there.
And you understand when I ask you this, Ms. Veal has asked you specifically about what you remember from that day. And I asked you if you remembered the time. And you've expressed to me that every bit of testimony you've given her, you remember. So I'm trying to see what you really do remember here, Deputy. Okay?
Yes, sir.
Is this the people you let in the courthouse? This is 0002? 003, I'm sorry, 3.
And Deputy, if you don't remember, you don't remember. It's not.
I don't, it's been some time. I don't remember it.
Okay, let's look at the next one, which is number 4. Do you remember about that one?
I do not.
Do you see where do you know where that is in the courthouse?
I do know where it is. Yes, sir.
It's past the security screening line, isn't it?
It is.
How about number 5?
So if they're all pretty much the same picture of the same group, he's
Only 2
indicating.
more.
Okay.
There's only 2 more. 5, we'll go ahead and run them 6.
Now, if this is a date that is after that date that's in question, then yes, it would have been past the security point.
I'm sorry, what now?
If this was before the security station was moved out to the front door, then it would not be an unsecured site.
Well, it would be past the secured site in April of 2021, correct?
Yes, sir.
I want to pull up 22, if you would.
AT22.
AT22. I'm leaving all the zeros out at the front.
I didn't go to Georgia Tech.
I want you to look down, scroll down to the second paragraph there. Are you familiar with this document? Have you seen it?
I believe so. Yes.
That's that's part of the internal affairs report that was on you about this.
Mr. Tate.
I'm going to object to this document being placed up on the screen at this time. if there's a question related to something that was in that document.
I'll withdraw.
Okay.
I'll withdraw. Did you tell the internal affairs investigator that your reason for bypassing the procedures and that you thought it was okay was that if you stayed with the party and you didn't feel like there was any need to screen them?
My practice was to stay with the party to make sure that they didn't get away and that I would be with them the whole time. I would take them upstairs, do the waiting ceremony, march them back downstairs and out the front door.
So your testimony is every single time you did this, you were with the party the whole time.
I tried my best to be with the party.
Judge, I hate to ask for that 15-minute video to be played again for him, but I think it shows to the contrary.
Well, I don't disagree with you, and it's in evidence. So consider that as impeachment evidence that we can consider. I recall specifically, and my colleagues will watch it again, a bunch of folks went upstairs, and then there was Deputy Clayton downstairs because there was more of the party to arrive.
Thank you. And I just didn't want to spend the time doing that if you all recall that.
Your Honor, so I'm going to object. The question that was asked was a general question about what he normally did, and his response was he tried his best to stay with his party. I would ask that before we get into impeachment territory or making it seem like we're in that territory, he be asked a specific question about what happened on this date with this wedding party.
Okay, why don't you ask that? We'll still remember what was in the video.
I understand. And I'm going to ask the question as if we've seen the video. If on this day, April, can't remember the exact, April of 2021, you know, the day we're talking about here. If the video shows you walking around by yourself after the rest of the party that we've seen in these pictures is gone on up to the next floor of the courthouse or whatever, is that you trying your best to stay with them?
I guess no, I guess it wouldn't be.
So do you admit that you hadn't stayed with the parties as they've gone through the courthouse without being screened before?
With this large party, I did not that day.
Well, you realize we're here about that day, at least insofar as your testimony goes.
Yes, sir.
And you realize that you told the internal affairs investigator, I don't remember his name, that the only reason you thought it was okay was because you kept them, you stayed up with them, right? True?
If that's what's in the report, yes, sir.
Now, who do you think is more familiar with the security protocols at the courthouse, you or Judge Peterson?
With security protocol,
Yes.
myself,
Well, I'm assuming you think she knows more about probate
right?
than you
Yes, sir.
do, but you would, correct?
Correct.
And I'm still unclear about one thing. Because you testified in response to Judge McBurney's question to you, that this was a new procedure in April of 2021. And then I've read this internal affairs report, and it seems like this has been a procedure for a while, and you and Deputy Vargas were violating that.
When you say procedure, what do you mean? The prohibition against?
A prohibition against them taking people into the courthouse after hours without conducting a security screen. So which was it? Was it something that was brand new, or it was something that had been in effect that you either ignored or did not know about?
It was something that was new because we had never been told that we couldn't bring someone into the courthouse and take them upstairs to do the weddings.
So if it was new, it would have certainly, if it was new to you, it would certainly been new to Judge Peterson, correct?
I suppose, yes, sir.
Oh, for the. Yes. Captain Sweat was the internal affairs investigator, correct?
Yes, sir.
Captain Sweat's the one that you told that you thought it was all right because they were with them, true?
Yes, sir.
Now, the party did you see the party that Judge Peterson brought in that day to get married?
I did see them some, yes.
Okay, and there were 4 of them, 2 adults, 2 kids. That sound right?
I don't recall.
Okay. If it was 4 adults, 2 adults, 2 kids, 4 individuals, that was a lot less than the wedding party you brought in that day, correct?
Correct.
So if there's a danger posed by bringing people into the courthouse without doing a security screening, the threat you presented, if it is a threat, was far greater than any threat Judge Peterson presented, correct?
Correct.
Are you, one of the things that it appears in some reports, and I don't know, sometimes, particularly if you're, I've always said the lawyers and police officers have something in common. Nobody wants to see them come until they need them. And we get called things that maybe we don't want to be called, but one name for you has been pastor deputy, that you're a pastor deputy or deputy pastor. Is that some name that has been used in connection with you before?
No, sir.
Okay.
I have been called pastor. I have been called deputy, but as far as pastor, deputy, or deputy pastor, no, sir.
You fill both roles though, as a deputy sheriff and as a pastor of a church,
I try
correct?
my best, yes, sir.
And you didn't fill out an event form that day. In fact, you never filled out an event form,
No, sir.
correct?
Yes, correct.
And so your wedding wasn't on the list, correct?
No, sir.
And you, as far as you knew, you weren't required to fill out any form.
Correct.
And you did not get, as I think Mr. Hyde thought, because there was something else in the IE package that looked like at some point you had lost a rank or whatever, but that had nothing to do with this, correct?
Correct.
Just the,
Misread
I just wanted to clear up that I thought that too when I first read it, Mr. Hyde. But that had nothing to do with that. You got 3 days off without pay, right?
Correct.
And did you file any appeal of this 3 days off without pay?
No, sir.
You just accepted it and went on, correct?
Correct.
Can I have just a moment? I think that's all the questions I have, Judge. Thank you so much.
Ms. Veal, any redirect of Deputy Clayton? Just briefly.
I have to apologize to Ms. Veal too. I think I took her water when I was up here
Oh,
before. I apologize for that.
I don't have anything further.
Okay, Deputy, thank you for being here.
Yes, sir.
Appreciate it. So you have one more witness you need to fit in today? I suspect you need to fit in today because he'll be in trial next week in Fulton County Courthouse.
And I have one witness report that is very, very short.
In stature or duration?
It will be very brief.
Okay. We can't stay too late because someone has I don't remember what your conflict is, but I'll try to remember it.
Yes, yes.
Both of the witnesses that are here have conflicts for next week.
Okay. let's make it happen.
At this time, the director would call Lieutenant Graham.
Yeah, choosing tables.
Yeah. Deputy, you mind swearing in the LT?
Tell the truth, the whole truth and nothing but the truth, so help you God.
I do.
Thank you, ma'am. If you would state your name and spell it for the record.
Elizabeth Graham, Elizabeth, Graham, Graham.
Thank you.
Lieutenant Graham, you're employed with the Douglas County Sheriff's Office. How long have you been employed with them?
21 years.
Okay. We are here today on a very limited issue with you. And so the issue I want to ask you about is related to events that took place on January 24th of 2022. On that date, did you serve Judge Christina Peterson with a petition for a writ of mandamus that had been filed against her?
I couldn't tell you exactly what the paper was that I served her. I've served her several papers
All right.
because I'm in the civil division.
Ma'am, when you say several papers, meaning on one instance you serve several papers or on multiple instances you
Multiple.
had to serve?
Multiple incidents.
I don't. Maybe I hadn't really been asked. I mean, I'll stipulate to that. Service at that time and place the time and place the document says. I hadn't been asked, but I apologize if I
Okay.
had somebody come that didn't need to, but.
Discuss it, and you said you would stipulate at our meeting.
Okay,
Okay.
Lieutenant, I'm showing you JQC exhibit number 46. Can you take a look at that document? And tell me whether you.
That is my handwriting. That is my name. I did sign this and that is my January 24th, 2022 writing. Yes.
What is the document?
It is from Miranda B. Jordan, Harrison Law LLC. P.O. Box 1495, Douglasville, Georgia 30133, to Christina J. Peterson. 8700 Hospital Drive, Douglasville, Georgia 30134.
Okay, but what actually is this document that we have? Like the title of this document?
It is from Superior Court, civil,
A sheriff's entry service.
Sheriff's Interest Service. Yes,
Okay.
I'm sorry.
So, and I'm gonna go ahead and move up. We stipulated exhibit 46 into evidence. So a sheriff's entry of service, this document is completed when?
January 24th, 2022 is when I served her.
Okay, and when you say serve her, who are you talking about?
Christina Peterson.
Okay, and that would have been serving Christina Peterson with something from Miranda B. working at Peterson Law LLC.
Correct.
Okay, and you tell us then, survey judge in the Philippines, with official papers, whatever they may be, what generally is your process?
I will, if I was going to Judge Peterson's office, I would go to probate court. I would ask her clerk or one of the ladies working there if she's in. And if she was, then I would wait for them to direct me back to her office and I would serve her there. Or if the clerk would, or her secretary would say, no, she's not there. Sometimes I would wait. They have a little sofa that I've waited there. And other times they'd say, no, she's just not coming in for the day. And I would return another day and time.
Okay. Do you recall specifically how you served Judge Peterson back on January 2022?
Honestly, if I served her personally, which is, it's checked, then I would have served her personally
Okay.
in her office.
Okay, and would you have ever, badged yourself into a back door of her office or let yourself into her office? in
I
order
don't
to
have
serve?
access to her office.
Okay, so you would have followed the procedure that you just set forth for us?
I always get permission and I always get directed by one of her staff to go back into her office.
Okay.
I've never gone in there alone.
Okay, and that would have been what you did instead?
Correct.
Okay, after you accomplish service of Judge Peterson on January 24th of 2022, is this document the sheriff's entry of service? Did you keep the copy of this document?
Yes, I return it back to my clerk at the Douglas County Sheriff's Office. And then she puts it into the computer and then that paperwork then gets taken back to the correct courts.
Okay, and there's a stamp down here at the bottom of exhibit 46, which says received Douglas County Sheriff Civil Unit, January 24th of 2022, 9:40 a.m.
That is correct. We have a timestamp of when we get it.
And that stamp would have been placed on this document when you returned this document to drop it off to say, I served this on Judge Peterson.
We stamp those when we get them from the courts. Like when I would go to the courts and pick up, or perhaps my sergeant would pick up papers for the day, we bring them back to the clerk and we timestamp it. So that's the day and time that we received it.
Okay, so when did you, this is entered by your clerk
Correct,
when you received this document?
correct,
Okay, and then you would take the document to the judge and serve her?
correct.
Is that what you did?
It was, we got the paper that day and I served her that day.
Okay, so this, January 24th, 2022, at 9:40 a.m., that would have been stamped on there by your clerk in the way you claimed. After that was done, would you have gone directly to Judge Peterson's office to serve her with this?
Correct, correct.
So then the service was then sometime after 9:40 a.m. on January 24th.
Right.
Okay. How long approximately do you think it would take you to get to the location where the state was placed on this document to get to Judge Peterson's office for service?
Our sheriff's department to the courthouse is less than 10 minutes. All depends on the traffic light,
Okay. So
within the hour.
within the hour. Lieutenant, I believe that is all I have. Thank you.
Thank you.
And then before Mr. Tate asks you any questions, if he has any, you were describing the process by which you try to serve a judge when you're called upon to do that. You said, sometimes I go to chambers and they tell me to wait a little bit. And sometimes they say, she's not coming in today. I know that's not a day when I can do it. Were you referring to instances when you, as you said, there was more than one, you were trying to serve Judge Peterson, or just in general, in your experience as a sheriff's deputy, lieutenant, serving process, you've been told, oh, this judge is not coming in today?
If her clerk or her staff says that, she's won't be in for the day, or she's in court for the day, whatever it may be, then I'll return it another day and time.
Okay.
But if they said, oh, she's doing something, or she's in her office, but she's on the phone right now, then I'll wait.
Mr. Tate, any questions?
And I'm Lester Tate, and I represent Judge Peterson, and I don't have any questions.
Great.
Thank you.
Thank you, Lieutenant, for your time.
Thank you.
Haven't gotten into. We look forward to you tying that into something else.
This is what happens when we have always out of
We'll keep up. All right, last witness of the day.
Judge David Emerson.
Wait to ask questions. If you would swear the judge in, please.
Promise to tell the truth, the whole truth, and nothing but the truth, so we got.
Yes, I do.
Judge, we know who you are, but if you'd spell your name for the record, we'll be ready to proceed.
I'm David, David, Emerson, Emerson.
Ms. Veal?
And Judge, for those who don't know, can you tell us what year you took the bench as a judge?
January 1st, 1991.
Was that the Superior Court bench in Douglas County?
Yes,
And you served in that capacity until when?
for 31 years. So end of 21.
You said end of 21?
December 31, 2021.
And that's when you retired.
I retired, took senior status.
When he transferred to Fulton County Superior Court.
Judge, I want to talk to you about a few different issues and hoping you can shed some light on them for the hearing panel here today. When Judge Christina Peterson took the bench in January of 2021, did you have a relationship with her at all, a professional relationship with her at all?
She'd had a few cases in front of me.
So she had been a practicing attorney in your jurisdiction,
Yes,
and you said it was just a few cases?
few domestic cases.
She didn't appear in front of you as an assistant district attorney?
She was the drug court attorney, so no, I didn't have any relationship with her when she was working for Brian Fortner. I don't remember her. She was never assigned to my courtroom. Douglas County, the DA would assign prosecutors to your courtroom. She was never on my courtroom team that I recall.
When Judge Peterson assumed the role as your probate court judge in Douglas County, did you reach out to her for training opportunities or anything of that nature?
Not especially.
Okay, and is there a reason why you wouldn't have done that?
I'm not a probate judge. I was never engaged in the probate court. I couldn't help her with the day-to-day operations of her court. Now, I do a lot of technology. And so I was always, did reach out to all of the judges of the circuit to try to teach them how to use the Icon case management software and how to use that to make them more efficient. And that was always available. Which all 5 courts were using. When she came into office, all 5 courts in the circuit were running Icon.
And we're gonna get to Icon, but I want to ask you about, back up just a little bit. We've heard some mention during this proceeding about your having written a letter regarding Judge Peterson's request for a salary increase after she took office. Are you familiar with the letter that I'm talking about?
I just don't remember that.
Do you remember that Judge Peterson was making a request to have her base salary increase?
I was aware that the Judge Hamrick was making 93,000 or so. And I learned from either press reports or whatever that she wanted a substantial increase on that.
Okay,
Substantial to you.
It was, I think it was up to 150 or so. I just don't remember the numbers. But she wanted a huge increase.
And what was your opinion on Judge Peterson's huge salary increase, or the request for that huge salary increase?
I have two views. One is that it was completely unjustified. Her rationale was that should get a pay raise because she was an attorney. The probate court of Douglas County has a very light caseload. And so it was really unjustified just because she happened to have a bar license. Number two, eventually it came out that she was keeping all of the fee surcharges or the fees for her court. So she wound up making a huge amount of money, which at the time I really didn't realize that probate judges could keep fees.
Did her predecessor keep the fees?
A part of it, I think he kept a percentage. I don't know I don't recall. Judge Hamrick has told me how much he kept, but he did not keep 100%.
But he was a non-lawyer.
Non-lawyer, layman.
So your understanding was that Judge Hamrick kept a percentage of the fees. Are you now aware, have you become aware that there is a statute out there that provides, or that the law provides, that those fees are to be capped at $7,500 unless there is local legislation that allows the judge to take more than $7,500?
I'm gonna object to this. I don't think this relates to any charge like that she's accused of overly charging fees or for whatever reason. It's certainly relevant, goes to bias as to what Judge Emerson might have thought about what she did or didn't do, but the specifics about that and the specifics of what her compensation were are not a subject of proper inquiry.
Why are we getting this granular?
Judge, they have inserted allegations of bias on behalf of Judge Emerson throughout every stage of this process. And I am exploring this with him on direct, as this specific allegation regarding his bias and he obstructed her attempts to get more money has been mentioned multiple times. And so
Absolutely. He filed a complaint, filed the very first complaint against her. So the allegation of bias is out there, but it's relevant on cross-examination. It's not relevant on direct examination. But the question she asked isn't relevant either place about the compensation scheme.
And we didn't know about this is the first time hearing about a complaint anybody filed on.
that's because that complaint related to charges which have been withdrawn.
Either way, it's still news to us. We don't get that information.
I'll be asking about it.
No.
But I think you are entitled to explore the bias preemptively. It's out there. What does Judge Emerson's knowledge about the $7,500 cap on fee retention absent local legislation have to do with that? That's all I'm getting at. I think that's what the objection is.
Judge, I can move on and
Okay.
he can talk about that if it comes up during cross. And since this piece of his alleged bias has now come up, it was mentioned that you filed a complaint, a JQC complaint against Judge Peterson. How many JQC complaints have you filed against Judge Peterson?
The one that comes to mind is a Douglas County investigator came to me from the sheriff's office. And she brought a stack of papers that constituted her criminal investigation of Judge Peterson in regard to a $70,000 settlement that one of Judge Peterson's former clients alleged that client was entitled to. And that investigator brought those materials to me. I looked at them. I viewed it as something I had a duty to report because it had contained potential criminal behavior. And so I mailed those papers to the staff of the JQC. I don't think it was the first complaint. I think she was already having issues though.
Well, how many, you said you remembered one complaint. How many complaints have you filed on?
That's all I've ever sent to the JQC was that piece of material.
Filed complaints other places other than the JQC about it?
No.
And the stuff you sent the investigative panel, you said it involved potential crimes. What crimes did you say?
It related to a $70,000 settlement that the judge received in a civil case. And according to that person, they were entitled to part of that and it was not received. So it was a question of the person went to law enforcement claiming that the judge had stolen money from her. She was one of her neighbors. I think her name's Starkey.
Well, that could also, you could also refer that to the bar. Did you?
I did not, because at the time, it was my understanding that the JQC had the authority to deal with that. I believe also the investigator indicated that the bar had not done anything with it.
Did you also refer to the district attorney
No,
or the attorney general?
no.
Why was that?
Was satisfied that sending it to the JQC. Well, I'll tell you what it was. The investigator indicated to me that she,
I'm gonna object him, tell him what the investigator said to him, hearsay,
Okay,
pure hearsay.
so let's stay out of that space unless the investigator's going to be
I
coming.
think the judge knows that.
I just asked why.
Right, but his answer was because the investigator told me and we can't get there.
All right. Judge, I want to talk to you about the events of April 17th of 2021, which was a Saturday back in 2021. Do you recall an issue coming to your attention related to Judge Peterson performing a wedding at the Douglas County Courthouse on that date?
yes, Major Lindy West contacted me regarding the events at that courthouse that day.
And based on the information that Investigator West conveyed to you about the events at the courthouse that day, did you take any action?
Just a quick correction. She was a major that contacted me. She was over Captain Trent Wilson, and she had been the captain in charge of the courthouse. So Major West reached out to me. I was driving out to Temple, and she called me to advise me that there was a wedding, that they had security at the courthouse for an 11 o'clock wedding. Judge Peterson and her wedding party did not appear. Major West told me that she talked to Trent Wilson, who's the captain in charge of the courthouse. And Captain Wilson told her that she could do the wedding on the front of the courthouse, but that she was not to allow people into the courthouse. What happened, she arrived late around 1 o'clock. Security had left. And so she was instructed not to allow the civilians into the courthouse when there was no security present.
Is it to run that up the flagpole all the way to the chief judge of the circuit? Is that in your experience?
Well, I've never had it happen before. That's why I was surprised to get that kind of a call,
Meaning you've never had a call from the major, or you've never had, I'm gonna call it a colleague, another judge trying to get people into the courthouse after hours?
Neither one.
And so would you agree you have some amount of supervisory authority over probate court? I don't mean for probate matters, I mean more administrative.
As the chief judge of the circuit, I, along with the sheriff, have authority to adopt the courthouse security plan. And I viewed it as my responsibility to try to enforce that plan and protect the lives of the people in the courthouse.
So would that plan authorize you to disable her or would it authorize you to prevent her from entering the courthouse?
Well, she was never prevented from entering the courthouse. It related, they had the ability to suspend after hours access.
Well, if she can't go in after hours, she's being prevented from entering the courthouse, isn't she?
After hours, yes.
But what are the hours of a probate judge?
Well, the courthouse is open from 8 to usually 6.
So that wasn't the question.
Okay, well, I don't know when she would work.
So you don't know what the code says about the hours of probate court,
I've not looked it up. But, it wouldn't have included Saturdays because, our courthouses are closed on Saturdays, a general rule.
I don't want to argue, but the code specifically says probate court can be open on Saturdays, doesn't it?
Sir, I just don't know about what it says about the probate court being open on Saturdays.
Will you supervise?
Not in that way, no. I didn't tell her to open or not.
But you told her not to come in.
Well, I instructed them to suspend her after hours access.
What was your specific legal authority to prevent her from coming in after hours? That's all my question.
I viewed that as something I had the responsibility to do as the chief judge. And so Monday, I immediately got to work to change the courthouse, work with the sheriff to change the courthouse security plan so that we would no longer have weekend unofficial thing like wedding events going on weekends. And I got that done by Thursday. It was midday. The sheriff and I communicated, and it was about, I don't remember what time Thursday, but it was Thursday that her full access was restored.
Judge, you indicated that you viewed it as your responsibility as a chief superior court judge to take the action that you did. Is there any support in the law or in the uniform probate court rules for the action that you took?
I have no idea about that, other than the being the judge that adopts the courthouse security plan.
Okay, and where is the support for that? Is there legal?
It's
support?
15, 16, 10.
And I don't want you to recite it verbatim.
It's subsection 10.
Okay, 15, 16, 10, and that provides, and again, not verbatim, but generally.
The sheriff and the chief judge of the Superior Court adopt and implement this courthouse security plan.
Did you give instruction to a member of the sheriff's office to revoke Judge Peterson's after-hours courthouse access?
I spoke with Major Lindy West, and after consulting with her, we agreed that that was what we should do.
And is it your understanding that then somebody with the sheriff's office took the steps to have that after-hours access revoked?
Whoever their programmer is,
Okay.
Why did you open it back up for her a few days later?
because we had adopted the revision to the plans that it required. I believe that what we required them to do was that they were not to have any weekend programs without previous approval of the Board of Commissioners. That's what the sheriff and I agreed on. And that's when I authorized her to have her full card access back.
So you and the sheriff decided what the Board of Commissioners was going to do.
No, we gave the Board of Commissioners the authority to decide if they were going to allow weekend functions. I mean, the sheriff has control over it. Yes, as opposed to the commissioners. So yes, the sheriff has control over that access. So he and I consulted, and that's what we agreed to do.
During your conversation with Major West, the one where she conveyed to you the events of April 17th, did she explain to you that one of the sheriff's office deputies had also allowed civilians into the courthouse for a wedding that were not screened?
No.
Is that something you should have been told? You in charge, you and the sheriff in charge of courthouse security?
She just didn't tell me. I can't answer, because she realized she's getting this from Trent Wilson. And so she's sort of a go-between between him and me. So she's not there either. So it would have been nice to
You
know.
and the sheriff in charge of courthouse security, and you're told about a elected public official doing something, and the deputy does similar or the same thing, do you think you should have been told about that?
It would have been nice to know, but it would not have changed my opinion of what she did. Because allowing the civilians into the courthouse when she was expressly told, if Trent Wilson told me to stand over there, I'd go stand over there. I mean, I'm going to comply with what the law enforcement officer who's in charge and command, I'm going to do what he tells me to do. And it would not have changed my view that by allowing these individuals, and I thought maybe it was 2 or 3. I think there were more. I've seen the video on television. I don't know how many total she allowed in, but she shouldn't have allowed anyone in. It endangered all of us.
Before you deprogrammed her, how did she explain that to you?
She didn't.
Did you ask her?
No.
Why is that?
Well, I got the call on Saturday and I talked to Major West on Saturday and we made the decision on that phone call.
You didn't think you needed to talk to the elected judge, get her side of it?
I trusted my major. I'd worked with her for years.
So you tried cases with this major, I guess.
Well, she was in charge of the courthouse security for many years. She's the person that kept us safe.
Gotcha.
During your.
Just a second. She's a total straight shooter, that person, in terms of integrity.
During your conversation with Major West, did she tell you that the sheriff had told Judge Peterson that because his pastor deputy was there, it was okay for her to go inside and take civilians inside?
No.
In your dealings with the sheriff, the following week, starting that Monday, when you all are working through how to amend the courthouse security protocol, did the sheriff ever say to you, hey, I told her this was okay because my pastor deputy was in there?
I'm gonna object. It's pure hearsay.
Seems pretty pure.
I can rephrase. Were you ever aware of the sheriff telling Judge Peterson that it was okay for her to go into the courthouse? Did anybody ever convey that to you?
Well, I think at this point, then it's relevant because if he had that knowledge or didn't have that knowledge, that's one thing, but when he had it, if it justified some decision on his part.
So I'm just thinking through the previous ruling. The question isn't, did someone say this to you? It's, did it not get said? I mean, that was in effect your question, Ms. Veal. Is that right? I mean, I'm not saying that very artfully, but it's not hearsay to respond. No one said X to me. Did the sheriff ever say to you? The problem is if the answer is yes, it's hearsay. But if the answer is no, it's not hearsay because the witness is saying, I didn't hear anyone say that. So if you, I think it's relevant, if you can craft the question where we don't run into a scenario where in answering truthfully, this witness is going to have to stray into hearsay. If that makes sense.
Did you at any point become aware that the sheriff had given Judge Peterson permission to go into the courthouse with those civilians?
My answer, my information was that he told her not to.
Well, move to strike.
Right. So we're okay. I mean, what we'll take from that is that the sheriff did not tell Judge Emerson that he had authorized the entry. That's where we are. It's the absence of that affirmation.
Judge Emerson, I am going to show you an exhibit, which is JQC exhibit number 13. And it should appear up there on that screen.
So it's not in yet. Are you gonna have an objection to, I don't think it's in according to your exhibit list. But now it's up on the screen. Do you have an objection to JQC 13, Mr. Tate?
I'm sorry, I was looking at that. Yeah, I'm happy. I don't have any objection.
Okay. It's not in yet, but since it's on the screen, I wanted to make sure that it wasn't controversial. Okay.
And Judge, I'm gonna scroll down to make sure that you recognize this document.
I do.
All right, and what do you recognize this to be?
It's the text of a hard copy paper I sent to Judge Peterson explaining why we suspended her after hours access.
Okay. I'm gonna go ahead and move Exhibit 13 into evidence.
It's admitted.
That what's contained on Exhibit 13 is something that you sent in memo format to Judge Peterson?
I believe I sent it to her in hard copy. Just based on the format of it, it looks like what I would have done. It does not look like an email that I would have sent to her.
Judge, what was the reason for you sending Exhibit 13 to Judge Peterson?
My recollection is that this is dated that Tuesday. And I was working on the courthouse security revision at that time with sheriff. And I was getting repeated email demands from her demanding that her after hours access be restored.
Okay, and so then the memo that you've attached to this email that's dated April 20th of 2021 would have been in response to the communications to you from Judge Peterson.
Yes, I believe I got one on Sunday from her. I don't recall the firm, but I believe the first one came on Sunday.
Okay, and you said that within those emails, she was demanding that her access to the courthouse be restored.
Yes,
Okay, did you respond to the email on Sunday, if you know?
I don't remember.
Okay, do you recall responding to any of her other emails about restoring her access?
With this.
Okay,
But you never sat her down and tried to talk to her in person.
No,
Why was that?
I did not think that she would be responsive to that from my previous dealings with her.
So you had tried to talk to her.
Well, just from knowing her as in court and things like that and what was doing. Yes.
Judge, I noticed that you sent this to Ms. Veal. I think it's the top of the document. Ms. Veal, if you could scroll up real quick. This is an email you're sending to Ms. Veal. Sorry, Ms. Womble. You had previously told us that you had sent Ms. Veal or the JQC, not Ms. Veal, but the JQC, some documents about potential issue with a client and client funds. Did that happen before this email, which is April 21st of 2021? Had you already sent those documents to the JQC?
I really do not remember when I sent the other package to the JQC. I just can't tell you. I was aware that she had ongoing matters with the JQC by this time.
Thank you.
Who told you that?
I really don't recall how I came to know that. It may have been that the JQC had investigators in the courthouse. I really just can't remember how I came to not be aware of it.
all right, Judge Emerson, within this memo, you indicate that you had seen nothing from Judge Peterson that indicated that she understood the seriousness of her conduct on Saturday.
That's correct. She never has.
At that point, what did you base that statement upon?
I've never seen her demonstrate anything that showed me that she was cognizant of the risk that she posed to the people that work in the courthouse by allowing unsecured access to that building.
Has she done it more than that one time we know about?
I was not aware of it any other time. No.
But before this, you'd pretty much had your fill of her head.
I wouldn't say that. There's always hope. I wouldn't say that I had my fill of her.
Well,
No.
that's my,
Well, I wouldn't say that at all.
but you never tried, did y'all ever go to lunch?
No.
You ever invite her to your office, or you ever go to hers and say, hey, I've been around 31 years, here's the way you might want to think about something?
Well, I convened it, I really couldn't help her be a probate judge. I was never a probate judge. And she was never one who lent herself to being mentored or otherwise guided. That just was not her way.
You know that because she appeared before you in court as a litigator.
You learn a lot about folks from that. Yes, sir.
Well, what did you learn about her as a litigator based when she appeared in front of you?
Very arrogant.
Anything else?
Just, it's not going to be kind. She really just was not very good at what she did. And she didn't seem to be able to acknowledge that.
But the people out there hired her pretty much. Didn't
The case I had with her was a very simple contempt for failure to pay a $3,000 some debt. And so it was just a very low level domestic case. That's the only one I really, pardon me?
The voters just got it wrong when they hired her.
Well, the voters get to decide. They had a choice between her or a gentleman named Leonard Danley. And so that was up to the voters.
Judge Emerson, during your years as a Superior Court judge, did you take other new judges to lunch or train, mentor them? Is that what you did?
Not from other courts. I would go to lunch with any of my Superior Court judges, but I never went to lunch with any of my juvenile court judges or any of my probate court judges or otherwise.
Why was that?
We just didn't,
You said they were your juvenile judges, your probate, but you're the chief judge.
Well, they just work in the county, sir. I don't own them. I mean, they were people, well, okay, but we didn't go to lunch, okay? And also, I just, would not have gone to lunch with her. I never went to lunch with Judge Michelle Harrison or any of my juvenile court judges.
Did the probate judge, the prior probate judge, Hamrick, did he have a courtroom in the courthouse?
No,
Where would he conduct?
it was my understanding he conducted his, I think he sometimes had to have guardianship hearings, things like that. And I believe he did it in a conference room in his office suite.
Okay. Judge Peterson has a courtroom in the courthouse currently. Correct?
Yes.
How did she obtain that courtroom?
I set that up for, when she came into office, she demanded that the commissioners give her Judge Brian Fortner's state courtroom. The history is that when we built the courthouse in 1990, we moved in it in March of 1998. The probate court at that time handled traffic. Well, eventually the commissioners implemented a state court. And a state court is a very busy court. And that court took over the traffic. So there was no longer need for the probate court to have that kind of a courtroom. When she came into office, we had a courtroom that Senior Judge Howe had used for hearings. And we made sure that that was set up so that she would have a designated courtroom. And if she needed to have a jury trial, which I'm not aware that she's ever needed to have a jury trial, we would have made arrangements to have her use one of the other courtrooms. But I was the person who got that courtroom set up for her and allocated it to her. It was a Superior Court courtroom on the 4th floor.
Judge, I'm going to show you Exhibit 12. It's already been admitted. Do you recognize the portion of Exhibit 12 that I'm showing you?
Yes, that's an email that Judge Peterson sent to me. I believe the date is correct, April 21, the morning of that Wednesday of that week.
Okay, and was that email sent to you in response to the memo that you sent to her?
I believe so.
Okay. When you originally sent her the memo, did you CC Tim Pounds, Trent Wilson, Kelly Robinson, or Sharon Subadan?
My recollection is I sent it to only Judge Peterson and no one else.
Okay. And Judge Peterson's email here where she accuses you of harassment and your actions being borderline racist, tells you that she prays that your soul is saved and asks you to retire. Did you respond to this email?
I did not.
Emails have you ever gotten like that from anybody, Judge, in 31 years? Other than prisoners?
Well, that's what came to mind, Mr. Hyde, was I've certainly gotten letters from prisoners or things like that, but I've never had anything like this before.
Well, a couple of sentences, she's kind of right, didn't she? Did you try to verify any of the information?
As I indicated, I was working with Major West, and Major West had informed me of what had happened. And I'm satisfied from seeing the videos, what I was informed of, which was that she allowed civilians, non-secure individuals into the courthouse. And so nothing came to my attention that would have changed my view that we should secure the courthouse.
But I know you didn't treat criminal defendants that way, did you? They always got to put up a case. If the major came in and said, Richard Hyde's a bank robber, you didn't just convict me and send me off, did you?
Of course not.
Right. Okay.
Judge, during your time as chief judge, after Judge Peterson assumed the bench, did you become aware of an issue related to her attempts to obtain data that had been maintained by Icon Software in order to get that data to a vendor of a new software company?
I walked off the bench around noon one day, and one of the county information services people named Rule Douglas was standing in my assistant's office. And he shared with me that
I'm gonna check. It's a hearsay response, and I think after 31 years on the bench, that Judge Emerson knows it's a hearsay
The
response.
objection is hearsay. I need to narrate beyond that.
It is.
And it sounds like it's heading in that direction. I know we've received a lot of this information through emails, but let's focus the witness on things he did.
Sure. What was your understanding that there was an issue with taking data from Icon and providing it to her new vendor with CJT.
All right, I can tell you what I did. I was aware that she was transitioning to a new system. And what I instructed Mr. Douglas was that she could have her data, but she could not have the program. The program is intellectual property. And we have a contract with the Icon software company that we could not disclose intellectual property to her, a competing vendor, whoever it was, JCT, I think was the name of it. So I instructed them to work with those folks to transfer her data. I would eventually find out that things happened where she wanted to sue the County Information Services Department.
Knowledgeable about the contract that Douglas County had with Icon.
I reached out to Marty Hahn, who at the time was the president and owner of the Icon software. And I inquired of them, and he sent a contract, and he affirmed to me, well, that'd be hearsay, but I knew that the county CJT people could not divulge the program itself, the program, and that's the intellectual property. That's what we paid a lot of money to buy. The county commission did.
Why was it you, as the chief judge, that was involved with this Icon software issue?
I was starting in 1993. I was always the one that did all of the computer programs for the court. And we installed our first system in October '93. So whenever it came to any kind of question regarding the computer systems, the software specifically, they came to me. A lot of judges won't have a lot to do with computer programs.
And you had knowledge of the computer programs that you all were using in your county?
Well, realize I had knowledge that I understand how databases work and the way they store information. And I knew that the label I was using, data, I could not say the specific file names. That's not something that bluntly, the IT people try to hide, the computer programmers try to hide that from you so you don't know. But I didn't know all of that. But I did know that the data, she was certainly entitled to transfer that. And what they'll do is they'll load that to the new fields in the new system.
Judge, I'm going to show you JQC.
I don't think these have been admitted yet. I know we've looked at them a lot. Mr. Tate, any objection to having them up on the screen before they get admitted?
I'm down.
Okay.
I mean, y'all are lawyers or almost lawyers or otherwise sophisticated. Y'all know something being displayed. There's no bell to be unrung here, I don't think.
Okay, agreed. Except for the sophisticated part.
Are you familiar with exhibit number 9, Judge?
Yes,
All right, and what is that?
the series, it's an email chain regarding Judge Peterson's persistent demands and threat to sue the county IT department because she wanted the county folks to provide the entire program to the new vendor.
And in looking through that email chain, and I'm going to go through it up on the screen, who initially added you to these emails?
I don't object to her leading the witness if she
Well,
wants to tell
If you
him,
wanna-
if she wants to tell him who added him to the email
Guide to
chain.
the one where suddenly Judge Emerson is in the mix.
Sure. Did Mr. Douglas from the IS department originally add you to these emails?
And it's multiple pages, so I was trying to track the exact dates and times, but
If Ms. Veal states that's who added him, I will accept that on this point.
Okay.
Mr. Douglas was the person who appeared in my office to ask me about this. So yes, I believe he was who added me to this chain.
I see.
Okay.
And there are no, you don't chime in at any course of the exchanges going on here in these emails, correct?
No,
And then you sent them to me on Tuesday, May 11th of 2021. And that's on page
Yes.
1. Okay.
She would have had, it would have been okay for her to get a copy of that contract, wouldn't it?
it's my recollection that she demanded that and I instructed my staff to give that to her.
I mean, it'd be a public record. My Aunt Dot could get it too, right?
It's a county record, yes.
Based on the time, I don't have anything further for Judge Emerson at this point.
Okay. Mr. T, you've got 30 seconds.
I will move with alacrity and dispatch. Maybe not quite that much dispatch, though.
I don't think those words mean what you think.
I had to look them up.
Do you want your computer?
Judge Emerson, thank you for staying late.
Yeah. Judge Emerson, I'm Lester Tate. We've known each other, I think, for years. As you know, I represent Judge Peterson, and I have some questions for you here today. And I want to start by asking you something about your background. You've been there in Douglas County in the courthouse since 1981, correct?
1976 as an attorney.
1976 has turned 1981. It's true that Judge Peterson is the first African-American probate judge in Douglas County. Is that correct?
I believe so.
And it's true that she's the first lawyer probate judge in Douglas County. Is that correct?
Yes,
And it's true that she's the first Article 6 probate judge in Douglas County, correct?
I'd have to go look at the Constitution to tell you that. I know that she was the first probate judge who would have had the authority to try a juvenile trial, if that's, a jury trial.
And also from whom appeals go directly to the Court of Appeals instead of the Superior Court of that county, correct?
I hope so.
And that in particular is a different duty from normal probate, or like it was in Douglas County or Polk County when you and I were growing up, right?
Well, counsel, in all candor, I've not looked at probate law in a long time. So
I know.
I know they redone the code.
And I'm on it while we're talking, I'm gonna read, I've always, in the King James Version, they put Jesus' words in red. I've made notes in red of things that you've said, and I want to ask you about some of those. You said you didn't do probate work, you didn't know about it. You said that I'm not a probate judge, that you didn't have anything to really offer Judge Peterson when she came into office. You disavowed your knowledge, even to a small degree, of probate or probate courts or how they operate, correct?
That would have been something she should address to Judge Hamrick. That I didn't, realize she was a one
That's not my
judge.
question. That's not my question. My
Okay.
question is, you disavowed any knowledge of probate court, what goes on there. You said just now in response to my question about Article 6 judges that you really didn't know about probate court,
I
right?
would not have been able to help her with routine probate operations.
Okay. But she was elected in 2020 to take office in 2021. Isn't that correct?
I believe so.
And before she ever took office in 2020, you took it upon yourself to write a letter to the county commissioners saying that she did not deserve the budget or the money or the raise that she had talked to the county attorney, talked to the county commission about after you learned of it. Is that correct?
I believe I did.
And it's an entire letter, multi-page letter. I can pull it out, but you wrote a multi-page letter talking about the probate court and why they didn't deserve money, right?
Well, she ran for a job that paid 93,000, and she asked for that job.
Do you understand that an Article 6 probate judge is different from other judges?
I understand that she is an attorney.
Well, I think my question is this: if you are so unknowledgeable about probate stuff, and if you are so in the dark about the probate court and what they do, why did you feel compelled to write a letter to the county commission trying to undermine what she was trying to get through?
Because she asked for a job at a certain level, number one. And number two, the probate court of Douglas County is a very light duty court. And it's not one that requires a whole lot of work.
And you know it's a light duty court, even though you don't know anything about it.
Well, I knew that, so.
And you didn't like the fact that she ran for a job and then asked for a raise, correct?
I felt that it was totally inappropriate, sir.
And so you before having any other interaction with Judge Peterson, except for the fact that she tried a few cases before you, when she was a lawyer in private practice, took it upon yourself to go to the county commission and try to undermine what she was asking for, right? Is that correct?
I told them what I thought about her request for additional money.
And you don't have any real supervisory authority over the probate judge or the salary, correct?
That's correct. I don't view a Superior Court judge as having supervised. There's something in the code about what we're supposed to do, but it's never really something that we can't tell any judges what to do.
Okay, and so that was in December of 2020. She gets sworn in the last day of December 2020, first day of 2021. You've answered Mr. Hyde's questions. You didn't go to lunch with her. You didn't go down, hang out with her. You didn't do anything else to interact with her in the first few months she was there. Is that correct?
I don't believe I did.
Okay, so now I want to put something up here and ask you if you recognize it. Do you recognize what that is?
Yes.
And I'll try to. So that's a complaint to the Judicial Qualifications Commission, isn't it?
That's my handwriting.
Yes, and that's your name.
Yes, sir.
And then there's Judge Peterson's name, correct?
Yes.
And that's in your handwriting, correct?
Yes.
And is this that I'm holding right here? I'm gonna let you look through it. But I want you to tell this panel whether or not this was the complaint that you filed against Judge Peterson within 3 months of her taking office.
What's the?
March 31st,
Of
2021.
Yes, sir. This was the file of the criminal investigation that was brought to me by Douglas County Sheriff.
I didn't ask you if it was a file of the criminal investigation. I asked you if it was the complaint that you filed with the JQC.
Okay, and he was explaining his answer. Let's not trample the witness.
All right, and so what is contained in here is the investigation that was brought to me by the Douglas County Sheriff's Office investigator. And I felt I had a duty to provide this to the JQC.
Well, I want you to look on the second page of that complaint form, if you would. Do you see the second page of that complaint form?
Says attached.
Yeah, do you see the next place where it asks you what your involvement is? Ask you if it's a civil or criminal case, ask you what your involvement is.
Said my relationship to the case was none.
None. You had no relationship to the case, correct?
It was news to me.
It was no case that had appeared in front of you. Correct?
It did not result in a case, counsel.
Okay, and you had no involvement in it whatsoever, except for some sheriff's deputy comes and talks to you about it, right?
Sheriff's investigator, not a deputy.
Okay, they're not deputies as well? I thought they were.
Let's keep going. The investigator's the title.
So you, just because investigator came to see you, you sent it to the JQC, but you didn't send it to the Attorney General, the GBI, any of those other places that Mr. Hyde talked about, right?
Did not.
And there was only one of there was only one of those agencies I rattled off that had any power to remove her from the probate court, and that was the JQC, right?
I would believe so, yes.
And that's the only one you sent it to.
Yes.
So is it fair to say that from the time Judge Peterson was elected through the first 3 months of her term of office, the only interaction you had with her or about her was to write a letter to the county commission saying she didn't deserve a raise and to file a complaint against her with the Judicial Qualifications Commission?
I wouldn't say that's the only dealing I had with her. I don't remember others, but I can't.
Well, you haven't testified to any others here today that I can recall, but if you can remember others, I'm happy to hear about those.
I really don't remember any others.
Okay, so it's fair to say that the only interaction you remember with Judge Peterson between the time she got elected in the first 3 months is that you wrote a letter saying she didn't deserve a raise and that you filed a complaint against her with the Judicial Qualifications Commission.
Those are the ones I can recall right now.
Okay, so can you, and I'm asking you this because again, one of the complaints that I wrote down here that you had was that she threatened to sue Douglas County. And you thought that was unbecoming that the judge had threatened to sue Douglas County?
Yes.
Okay, but it wasn't unbecoming of you.
Take a deep breath before you ask your next
I'll
question.
do it.
Sometimes the witness says yes, and then there are more words to follow. Did you have more you wanted to add?
Yes, I thought it was really incredible that she would threaten to sue the county IT department at that point.
Do you understand that? I mean, you've been a judge for 31 years. Do you understand that courts are places that people go to have their disputes resolved?
Sir, I would appreciate if you wouldn't ask insulting questions. Obviously, we all know that.
In your
So-
31 years, how many times did you threaten to sue the county?
Never.
So my question to you is, did you do anything to try to help Judge Peterson in any way, not just giving her advice on probate court, but in any way?
Yes, basically, I always work to help as I mentioned, I thought she needed help on her computer system. And I offered, and I actually had a class in my courtroom for all of the judges in the circuit on how to take advantage of the computer system we had. Also, one time she reached out to me, she emailed me you couldn't do her case count, which was due to the workload, to the ALC Workload Assessment Committee. I guided her through the process to compile her case count for that year.
Did she request a meeting with you in the first few months of her tenure as probate judge?
I don't remember it, but I think she might have.
I'll just tell you, she's testified, she requested and actually had a meeting set up with you and that you canceled it and never rescheduled.
Stop for a second.
Object to the point of the question regarding what Jeff Peterson testified.
Right, don't ask a question like that again.
I'll rephrase it. Did she have a meeting set up with you that you canceled and never rescheduled a private meeting with her?
That could have happened. I don't really remember one way or the other about that.
Okay. And so we talked about from the time she got elected through March, and then we get to April, correct? And in April, the issue with the courthouse security after hours wedding comes up, right?
Yes, sir.
Okay, would you put up 002? Aiken and Tate, AT 002, please? I'll probably have to switch this. I'm not going to take time to show you video, but I want to run through, if you just slowly scroll through these pictures, do you recognize this as being the courthouse?
Yes.
And you said you saw, somebody showed you, or you saw on TV or something, you saw some video. Are these stills, do they appear to be stills of the video you saw?
The only video I saw was of people, was of your client going to the front door of the courthouse and letting people in. I'd never seen these.
Okay. But you said it was multiple people, right? Like you said, there were a dozen or so, I think. Is that your understanding?
I understand it was at least 7 and maybe 14, but
So you understand that it was at least seven, but not more than 14 that Judge Peterson let into the courthouse in April of 2021. Is that your understanding?
that's my understanding, but only from scuttlebutt around, just, I don't remember who told me that.
Well, were you aware that this wedding party that I've just shown you in the courthouse was a group of people who were let in by Deputy Clayton to perform a wedding that at the same time?
Counsel, I've already told you, I've never seen this picture.
Why don't we take it down since he
That's fine.
says he
I'm
hasn't
fine
seen
with
it.
that. I'm fine with that. Were you aware that Deputy Clayton was at the courthouse that day?
No,
Were you aware that Deputy Clayton let 10 to 12 people in that day?
not during the time of the events in question.
Okay. Were you aware that Sheriff's Deputy Vargas had weddings after hours in the courthouse and had people to pass, to not go through screening coming in?
Not at the time.
Okay. Were you aware that Deputy Clayton had as many as 100, some portion of which were behind the security screening line in the courthouse that had after hours weddings there over the course of the years?
No,
You talked about Lindy West being a straight shooter. Were you aware that there was an internal affairs investigation?
Objection, Judge. We're going to go into an internal affairs investigation. I guess I'm concerned about where this question is going.
Well, I don't know how to address that. If there's a specific objection, I'm happy to, but I want to know what he was aware of at the time he suspended my client's access to the courthouse.
So was your question going to be about an investigation into Major West or an investigation into Clayton?
And to Clayton and Vargas.
Oh, okay. I would overrule that, but I don't think that was what the concern was.
Yeah.
It sounded like from your trajectory that we were.
No,
gonna
no,
get
no, no,
into
no.
Some unrelated situation.
No. Sometimes my brain moves too fast, I guess, but he had testified he had relied on things that the sheriff's office had told him. And I just wanted to see if he was aware of some of this thing, some of
You
this.
may
stuff.
explore with this witness the IA into Clayton and Barnes.
And I mean, as are you the co-chair of courthouse security with the sheriff? What's your role with the sheriff? I want to call it the right thing and I don't know what to call it.
I don't think it's co-chair, but the sheriff and the chief judge of the Superior Court have the responsibility to adopt and implement the courthouse security plan.
But in that role, you were not aware that all these after hours weddings were taking place without security screening where the deputies were doing the weddings. Is that correct?
And I would have disapproved of that if I'd been aware of it. I was never aware of it.
Fair enough. Are you aware that the very first time anybody ever complained about that was the first time that Christina Peterson did it?
I didn't have it, as I said, I was not aware of any of that going on.
Okay. And one of the people that could have told you that would have been Judge Christina Peterson. Is that correct?
I have no idea what she could have told me.
Well, you didn't ask Judge Peterson, did you?
No, I didn't ask her.
And you said you didn't ask Judge Peterson because she had appeared before you as a lawyer and she appeared very arrogant. I wrote that down too. That's
Sure.
what you said.
Sure.
But you do recognize as a constitutional officer, she has a right to go in and out of the courthouse.
Well, and we ensured that she would have that right during normal hours.
Well,
And we restored her as soon as we could make changes.
let's not quibble. You cut off her access for part of the time. You cut off the access that she previously had. True?
After hours access.
You did that.
Well,
There's
the
no
sheriff,
question
the
about
sheriff's
that.
office and I implemented that.
And you
Yes, sir.
did that without ever talking.
Space between question and answer. It's late and our court reporter is graciously staying late. There needs to be space between question and answer. So next question.
You did that without ever even asking her about an event that she was a personal participant in, didn't you?
I did not ask her.
Okay. Now, do you realize, do you know what she's charged with here?
I've seen the formal charges.
You've read it.
Sure, they're public.
Are you aware of the Code of Judicial Conduct as pertains to performing administrative responsibilities?
Yes,
And are you familiar with Rule 2.5B?
yes,
And it says judges shall maintain professional competence in judicial administration and shall cooperate with other judges and court officials in the administration of court business.
okay.
Would you agree that that would apply to you in your capacity as chief judge and your role specifically in courthouse security?
As a general proposal, yes.
Okay. But you didn't cooperate. You didn't ask, you didn't consult. You made a decision to bar her from after hours access without ever consulting her, right?
You've made that point. There was no consultation, none.
Yes. Do you believe that was a violation of your duty under these canons?
No,
Why not?
because I had the duty to protect the people in that courthouse.
Could we have back up? Well, I'm not sure how to pull it back up. You remember which, if that is. You put 9 up. They're 9, obviously. Yeah, scroll on down. Scroll on down. Sit right here. All right. Can you see that?
Yes,
And so earlier, when you were shown that, I understood and wrote down that you said that what she was asking for, technically, we could not give them. And you specifically looked at this and were able to identify that she said she was going to move forward with legal action to try to resolve the dispute. And I didn't highlight that last sentence. I want to make that clear. It was highlighted by someone else. It was highlighted on what went in. But would you read that sentence?
which one?
The one that's highlighted?
In the yellow?
Yes.
Because there's two. There's one in bold above it.
No, I want you to, the one that's highlighted, I think of yellow as being the highlighted one.
Judge Peterson says, again, I am making the directive, provide CJT what they need for my conversion.
So isn't a fair reading of that instead of demanding data or whatever was prohibited, she said, I just want my folks in the system that I'm trying to put in to give me what I need to put that system.
That was not the demand that she was making.
Well, you see what's in writing there, correct?
That was not the demand that she was placing on the county staff.
Well, who is that email addressed to?
Whoever Kurt at CJTS Software,
Well, who is Ruel Douglas?
he's the county IT guy that came and talked to me.
And is he part of the county staff?
Yes,
And who is Alex Betancourt?
he's the head of the county IT,
Is he part of the county staff?
of course.
And who is Sharon Subadon?
She was a brand new county administrator that had just come on board
And Ken Bernard's a lawyer who serves as the county attorney. Is
at the
that
time.
correct?
Yes,
So is it your testimony that notwithstanding that this email went to multiple members of the county staff and merely said, provide CJT with what they need for the conversion, that she didn't make that demand that's in that email on county staff?
But isn't that, I mean, we haven't with Judge Emerson, but we have with other witnesses gone through some of these emails. And what Mr. Douglas was saying is what CJT is asking for is inconsistent with the terms of our contract. And so for Judge Peterson to say, give CJT what they need, if rightly or wrongly, IT is saying, well, but actually it's more than just data, it's database structure or something that's intellectual property, then by saying, give CJT what they need, Judge Peterson, maybe not intentionally.
With all due respect, Judge, I just asked him to read that and he read it and he said that is in the email is not what they were asking for at some other time. So I hear what you're saying, but my question, I think, is based directly on that email. He said, you were asking for all this stuff we couldn't give you. And I said, what about this? And he said, well, what's in the email wasn't what they were asking for. I think that's fair game.
I'm not saying your question was unfair, but the phrase provide CJT what they need is a phrase that is more completely defined throughout the email chain, which we've asked Judge Emerson to read. And what CJT was saying they needed, according to county IT, crossed the line into contractually protected. And Judge Emerson has made clear he followed that as well. And so we're not a jury, so we're not snookered by, hey, here, all she said was provide them what they need. If what they need in the eyes of people wrongly or rightly is contractually prohibited, then we're at the stalemate. And the way the judge decided to press through with that is say, I'm gonna sue you if you don't give them what they need. And IT's response was, but we can't under the contract. Doesn't make anyone incorrect in this process, but because we all have seen these other emails, you're asking this witness to, I think, falsely cabin himself to that one highlighted sentence.
I understand.
Okay, as long as you understand, because I think here we spin our wheels a little bit because of that additional context we already have.
Is it also true that you did not tell Judge Peterson that you were suspending her access to the courtroom, the courthouse after hours before you did it?
I did not tell her.
Why not?
I did not feel a need to.
Did you ever talk to the sheriff about his conversation with Judge Peterson? Not asking what he told you.
What I recall talking to the sheriff about was how do we prevent this from happening again? And what changes did we need to make to the courthouse security plan to ensure that it did not happen again?
What is this in it? The entry?
The entry, yes, the improper entry.
May I have just a second?
Yes, sir. Ms. Veal?
Judge Emerson, during your 30+ years on the bench, had you ever before been brought an investigative file with indicated that another judge had committed a crime?
No.
Right? And since we want to talk about the Code of Judicial Conduct, and I'll just get through this quickly, Rule 2.5 or 2.15 deals with responding to judicial and lawyer misconduct. Are you familiar with that rule, Judge?
It's okay if you're not.
I don't memorize them by number.
Sure. Well, it is.
So if I think I know where this is going, but if it's to ask him if that was a motivation, that's a leading question unless he knows what.
Right. If he's not familiar with the rule, then that can't have been what motivated him, specifically the rule, as opposed to the principles behind it.
Well, he testified earlier that he felt he had an ethical obligation to provide that information. And so that's what I'm trying to explore. So what did you?
But the appropriate way to explore that would be, what authority do you have for that?
Judge, if I could ask my questions, please.
Okay, I'm gonna take it off the screen though, and you ask your I just switched the screen off. So you ask a question and then we'll see if there's an objection.
What did you mean when you said that you had an ethical obligation or you believed you had one to report that?
As I said earlier, it's my understanding that when I am aware of judicial misconduct, I have a duty to report it.
And it says something about the appropriate authorities, right?
Just recall, I have a duty to report it, and in my view, it was appropriate for me to take that to the Judicial Qualifications
Even
Commission.
though the JQC doesn't investigate criminal conduct.
If it, as a general rule, yes.
And you're one of the statutory requesters of the services of the GBI, right?
I do have that authority, yes, sir.
Had you ever before dealt with a situation where a judge had violated any kind of security protocol at the courthouse in your 31 years?
I don't know what ever before has relevance to what he did here.
Okay, understand, overruled.
No, never dealt with this before.
In your 31 plus years, had it ever been reported to you that another judge in your county was threatening to sue the county?
No,
Mr. Tate.
I'm gonna stand here because I think
Yep.
the conduct that you reported to the JQC, and I guess I should move that into evidence. I'll mark it as defense one and move it into evidence.
Okay, Ms. Veal, any objection to defense one, which would be the complaint that Judge Emerson sent to the JQC?
Can I see it, Judge?
Sure.
and here are the other exhibits. Well,
That's it. Yes, one they produced.
Right, and I did not review this complaint in advance of this proceeding since I withdrew these.
So why don't we do this? I will conditionally admit it, and it would be at a minimum, one of those things that goes into the record that's transmitted. I think it would be wise to flip through it to make sure there's nothing in there that doesn't need to be redacted. But I will provisionally admit defense one. That'll give Ms. Veal and her team time to review it, to say, hey, page 92 needs to come out.
Just want to make sure I put this in the right place so I don't run off with it. Should I give it to the court reporter? Mark?
Well, I wouldn't hand anything to the court reporter. Just put it on that shelf where the exhibits are going.
Somebody put a sticker on it. I'll ask my last.
Please do.
Last question, series of questions. The conduct that you complained of in 2020 obviously occurred prior to the time that Judge Peterson was a judge, correct?
I believe it did.
It actually happened more than 2 years before that when she was in private practice, correct? It was the case that you complained about, the alleged conduct, I should say.
I agree.
And even though it happened then, you didn't report it to the bar.
No. As I said, I viewed the JQC as the appropriate entity.
Well, and again, the JQC.
But you asked me for my motive, sir. I gave it to you.
Was your motive to have Judge Peterson removed?
My motive was to allow this information to the JQC and comply with my ethical duty.
That's all I have, Judge.
Okay. One question. Or two.
Since the Douglas County probate court was an Article 6 probate court when Judge Peterson became the judge there, had she been disbarred, would she have been able to continue to serve as the judge of your probate court?
I do not think so. We had passed 96,000 in population. And that required that it was a population cutoff. Once you hit 96,000 in the county, I believe that's the number, the probate judge had to have a license to practice law in Georgia.
All right. Judge Emerson, thank you for your time.
Thank y'all.
Appreciate it. You're free to go. Ms. Veal, anything more you want to get on the record? We'll talk scheduling in a minute. I just want to let the court reporter stop having to type. But if there's something you need to get on the record, we should do that.
No.
Mr. Tate?
No.
Okay, let's get off the record. Thank you, Ms. Wong. So we're done for the day. Thank you, Deputy, for staying late. Appreciate it. Hope you get time and a half or something. We will be back here on the 14th. That's next Thursday. Mr. Tate, I'm not reaching out to any judges on your behalf unless you send another email saying,
I'm clear.
I've heard you clear. I would ask you all, not tonight, but sometime soon, just to coordinate to make sure you know if there are witness constraints, that we take folks in the order that best enables us to get through both sides. I will direct you all to confer, to give us your good faith estimate as to whether we'll finish by Friday, because if we won't, then we need to look for another day that we can get the three of us together and clear your respective schedules. And we don't want that day to be December. So we just need to figure that out.
Can I ask just one sort of question here, which is, and I'm jumping ahead a little, what you want us to confer about, but we're here today and we know what's gone through. I know I need to go back through stuff with Judge Peterson at some point. But I'm trying to decide, do I need to have witnesses here? And do we know that now? We may not, it may be, they have to go back and look, but do they think they have another full day and I'm looking at Friday?
That's why I'm directing you all to confer, because that will also inform you. If you learn from Ms. Veal, we won't finish till Friday morning, you may be able to say with great certainty, we're not finishing close of business Friday. So you all can talk, wait, take a day off, but do confer and then let me know what the 14th and the 15th look like.
I just want to be ready to go when.
Good. We want you to be ready to go. If we block out some days the week after Thanksgiving for your other matter, how does that look for you?
For my other matter,
Judge Reeves?
yes, I have to look.
Okay, that's what we're wanting you to do.
We have to spend a week in trial with Mr. Tate once a year.
Well, that's why you have a buffer. You got to deploy your buffer.
You got a deputy director and 20 other staff members.
That was 25.
25.
Compared to the time when the JQC didn't try any cases.
Yeah, I've heard about that.
Yes, that's why you took the
That
job.
must have been so nice.
Yeah. But then you're out. After Reeves, you'll have nothing to do.
When the investigative panel was also the hearing panel, it seems like there was a lot less to be heard.
It's funny how that worked.
Yeah, so we're talking about the first full week of,
I think it starts with the 27th.
well, he said the week after
Well, I
Thanksgiving.
meant 27th, I'm sorry.
Well, no, whatever. We're trying to describe the same thing. That Monday after Thanksgiving.
I was quoting Judge McBurney.
I thought that was the 27th.
20, okay. 27th, 28th, 29th.
Yeah, so I stand by my
That,
command of the calendar.
And down that way, not here.
so, it looks like on Thursday of that week, I am, supposed to be in Dallas.
Okay, but we could at least have the first 3 days tentatively.
We could probably have a couple, 3 days. Yeah.
Okay.
That's right.
All right.
And it, but it would, I would point out, it would ruin Ms. Veal's Thanksgiving, not mine, since she gets to go first, but.
We'll figure it out. We just want to know if we could try to lock that in because our venue will likely be mid-Georgia and not up here, given where all the witnesses are.
Okay.
Okay. So you will be in touch with me about your forecast for Thursday and Friday of next week. And we'll see everyone a little before 9 o'clock on the 14th. Thanks to our hosts here in Cobb County.
Thank you.
All right.
Appreciate it.
Judge, one more thing, and this didn't need to be on the record,
So we've been off the record for a while.
right? I just
She
want everyone
backed up.
to know, this evidence, just because of the nature of our headers, I am going to pack it up and with me, if that was okay, I can't do.
And Mr. Tate, if you wouldn't mind grabbing this, this is exhibit 56. It's part of the record. And if you would include defense or respondents 1 in that universe as well.
Sure.
It would really have been would be helpful.
So long as.
The video that was shown, if that was transcribed, because if it's not,
Mustache video.
it's gonna slow us down a whole lot because I'm gonna have to transcribe it word for word. And this ain't a paying job.
But you get paid so well on the other one.
I'm not-
Yeah, you should keep your binder. No, it's just how we control the. No, sir. We're coming back on the